We'll salute the flag. We'll do the honors.
I pledge it.
To the
And to the republic
for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Amen.
As chair, actually vice chair of the House Criminal Justice and Public Safety Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing with the potential for executive sessions to be held throughout. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting notice complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting assisting us. Brad Greenland, committee researcher. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Clerk will call the roll.
Vice Chairman Welch.
Here.
Representative Mooney.
Here.
Representative Hopper.
Here.
Representative Green.
Here.
Representative Wallace. Representative Testerman.
Here.
Representative True.
Present.
Representative Pratt.
Present.
Representative Marston.
Present.
The clerk is present. Representative Harriet Gathright.
Present.
Representative Pantelakis.
Present.
Representative O'Hearn.
Present, alone.
Representative Bordenay.
Present and alone.
Representative Muse.
Here and alone in my office.
Representative Newman.
Present and alone.
Representative Bolden.
Present at home with my family.
Representative Conley. Representative Klein Knight.
Present and home with my family.
Representative Bradley.
Present and with my daughter.
Chairman Abbas. Mr. Vice Chairman, we have Chairman Abbas and Representative Wallace, I believe, are both in chairing the meeting, so they will be here in just a little bit.
That's right. First bill today, House Bill 147 FN. We open the public hearing on House Bill 147 FN. Please remember that the testimony will be limited to 2 minutes. Except for the sponsor who is introducing the bill. And Representative Abbas is not here. Is Representative Love available?
He is online.
Representative Love?
Representative Hughes, do you see Representative Love?
Yes, I've brought him up to panelist status and have asked him to unmute.
Thank you. Thank you.
Representative Love?
Hello. Hello, this is Representative Love. Can you hear me?
Again.
Okay, here we go. I come before you to introduce House Bill 147 as amended. House Bill 147 would add first and second degree assault charges for an assault on an elderly person into statute, and thus enhance penalties compared to simple assault. Many of our elderly suffer lifelong disabilities and pain from assaults throughout the country, and several states have currently similar laws on their books. Massachusetts, Connecticut, Florida, Texas, Illinois, California, to name a few. Some have mandatory 1-year state prison sentences, some up to 3, and Texas takes the cake with 5, a 5-year prison sentence for assault on an elderly person. New Hampshire has a fair but firm reputation in its criminal sentencing, thus a serious deterrent to crime. And this bill would define the crime of assault on an elderly person in punishment for the heinous crime that it is. I thank you for taking my testimony, and I take any questions.
Any questions for Representative Love? Representative Sue?
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Right now, as the law is written, what is the penalty for causing serious bodily injury to another?
Right now, our laws are mostly defined as simple assault, and people are walking away with fines and 6 months to a year probation. This law put some teeth in. This bill would put some teeth in the law, and put some teeth in the punishment also.
Thank you.
Other questions? No further questions.
Mr. Chairman. Representative.
Representative Marshall?
Thank you, Mr. Chairman. And thank you, Representative Love. I'm now for the first time looking at the amendment, and I'm not sure I understand. You have section E and G. Is it not the same?
I don't have the bill in front of me myself. I just got a copy of it last night on my phone, and my computer's broken, so I'm using my phone. I can't do both at the same time. But I'm not sure I understand your question either.
Further questions?
Yeah.
Could you read it to me? And
Well, I've looked at it some more, and the only thing that I see that's different is they threw in the word causes unprivileged physical. And
yes, that would be a shove, up to an outright punch in the head or whatever. Unprivileged. A hug is not unprivileged, but when somebody is hurt, and elderly, like I said, they suffer the pain and disability a lot longer than a 20 or 30-year-old.
A follow-up, Mr. Chairman?
A follow-up, yeah.
Thank you. So with that being said, and I'm not arguing with you, I'm just saying that the section E just states purposely or knowingly causes bodily injury. Doesn't that cover it? I mean, you need an unprivileged in there?
I'm not sure. I think he'll have to talk to the sponsor about that when he gets back. You know, the prime sponsor is your chair, and you know, I'm sure he could give you the reason for it.
Thank you.
Representative Knight, you have a question?
Yes, thank you, Chair. Thanks for taking my question. I might have to wait for Representative Abbas, but I was hoping you could give me a rough idea how many times this happens in our state. I just want to know. You don't have to give me an exact number, but I want to know how many times an elder suffers abuse roughly and isn't able to do anything about it. Do you have any rough figures?
I don't have any figures, but I did talk to my police chief last year when I introduced this, and he said the crime is often reported, but very often unprosecuted because the elderly people are afraid of retribution, and you know, and right now our statutes don't have much teeth as far as the punishment goes, and so it like I said, it goes unreported or unprosecuted because they refuse to testify.
Thank you.
Are there any other questions from the committee? Papa.
Thank you, Mr. Chair, and thank you, Representative. There's an echo. My question is, isn't this more about physical disparity between the two parties? Like, for instance, if I said that Representative Rhodes' mom wore army boots and she punched me in the nose, she's next year, she would be guilty of this crime because I'm over 65 and she's, you know, well younger than 10 years younger than me. So it seems like if we pass this, people that this shouldn't apply to could also be prosecuted.
Well, there's the 10-year difference in there, and you know, the fact of the matter is verbal jousting should never be met with physical force, especially on the elderly. It shouldn't be met with physical force at all in society, but especially on the elderly.
Thank you.
Any further questions from the committee? I see none.
Excuse me, Mr. Chairman. I see some people online that don't have their microphones muted, and I'm wondering if maybe that's part of the feedback we're getting. If you could just ask everybody that please put their computers on.
If everyone would unmute, with the exception of Catherine Cooper. Catherine Cooper, would you testify?
I have a follow-up, Chair, sorry.
Oh, all right, excuse me. Representative Knight has a follow-up question.
Thank you. Just one last question. Do you know if elder abuse is on the rise in New Hampshire?
Representative Love?
Hello?
Yes.
Can you hear me? Yeah, I keep buffering here, but anyway, I don't know. Like I said, my police chief said that it's a crime that you know, often goes unreported, but more often unprosecuted because they're afraid for any retribution, and thus we don't have any statistics on it. But it is one of the most unreported crimes there is.
Thank you so much.
Catherine Cooper. Catherine Cooper, are you there?
She has just been promoted to panelist.
Yes. Can you hear me now?
Again, yes, you have 2 minutes.
I'm calling in today on behalf of the New Hampshire Association of Criminal Defense Lawyers to oppose this bill. I would like to, unless there's an amendment that is there that I'm unaware of, I would just like to point out that this bill applies only to first-degree assault, not to simple assault. And first-degree assault is punishable by 7.5 to 15 years in the state prison. This is not a crime that is taken lightly. This is not a crime where people are walking away with probation and fines. If you're convicted of first-degree assault, you usually go to prison. Or if there's some other sort of strange circumstance, you're going to be on a long time of supervision. I just wanted to state that to clarify. But also, we oppose this overall because it's really unnecessary. The new section E in this bill is essentially arbitrary and somewhat meaningless. It's really no worse to commit a crime against someone if you're 11 years younger than them than it is if you're 9 years younger than them. And this age qualification creates an arbitrary factor that sort of parses out and creates classifications of victims for really no good reason. If you're assaulted and someone purposely causes serious bodily injury to you, it is terrible, no matter how old you are or how old the person is who did it. I also think this bill is rather ageist and promotes some discriminatory stereotypes based on age. I think there's many older people who work very hard to discourage being treated like they're weaker or less powerful than those who are younger. In the medical field, there's a lot of work being done in that community to get rid of the kind of ageism that this sort of bill promotes. And I think the legal system should follow suit with that. And finally, the biggest reason is that this bill is unnecessary. Victims who are purposely assaulted are already covered by Section A, and the knowingly mental state here is simply bootstrapping an increased exposure that would normally fall under second degree assault. Again, a very serious charge. I did actually do a little bit of research that addresses one of the questions. I'm sorry, I can't remember who asked it, but there was a request for statistics. And the United States Department of Justice Office for Victims of Crimes has an information sheet on this, and they talk about the fact that older adults are actually less likely to experience violent victimization than the general population over the age of 12. So this bill actually segments out and gives extra punishment on behalf of victims who are actually less frequently victimized than the rest of the population. And another interesting and relevant stat I found at the Office for Victims of Crimes is that more than half of violent crime victimizations against people over age 65 involve perpetrators who did not know the victim. So that makes it highly unlikely that more than 50% of the people involved in offenses like this would even know how old the victim was, thus defeating any kind of a attempt at the bill to discourage crime against the elderly. There just wouldn't be any impact in that way. So
your 2 minutes is long up. I'd like to go on.
I'm finished. Thank you very much.
Are there any questions of Ms. Cooper? I don't see any. Thank you very much for your testimony.
Representative Newman had his hand up.
Oh, Representative Newman?
Thank you, Mr. Chair, and thank you for the witness testifying. I think you said a couple of things where this law is unnecessary, that the charge is probably too grave as first-degree assault. And I'm just wondering if you have any, and I think, you said it was unnecessary. Could you just maybe further elaborate on how this bill could be made to be more useful and more appropriate?
Thank you for your question, Representative Newman. I'm saying it's unnecessary because if you look at the first-degree assault statute, The elements of the crime is that if a person purposely causes serious bodily injury to another, that's in paragraph A. That is exactly the same language that's being set out here, purposely causing serious bodily injury. So my point is simply that E is already covered by A, so it's unnecessary. And then the knowingly mental state already appears in the second degree assault statute. So a knowing mental state means that you know you're doing something, but you're not necessarily purposely causing the harm. So it's a lesser mental state. It means that you know, you're doing something bad, but you're not necessarily doing it on purpose to harm the person. And you know, we set out the first degree versus second degree because those mental states mean that you're doing something that's significantly worse. And this conduct is already covered in our current statutes. So that's why it is unnecessary.
Representative Newman.
Thank you, Mr. Chair. When I first read this bill, my opinion was that perhaps this was being offered as a solution for situations where someone has a guardian, they're elderly, they have a guardian or someone who is in constant control with them and is being abused by them. Do you think that this bill could be amended to cover that situation if it's not covered in current law?
Well, I think that situation would already be covered by this current law. If someone is purposely harming someone they have cared for and causing them serious bodily injury, they can be prosecuted under the statute currently. And nothing in this amendment makes it, you know, has any kind of an element where the person is a caretaker. So this applies to the entire population.
Thank you very much.
Thank you.
Are there any further questions of this witness? I don't see any. Thank you very much for your testimony.
Yeah, thank you.
I have no one else on my list.
And I see no additional speakers either, Mr. Chair.
I guess we will end the public hearing on House Bill 147.
Support and opposition?
Yes, on House Bill 147, the number of people signing in support of the bill was 8, and we also had 8 people signing in opposition.
Thank you.
We have some time before the next hearing. The next hearing is at 9:45, so I guess folks in the committee room will take a rest, and the folks at home can have a cup of coffee. We'll reconvene at 9:45.
We're still on, we're still live though, right?
As far as I know, yeah.
The committee room is not muted.
Mr. Chair, I will mute the committee room.
Good.
Thank you.
David, you're not muted.
Thank you.
Mr. Chair, do we have to do something special with the computer?
Still have an echo.
The room needs to be unmuted and everybody else's speakers need to be muted as well. If someone can go over to the computer and unmute the room, that will get rid of the echo.
How's that?
Is that better? Can everyone hear me?
Yes, that worked.
All right. We will begin the public hearing on House Bill 493 FN. And again, when we have the bill introduced, the witnesses coming after will be limited to 2 minutes. Start the hearing on House Bill 493 FN, an act establishing a criminal penalty for an assault committed against a person who is conveying public health or safety guidance or requirements during a declared state of emergency. We have a sponsor.
Good morning, Mr. Chair and committee. That's a go, right? Okay. Can you hear me okay?
Yes.
Good. All right. So the intent behind this bill has changed since I first introduced it. When I first introduced it, I was inspired by a law passed by Illinois that was more about anyone violating mask ordinances at the state or local level. I have since decided, and this is how the bill is written, that really what I think is most needed, given really there aren't many mask mandates in New Hampshire, and that is not a battle I want to fight, whether or not we should have mask mandates, etc. It is simply a bill to target these sort of viral video type incidences you may have seen that take place where someone works, and the person who is on the receiving end of, say, someone's belligerence is simply enforcing their workplace policy for anyone entering that workplace that may or may not have a mask on, or may not be doing the 6 feet distancing thing, and if that person is belligerent about their enforcement. So I took what was the big battle and reduced it to simply, and hey, the employee could be someone who would prefer not to wear a mask, have views differing than mine on COVID, but to protect that frontline person in their place of employment from any backlash to just their doing their job. This could be a place of business, this could be the DMV, but any place where there is a workplace policy that an employee must do their job to enforce, and someone coming into that place of employment as a customer or as a member of the public and not working for that place would simply be protected by that through this law. That, some folks might have forgotten a mask, that's fine, they're not in trouble. Some folks may not have been aware of the policy at this workplace, that's fine. This is simply to protect an employee at a place of employment from belligerence, flagrantly flouting that workplace policy for any members of the public entering that space, and not abiding by what that workplace policy is. It could be the 6 feet distance. It could be, the mask and the 6 feet, whatever that workspace policy is, simply a protection for that employee who is just doing their job And if someone entering that workplace from a member of the public is not happy with that and does something that puts that person's health at risk, and by violating that workplace policy has maybe put that employee in a conflict they really didn't want to be in, to be honest with you. So I took what could have been one of those political battles that have become partisan. That's actually not what I want this bill to be now at all. It is simply a clarification and clearly outlining what an employee at their workplace might be in a position to enforce with the members of the public. That's all this is. And that's after lots of conversations with folks in the retail sector and business owners, conversation with law enforcement about what's already on the law. You know, a certain level of this was, could be interpreted to be under the existing assault laws, but this was specifically worded the way it is because of the because of any broad public health concerns from a pandemic, and only to protect someone simply doing what they are supposed to do in their job description. And if someone coming into that space doesn't like it, but then does the extra step of becoming belligerent or difficult and blaming that person who's just doing their job. That's really all this bill is. And I think it's a good bill. And I think it helps clarify for retailers in particular, but also nonprofits, even in places, where the government, like the DMV or local governments may have these policies, municipal governments may have these policies, and simply to give a little bit of teeth to the law in favor of that employee, regardless of their views on masks or social distancing or even COVID. They're simply doing their job. That's the intent of this bill. I think it helps clarify a part of the law around any public health crisis that simply helps protect that employee from whatever opinion or view belligerently reacting to someone just on the front lines doing their job. And that's the bill. Couldn't make it more complicated if I tried.
Thank you. We have a couple of questions from everybody. Representative Hopper.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. So somebody under this, if this passes, somebody is guilty of this crime if they don't follow the recommendations of an employee at a place of business. If it's a healthcare recommendation during a state of emergency. So I fall off my motorcycle this spring. I'm in the ER, and one of the workers there suggests that I get a vaccine. Under this, if this passes, if I do not comply and get a vaccine, would I also be guilty of violating this ordinance or this bill?
I hope not, because that wouldn't actually be something that would infect that employee. If that, I believe the way it's worded, and I did talk with the bill drafters about this to make sure that this wouldn't be something that would cause a difficulty at a healthcare setting. Let me double check the wording. I would be definitely open to an amendment if you don't think the way that it's worded covers that. But to be honest with you, that is absolutely not the intent or purpose of this bill at all. If, anything to put any sort of criminal penalties to vaccination or not is not my intent. This would simply be for frontline employees to be protected when they enforce just the policies for entering the work or entering their workspace. I guess you could make the case that if that workspace required people entering to have vaccination, maybe, but that is definitely not the intent of this at all. I don't think anything regarding CDC requirements that are currently being addressed by employer policies have anything to do with vaccinations, so far as I know. I've only heard the basics of this: keep a 6 foot of distance, limit the number of people in an area, and wear a mask. I would hope that this is not used to enforce some policy about vaccination. That is definitely not the battle I want to have here, but I'm pretty sure it's worded in a way that it wouldn't include that. But I am open to amending this if you want to be extra clear. But I'm going to look at the text again. I'm pretty sure that this just looks at an employer policy. I would hope Shaw's doesn't have a policy, no, this would just be about directions for, it's here, I'm reading the bill in section 1A. Relaying directions for healthcare safety from his or her supervisor or employer. So this is specifically about addressing what the public does. And I believe it is worded in a way to not include healthcare providers' advice. This is simply employment duties at a workplace where people are entering their workplace, not for healthcare, but to, renew their driver's license or buy groceries. I'm pretty sure it's worded in a way not to affect suggestions from a healthcare provider.
Representative Testament?
Thank you, Mr. Chairman. Thank you for taking my question. Let me give you a scenario and see if you're guilty. They walk into a local supermarket and just keep walking. They don't make any comment. They have no mask on. And some employee comes up to them and you need to put a mask on, and gets very belligerent about it. But the person who's walking in just keeps on walking, does not say anything to them or do anything. Would they be guilty in this case?
I love good hypotheticals, and that's a great question, Representative Testerman. Good to see you this morning. I don't think so. If the employee has conveyed the required policy that that person's required to convey, and they're not continuing to follow that employee, customer, I don't believe, if that person isn't being compliant in and of themselves by continuing to walk, that wouldn't be necessarily what this bill covers. This is simply if someone is flouting that, basically taking an extra step of aggression towards the employee. If a person's just continuing to walk away, I don't know. I don't think that's at all the intent of this bill.
Follow-up question.
One last question, but 1A at the end says refuses to comply with another who the actor knows to be. And I'm assuming that this person walking in would know that that's an employee, so they would know they would be, and they are refusing to comply by just not doing it. So doesn't this then make them guilty of the assault?
I don't think so. I don't think anyone objectively would consider walking in a certain direction after hearing the policy from the employee at their place of business. I don't think that anyone would consider that an assault in and of itself. I think there are things that the governor has suggested with retailers that maybe do or don't have teeth to them about making a call to local law enforcement for that. I think these things are that kind of thing is between the governor and law enforcement and retailers. This wouldn't, this would not add any new penalty to the law for someone who's not wearing a mask and simply walking into a place of business away from that employee. No, I would not consider walking away a belligerence. I think objectively that would be an agreed upon thing. A belligerence would be getting in someone's face, closer than 6 feet without a mask, or starting a verbal argument that escalates to someone ripping a mask off or, that sort of a thing. But walking away, I think universally is seen as not a sign of aggression.
John Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. So Representative Testerman, his follow-up was along the lines of what my question was going to be, but there seems to be, for lack of a better word, wish-wash. Yeah, I mean, it clearly says on here, second-degree assault, and it clearly says, or refuses to comply. It doesn't say, it doesn't say, well, it shouldn't matter, or that's not what I mean. It clearly is written, or refuses to comply. So, one, how would this even go about being enforced? I guess that would be my first question, then I'll wait for a follow-up.
Okay, I hear you on the first part. On the second part, it would be enforced the same way any assault would be enforced. The person who has been assaulted usually has to contact law enforcement, or the employer in this case also probably would be the person calling law enforcement. And then the process involving law enforcement would continue per usual as an assault would be anyways. Good question. I suppose an employer could, call law enforcement for help enforcing this policy anyway, honestly, given how the governor has spoken about his own executive orders. But that is absolutely not the debate I'm trying to just tiptoe into here. I'm simply talking about a direct belligerent act to an employee in a workspace enforcing a policy. If an employer wants to call the cops because someone is walking through their place of employment without a mask, they can already do that. This law wouldn't change that fact. The teeth behind the misdemeanor in this case is specifically about a belligerent, aggressive act towards the employee enforcing this. I think what you're suggesting and what Representative Testerman was suggesting is something that, an employer could already call the police about, given at least how I've heard the governor speak about these things. And that's definitely not a battle I care to enter with this bill. So if you think that this gives teeth to that, I would be very open to an amendment to clarify the wording around this regarding the way that the penalty and the act of aggression is worded. But I will say, if it helps reassure anyone, I did vet this wording with law enforcement and with a former prosecutor to try to make sure that this bill just gets to, a poor employee who's just doing what their employer asks around public health crises, and that interaction between someone with the public that is aggressive and flouting a public health recommendation. That's it. But I feel like I'm talking too much. I feel like what you're suggesting is something that can already happen and someone could already call law enforcement is really the bottom line on that. And this bill absolutely shouldn't be worded in a way to add any new teeth to that, based on my consultation with a former prosecutor and some members of the law enforcement.
Follow-up question?
Thank you. So to follow up with that, to be clear, I don't believe that Representative Testerman or myself are suggesting anything. We are simply reading exactly what it says here. So, and you had talked about hypotheticals. So this isn't actually a hypothetical. This is an actual. I have a handicap sticker and a handicap placard for my vehicles, and that surprises a lot of people. But the reason I have that isn't necessarily anybody's business.
Right.
There are more times than I should even have to count. If I take it upon myself to use that opportunity to park in one of those spaces, people come up to me and they question me and they challenge whether or not I should be parked there, and they look to see if I should be parked there. So I'm put in a position to have to explain myself, making it even more uncomfortable than I already am about the situation. So with that being said, you know, there are plenty of situations where people are not able to wear masks. There are some that choose not to, and there are some that clearly are not able to. So now you're gonna put a person that has to now explain again why they're not able to wear this mask according to your piece of legislation. They would be belligerent, and now they would, I mean, how is that gonna be a person's mental health on top of everything else?
First of all, I just want to say, I'm sorry you have to go through that with your handicap thing. I have encountered that with members of my family, and you shouldn't have to go through that. Second of all, so that's just as a human being, I wanted to say that. Second of all, you know, I guess it depends on the interaction. Like any assault situation, there is an element of assault that might feel subjective to someone. But what you're describing in no way, shape, or form would sound belligerent to me. If someone is saying my healthcare provider says I can't wear a mask, and they continue to move through the place of business, I can't see that being interpreted as an assault. You know, and I'm not a member of law enforcement, but like I said, I did vet this language going through multiple potential scenarios. And I would hope that is not how this bill is used. I can't imagine it would be. But if you think we need to further clarify the language, I'm open to that.
Representative Muse.
Thank you for taking my question. Listening to some of the other questions this morning for you, one of the things that strikes me is that that a lot of the situations that we're talking about are covered under our current assault and trespassing laws. I notice in our trespassing statute that is an unclassified misdemeanor, so it's not classified as A or B. I notice that you're asking for the particular offense that's outlined in your bill to be a Class B misdemeanor. My question for you is, are we better off if we were to go down the road of having a statute like this, of acknowledging the other statutes and simply requiring that during or simply saying that during a public health emergency, these types of offenses, so trespassing offenses and assault on a person in this situation under a public health emergency, should be elevated to a Class A misdemeanor? Would that address your concern better?
I don't know that. I definitely spoke with the levels of misdemeanors with law enforcement members and with a former prosecutor, and knowing how stringent a Class A misdemeanor is in New Hampshire, I specifically did not want it to be elevated to that. I am, though, drafting an amendment for consideration to drop it to potentially as a violation. If you think a criminal penalty for any of these aspects that aren't already addressed by assault, I'm open to dropping it to a violation. Yeah, I'll just leave it at that. I think that over answers your question, but did I answer?
I think you sort of did. Thank you.
Sorry.
Representative Marston.
Thank you, Mr. Chairman, and thank you, Representative, for taking our questions. I simply I've opened my book, RSA book, to 631-2, and it's in here twice. It was amended and so on in 2015. And aren't we all under that? And your bill would simply make a carve out for people that are in the health profession of some kind. And I think that making carve-outs is a very dangerous precedent to be going down. And I think this bill may be redundant. Any thoughts?
I don't think it's redundant, or I wouldn't have, if I thought it was redundant, of course, I wouldn't have written the bill. I have read the statutes of definition around the various misdemeanors and felt that the way that assault is listed wasn't specific enough for an employee enforcing a policy around masks necessarily. I feel like, with all due kindness to law enforcement, there's a bit of subjectivity to how this has been applied during COVID. And there have been instances, luckily not so many that have made viral videos, but there are enough instances where even owners of these establishments have been confused. And to make it clear for the protections of the employees, I wouldn't consider that a carve out. This is an addition to, at least the way the bill is worded, it would be an additional new misdemeanor that is in application during a pandemic that just protects that employee from enforcing their workplace policy. That's it. There is in no way, shape, or form meant to be any sort of carve out. Really, this is simply adding and clarifying what would be considered assault to an employee enforcing their workplace policy. You guys are smart and asking tough questions. Bring it. I'm happy with this.
Representative Marson, you recognized for a follow-up question?
Thank you, Mr. Chairman. In the RSA laws that are on the books, 631-2, it talks about Class B felony. Your bill says Class B felony, not a misdemeanor.
No, it does not.
Class B.
Question for the chair.
Sorry, it's a Class B
Representative
misdemeanor.
Marson, let's suspend for, listen, one is, there needs to be a question. Number two, we're not supposed to debate the witness. We ask questions to obtain information. We always have healthy debates during the executive session amongst ourselves, but it's just that I always remind the members of the committee of that. That's the policy.
Before you interrupted me, I was trying to ask.
I was not interrupting you, Representative Marson. And I do have, as the chairman of the committee, I do have the discretion to ask a member to suspend. That's not interrupting. It's within the rules of procedure. The parliamentary rules allow that to happen.
May I continue?
May continue. Please ask.
Point of order, Mr. Chairman.
Representative Knight, you recognize for a point of order.
I know it's at the discretion of the chair, but I believe this representative has asked multiple questions, and I've been sitting here for a real long time with my hand up.
Representative Knight, now explain that, and I've become an expert on what is and is not a point of order. A point of order, and this is, I really hope this is the last time I have to say this, because I repeat myself, is when a member is challenging the ruling of the chair, and that is that. If I make a decision on something, that is what it is. Now, if you saw at the beginning of this hearing, there was a different chairman sitting in the chair. So the mere fact that I may have deviated to some extent from the rules, please accept my apology. I mean no disrespect to any of the members.
Apology accepted. That was not my intent. I did not think that you were disrespectful. I just wanted to.
Withdrawing your point of order. Representative Marson, you are now recognized for a follow-up question.
Thank you. This is only my second question, and my point to the representative, I want to apologize. I thought what you had in your bill was a Class B felony, and I now caught my eye to it's a Class B misdemeanor. So with that being said, I would withdraw my question.
Thank you. I appreciate the question and appreciate the clarification. Thank you.
Representative Newman.
Thank you, Mr. Chair. And thank you to the witness for answering the questions. It appears to me that your intent was probably to have this law or this bill address the situation where to prevent an argument between an adult and perhaps a teenage frontline worker. And that even though that it has a Class B misdemeanor as the penalty, as in any case, I believe, under the law, it's that penalty could be pled down to something as low as a violation. Was that your intent when you put forth this bill?
Well said, Representative Newman. I would say absolutely the scenario I had in mind was about frontline workers, typically low-wage workers. You know, just as easily, by the way, could be an older woman, to be honest with you. Typically, most of our low-wage jobs in this sector are women, like 80% actually. But that is an excellent point. And I do feel that we've put too many frontline workers in these situations to create these difficulties when honestly, I bet they do not want to be in that position. And the way you describe the pleading and the discretion of a judge would absolutely be what my intention was with the bill. I mean, we could reduce it to a violation. I do think, though, personally, I wrote the bill this way after lots of questions with law enforcement and a former prosecutor, and talking through that just a misdemeanor in New Hampshire means something very different and is much more hard-hitting than in many states, maybe most states. I would think there is a possibility, and certainly by the viral videos we've all watched, that some of these interactions, I don't think many of those were New Hampshire in all fairness, could be quite serious. So to have some teeth for those instances would be very appropriate. If you think we need to add more discretion with a violation or adding it the way you said it, Representative, I'm open to that. But I trust judges to use their discretion and experience in what the penalty phase of these decisions would be. And having the teeth in this bill with a Class B misdemeanor, I think, is a good thing.
Thank you for your answer, and my intent was only to gather your intent. Thank you.
Yes, and actually, the way you said it was better than my answer.
Knight.
Thank you, Chairman. Thank you, Representative, for taking my question. There's been a lot of we were trying to understand this, so a lot of my colleagues were making hypothetical situations. So as I understood this, I have a question based off all these hypothetical situations. Let's say somebody intentionally comes and coughs in my face. Like there's words exchanged, and then they go over and to intimidate me, they go over and sneeze or spit or cough in my face. I mean, spitting is already I think, considered an assault. But where I'm going with this is if they did this during a pandemic, is there any recourse that I can take if somebody coughs like this currently in my face, that I could go report to police and police officers actually carry out enforcement on a crime like that?
That is an excellent question. And that sort of differentiation is why I felt this bill needed to be written in the first place, because that actually enumerates exactly the sort of thinking I was concerned about. I think the interpretation of someone spitting in one's face is already a misdemeanor, and so that's good enough. If that's all that people did or potentially would do during COVID, that would be fine. We wouldn't need this bill. But someone merely, even with a mask on and getting within 3 feet, 2 feet, 1 foot, with this employee who's just doing their job could also catch COVID is also a concern. So this is specifically to codify that public health concern during pandemics and public health crises is exactly why we need this bill. To be able to say, simply getting in a closer, into the personal space of someone during COVID could be deadly, is exactly why I wanted this bill to exist. That still, to me, is an aggressive act and maybe could be considered assault the way the bill is written. I mean, the way laws are written without this bill. But too much of that is left to discretion. This bill is specifically to address that kind of concern, where the law is too fuzzy with what is considered an assault to specifically getting to what the health recommendations are today. So that was an excellent question.
Thank you, Chair. Can I have a follow-up?
Representative Knight, you're recognized for a follow-up question.
Thank you, Representative. I'm still a little fuzzy. Can you just, with just the shortest answer possible, just tell me, is there currently a recourse for someone that has been intentionally harassed or coughed on during a pandemic to go seek law enforcement help? Is there currently a system in place?
I guess one can call law enforcement anyway. The definition of assault doesn't cover what you stated specifically. A cough, I don't believe is considered an assault currently. So, yes, you could, I don't believe that. I'm trying to be as simple and short as possible. That's the intent of this bill, is to clarify what you just suggested. So the bill would be needed to do it properly.
Thank you.
Representative Hopper.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. So tomorrow I go and get a pedicure, and I'm really proud of it. So I walk into the shop, Hannaford's, without any shoes. What is the current law when the employee says, sir, you have to leave the building, you're not allowed to enter here without shoes? What happens now? What is the law relative to that?
I'm going to be honest with you that I'm not a lawyer myself, so I'm not an expert. I believe public health law covers that, but I don't know for sure. I'll be honest, I'm not an expert on shoeless entry to a grocery store. But congratulations on the pedicure.
Let's try to keep our questions relevant to the bill. I'm not. Representative Bolden.
Thank you, Mr. Chairman. Thank you for taking my question. My daughter is a teenage frontline worker, so she's been coming up in this conversation. She's 14, she's a cashier at a grocery store. And I've seen a lot of people in her store without masks on, and I've seen them go through her checkout line. And the nature of her job and the lack of cooperation with basic requests about hygiene in the store has made it so that we haven't been able to visit my mom, my elderly mom, for months. She's kind of high risk, but I just talked to her through the window in the front door. So obviously this has been really stressful for our family, and I wouldn't ever want to put my daughter in the position of having to choose between her, her first job and her paycheck and our comfort. So we forego visiting my mom so that Sophia can keep working on her goals. So I appreciate this bill, but I have a concern. I'm wondering if there are people who aren't able to comply with requests because of some maybe physical or cognitive limitation. I guess I don't see any language in the bill that provides flexibility in that situation. where someone isn't complying but it's not due to some refusal to cooperate. It's really through no fault of their own. So I guess my question is, are you willing to maybe bring some language back to the committee, an amendment that could address the issue of someone who isn't complying through no fault of their own? Thank you.
I'm open to amending this however the committee wants, to be honest with you. I think in a situation like that, and the employee is simply enforcing their employer's policy that leads to a difficulty, I'm not sure this bill would cover that currently. But if you think that needs to be a second layer of the bill, I'm open to it. The way that you worded it, I wouldn't see that would cause the employee to need to enforce anything specifically. But again, I'm open to amending the bill however the committee deems necessary. I hope that answered your question.
Seeing no further hands raised, the witness is excused.
Thank you, Mr. Chair. It's good to see you.
Here's our representative. And just to understand, due to time constraints, we are limiting testimony from the public 1 minute. We do, at the chair's discretion, we will allow exceptions for the representatives who are introducing the bill. Elliot Axelman.
And I'm scanning the list for him, Mr. Chair. I do not see him.
Laura Condon. If any members of the public are present in attendance that wish to testify, please raise your hands now as well.
I do have Laura Condon, and I'm elevating her as we speak.
Thank you, Representative Muse.
I'm sorry, I think it looks like I elevated the wrong person. Laura Condon, okay. And Ms. Condon, if you could unmute yourself. There we go.
Good morning. Can you hear me now?
Yes, we can hear you. And just a reminder, your testimony is limited to 1 minute.
Thank you very much. Good morning, Chairman Abbas and honorable committee members. My name is Laura Condon. I'm from Bedford. I'm a volunteer New Hampshire Director of Advocacy with the National Vaccine Information Center. And I oppose this bill, House Bill 493, that seeks to make a criminal out of everyone who chooses not to get a COVID shot and chooses to strengthen their immune systems through a healthy diet, good hygiene, and other effective lifestyle practices, rather than get a COVID shot that is still experimental and only approved for emergency use authorization. The bill also seeks to make a criminal out of everyone who selects a different medicine, say like hydroxychloroquine, for example, for reducing COVID symptoms upon possible infection, other than the experimental COVID shots. It is truly shocking that there is an attempt to criminalize health and medical decision-making and choices and seek to make a criminal out of everyone who might make different medical decisions other than those recommended by DHHS and the CDC during a state of emergency and beyond, I know, in the bill.
Thank you, Ms. Condon. Your time has expired. Seeing no hands raised, the witness is excused. His next witness is Tammy Anu.
I do not see.
Eric Horton. Mr. Horton's present.
Okay.
Reminder, Mr. Horton, your testimony is limited to 1 minute.
Thank you. Assault is a serious crime and one which has no place in a civilized society. But peaceful non-compliance is when a person disobeys an order without raising their fists or making angry threats. And what I'm afraid of is that this bill opens the door to first being applied as intended, and then later, when we're all gone, it could be misapplied to people who are simply being peaceful, not obeying the orders of authoritarians. It's really dangerous when the government starts granting itself more power under the justification of a state of emergency. So I just want to be thoughtful and consider that we already have laws that protect against assault. Assault is bad. We don't want bad behavior. But I'm afraid that this would be applied against people like Rosa Parks, who was just disobeying an order to go to the back of the bus. She was not assaulting the bus driver, but it was disobeying an order. And I want to just be cautious about expanding government power in the Free State.
Thank you, Mr. Ward. Seeing no hands raised, the witness is excused. Chair now recognizes Greg Pugh.
Greetings. Can you hear me?
Yes, we can.
Okay. I will be as brief as possible. Almost every word in this bill is problematic. It appears the whole purpose is to allow anyone to enforce anything but law, with the threat of force by way of governmental penalty for simple non-compliance. The scope of government overreach is quite frankly frightening. George Orwell himself might have come up with a dystopian concept of public service, but it is no place to be in New Hampshire. Mr. Chair and the members of the committee, HB 493 must never see the light of day. It's pathological in its design, and it is bathed in resentment, arrogance, and deceit. This bill must be ITL with prejudice, if possible. Thank you, Mr. Chair and members of the committee.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Caitlin Hudson.
Can you hear me?
Yes, we can.
Okay. I'm a member of the public and I strongly oppose this bill. I believe this bill is a violation of my constitutional rights. Under the current emergency mask mandate, many of us have already been under the threat of harassment, threats of physical violence and discrimination for not complying. Adding fines and possibly forcing vaccines is just adding fuel to a fire of civil unrest we're already seeing across the state. The state should never have the power to force any medical procedure or medical product on its citizens. Those of us who have medical or ethical or religious reasons for not taking a vaccine or wearing a mask are already the minority. We, the people of New Hampshire, should be free to choose what is best for our bodies and not lose our ability to function in society because we choose differently than the majority. I thank you for letting me speak, and I plead with you to vote no.
Thank you, Ms. Hudson, for your testimony. Seeing no hands raised, the witness is excused. Oh, excuse me, Representative Muse.
Yes, I just had one question. And my question is where it is exactly in this bill that would force people to get vaccinations or would penalize them if they don't?
It just is such an open-ended, with the compliance, it's pushing compliance. So say we turn where the majority does have a vaccine. Am I not going to be able to get a driver's license? Am I not going to be able to go get groceries? Because the mask was the beginning and the vaccine will be the next step. That is what they are saying, the CDC and so on is recommending these things, but we choose differently. The small minority of people choose differently, but we are going to be discriminated against. And this bill gives power to that for me to, and we're speaking about young employees. I don't want young employees being harassed. I have never treated someone with disrespect in a store when they ask. It is, again, with the medical issue, I don't want to sit and explain to a 16-year-old that I have medical issues and that's why I must not wear one. And I don't need to go in that same direction with the vaccine, because it is a snowball effect that this bill is so a blanket statement for all kinds of things that they want to do. And it's just wrong.
Thank you.
Seeing no hands raised, I want to thank the witness for her testimony. Questions. The chair now recognizes Rebecca Kishavinsky.
Thank you very much. I respectfully urge for you to oppose this bill. Failing to wear a mask is not a criminal act. There's simply not scientific proof that wearing masks even limits viral transmission. We're talking about the everyday masks that regular citizens are wearing. These are minute particles, and even the FDA had put out a statement on April 24th of 2020 stating to the manufacturers and healthcare providers that the labeling may not say that, recommendations against use in a clinical setting where infection or risk level through inhalation exposure is high. They may not state or imply that the product is intended for antimicrobial or antiviral protection or related uses, or for infection protection or reduction. So even though this is what's implied by masking, there's not hardcore scientific data showing that this is even effective. So to make this a criminal offense to not mask is a huge mistake. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair now recognizes Dan Verville.
Hello, can you hear me?
Yes, we can hear you. And just a reminder, your testimony is limited to one minute.
Okay. Yep. See, I strongly oppose this bill. Me and mine have been New England natives our whole lives. And we wound up buying property in New Hampshire. Why did we do that? Because New Hampshire, to our eyes, is the last bastion of the old republic. Our founders designed this nation to be a conglomeration of states and people in a barely controlled state of anarchy. The government deals with the larger issues we, the little people, cannot, such as interstate and international trade and diplomacy, national defense, as well as arbitrating judicial matters fairly, impartially, and justly. Beyond that, the government stays the heck out of our business and the minutia of our lives. We are allowed to pursue life, liberty, and happiness, and all the minutia therein as we see fit, so long as their pursuit does not unjustly interfere with someone else's pursuit of the same. This bill unjustly interferes with the aforementioned pursuit. This bill perverts those founding ideals. Let me illustrate.
Mr. Verbo, thank you for your testimony. We do have to limit testimony to 1 minute if your time has expired. Seeing no hands raised, the witness is excused. Representative Torossian.
I am looking for Representative Torossian. I do not see him.
Julie Ledoux. You have a phone call listener.
We do have a phone call listener.
You have.
I will. Would you like me to unmute the phone call listener,
Is
Mr.
there that person's hand up?
No.
Yes.
We do have Nicole Nordland. Her hand was up.
Nicole Norland, you're recognized.
Thank you. Can you hear me?
Yes, we can.
I strongly oppose this bill as it is written. I did send written testimony. However, they were all bounced back to each and one of your emails, unfortunately. I would just like to pose a question. If your job does not require you to wear a mask, if somebody comes in and acts, quote unquote, belligerently that you put one on, who would be charged? I just thought that would be food for thought. Thank you for taking my testimony.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair now recognizes Curtis Barry. Just a reminder, your testimony is limited to 1 minute.
Yes, good morning, Mr. Chair.
Good morning.
Members of the committee, thank you for the opportunity to testify. I'm Curtis Barry, before the committee representing the New Hampshire Retail Association and its several hundred members, both large and small. I'd like to sum up a few of the comments. As we know, emergency order number 74 requires people to wear masks in public spaces where they can't distance consistently. That comes along with responsibilities for the retailers, in our case, to inform the customers if they're not wearing a mask to enter, that emergency order requires them to do so. Now, subsequent guidance issued by the Attorney General's office that was requested by us outlines responsibilities, which includes that specific duty of informing the customer. We support the premise of the bill, which creates penalties for assaulting an employee simply for relaying that information. In that circumstance, that's required by the government. The employee could be elderly, as previously cited, could be a teenager, just simply doing their job, enforcing an emergency order.
Thank you, Mr. Barry. We have to limit testimony to 1 minute, and your time has expired. Seeing no hands raised, the witness is excused.
Mr. Barry.
Is Elliot Axelman present?
Mr. Chair, I did have a question.
Oh, you do. Sorry.
So sorry.
Oh, we're working together. My mistake.
No problem. Mr. Barry, I'm curious. I know you were cut off just as you were kind of getting to a point, but it sounds like your organization supports the premise of the bill, but you may have some issues with some particular parts of the bill. I'm just wondering if you might be able to outline for us what some of those might be.
Representative Muse, thank you for that. Yeah, I was going to say we support the premise of the bill. If the committee wishes to tighten up the language to get at the very specific intents, that's fine. I don't have any specific recommendations, but I'm happy to work with the committee on that. So thank you for that question. And Mr. Chair, I do have some information that may respond to both Representative Bolden's question and Representative Rhodes' scenarios that she inquired about earlier in the hearing.
I would encourage those members to seek that information out through a question.
Thank you, for sure.
Representative Newman, you're recognized for a question.
Thank you, Mr. Chairman. With your organization, I am not familiar with exactly what the enforcement is statewide on the mask mandate, but I am familiar with the mask mandate in Nashua. And it originally did not, it was very difficult to enforce, and they passed another amendment that said no mask, no service. So then it transferred the responsibility kind of to the realtor, in that it was then unlawful to serve a person without a mask unless they had a medical excuse for not wearing one. Does your organization have any opinion about how that might affect them?
Yes, we have actually very strong opinions. We think it's not appropriate for a government entity to ask a private sector employee to enforce statutes. They're not trained in enforcement, not trained in detention, not trained in conflict resolution, which is why the subsequent guidance from the Attorney General's office relative to Emergency Order 74 was welcome, which says, in essence, the store, the business relayed through an employee simply has a responsibility to inform the customer. And after that, if there's an issue, then law enforcement should be contacted. Yeah, our conversations specifically with the city of Nashua and then the Attorney General's office were both satisfactory in that regard.
Follow up, Mr. Chair.
Representative Newman, you were recognized.
I withdraw my question. I withdraw my question.
Thank you. Representative Bolden, were you going to? The witness wanted you to ask a question. Once, twice. Seeing no further hands raised, the witness is excused. Are there any members of the public who wish to testify that have not testified already? Seeing no hands raised, we will now close the public hearing on House Bill 493.
And Mr. Chair, on House Bill 493, we had 71 people signing in support of the bill and 490 signing in opposition, and we had one person who signed in as neutral.
Thank you, Representative. At this time, we're now going to open the public hearing on House Bill 419 relative to assault of a campaign worker at a polling place. I believe this is going to be, the chair now recognizes Representative Peter Terosian. Representative O'Brien, you recognize and introduce yourself.
Terosian.
Chairman Abbas, this is Representative Prudhomme O'Brien. Did you mean me?
Oh, sorry, your name was cut off.
Okay, because I had a little trouble signing up. I don't even know if you can see me. Is everything copacetic there?
We can't see you, but we can hear you just fine.
Okay, that's good. We'll go with that. That's good enough.
Just to clarify, although testimony for the members of the public is being limited, for the representatives in introducing the bill, the time restrictions do not apply to that representative.
Mr. Chair, I do see Mary Beth Terosian, and I'm just wondering if they may be sharing a computer.
That's his wife. It's all right. Oh, it is. This is the bill sponsor introducing the bill, so we'll allow her to use it, and then we will recognize Representative Terosian next.
Thank you. So I'll tell you a little bit about this bill. I'm sorry that you can't see me. I dressed up and I dressed nicely like a state rep today too. So that's always, but anyway, this bill was inspired by some events that happened in Windham and in Derry in February of last year during the New Hampshire primary. Some citizens were assaulted when they were merely holding signs for their candidates outside of the polling place, and people that disagreed with that candidate literally assaulted them, went up to them and assaulted them. Now, you know about the case in Windham, that was newsworthy, and the case in Derry, though, was not in the news because the victim chose to not press charges. So what happened in Windham was quite serious. The victims, there were 3 of them, later had to get a restraining order and go to court. And the police were there and witnessed the event, but they didn't arrest the man who assaulted the victims immediately. And this bill would give police more tools to address this issue. And I'll go back and I'll talk about what happened in Windham in case anybody does not know. What happened was there were people holding signs for their candidate at a tent. And a man went in and voted. And then when he came back out, he walked by them and then backtracked and literally assaulted them seemingly out of the blue to the victims. That was how they described it, is that they didn't expect that this would happen. The man took a sign that was on a wood holder and hit a young teenage boy with it, or was about to hit the young teenage boy when one of the other men holding a sign got in the way, but that man got bruises on his face. Another man attempted to stop the assaulter, and he got injured quite severely, and in a way that I did not see in the news. And because I went and I spoke to the men, I know that one of the men I knew already from his business in Derry in my town. I buy gas from him. I've known him for a long time.
91
and
and 71.
I saw that he had bruises. I spoke to the other man, and that man had a fractured jaw and lost a tooth in the attack. And the expense of having to get the tooth repaired is quite high. It's in the thousands of dollars to get an implant. So these people were severely injured, and then to find out that they have to do all of the work of getting the restraining order, getting lawyers, trying to fight this. The attacker wasn't arrested right away. He lives in the same neighborhood as one of the men that was assaulted. He and his family were frightened by that situation. So I looked at what state laws we have right now for poll workers, and I simply added campaign worker to poll worker. Now, with a campaign worker, I know it sounds like somebody who's making money from the campaign, but this of course includes volunteers that are simply holding a sign for their candidates. I never mentioned here what side these people were on, because that's not important. That's not relevant. We need to have a situation in our state where people feel comfortable holding signs for their candidates. This is a free speech issue, and they need to be able to hold signs for their candidates, or if they are the candidate, and feel confident that they will be safe at the polls. Now, when there was a young person involved, there was a teenage boy involved here who was much smaller than the attacker. And I myself, in the past, have gone to the polls without being certain about all of the candidates that were on the ballot. But I also knew that what I'd do when I got to the polls was speak to the people holding signs. That would be either the candidate or someone who supported the candidate. And I could ask them questions about the candidate, where they stand, what the issues are that are important to them. So when I have not had the opportunity throughout the campaign to learn more about candidates, that's how I have done it. And that opportunity should not be taken away from our New Hampshire citizens so that they can do the same thing. And if we pass this bill, that will make people who are campaigning at the polling place safer, and it will allow the police to have more, another tool in their tool belt to address this very serious situation. I'm glad that nobody was hurt more than they were. So I think that's everything. Are there questions? I hope I can answer them all.
Representative Bourdonnais.
Thank you, Mr. Chairman. Thank you for taking my question. Are you aware that we have laws against first degree, second degree, and simple assault in the state? Why is this law necessary?
Thank you. Yes, we are, but this was a situation that was witnessed by police, and the man was not arrested. He left, and he left the polling place, went home, and wasn't arrested for days later. I would go back and ask, why did we create these laws originally to protect poll workers? Okay, people that are this simply adds campaign workers to election workers in our laws. And why do we have those such laws? And that would be to protect the people that are working at the polling place so that they can do their job and our elections are safe and our citizens trust that they are safe and that when they go to the polls that they will be safe. And I think the same thing applies for people that want to hold a sign for their candidate. And again, not concerned with what side it is. They could be Democrats, Republicans, Libertarians, Vegetarians, I don't care. I think that they all should feel safe going to the polls and holding their signs.
Thank you.
Any more questions?
Representative Newman.
Thank you, Mr. Chair, and thank you to the witness for answering the questions. The issue you just brought up, whether it should apply or not to a citizen who is simply holding a sign and may not be associated in any way with the campaign. You'd like to broaden it to that. It sounded like that's what you said. Is that correct? And would you recommend an amendment to do that?
Thank you. I would be okay with it, such an amendment, but I do like to keep things simple so that they you know what, I'm fine with either one, and it depends on if the committee feels that way. Right now, it does say campaign worker, so it would be someone holding a campaign sign. So perhaps my wording with when I said vegetarian doesn't actually apply, but I would be accepting of that if the committee feels that's important.
Representative Newman, you're recognized for a follow-up.
Thank you for the follow-up. So I withdraw my question.
Representative Knight.
Thank you, Chair, and thank you, Representative, for taking my question. And I understand your intent, but my colleague, Representative Bourdonnais, asked, if this was already covered, this kind of protection was already covered already in our state laws. So my question is, as I'm a little confused, bear with me, does election procedure or campaign law, is it different? Like we have different rules in our body, the legislation. So state laws don't necessarily apply, like they're different when we're in a body. Is it different similarly here? Is that why this is needed?
Thank you for your question. There are enhanced penalties for if a person is attacked while working as an election worker. So if you're working at the polling place and you're, say, the supervisor of the checklist, or you're the town moderator, there are enhanced penalties in place that protect you. And this would simply extend those same laws to people who are campaign workers. That is how it is phrased here, but it would include a person holding a sign for a campaign. And so that's why I think this is a free speech issue. And when I found out that the people who had been involved in the Windham case had to do so much work to advocate for themselves after the fact. And when the man had a fractured jaw and is now looking at the expenses of thousands and thousands of dollars to get a dental implant to replace the tooth that he lost, that's just, I was just amazed. And so I thought that this was the simplest way to enhance penalties for people that do such a thing and protect members of the public who want to hold signs at the polling place. Yes.
Oh, Chair?
Sorry, Mr. Chairman.
Follow-up question?
Thank you, Chairman, and thank you, Representative. So currently, this victim, he couldn't get the assaulter to pay for these damages, or he couldn't get any sort of restitution because there's no law in place to protect campaign workers or volunteers.
Well, I think that may be coming later. He may find out more about that later as the court case goes through the system. But because the charges were, they were a misdemeanor, and like I said, the police police officer saw it happen, there wasn't much he could do. For some reason, the man was not even arrested and he was let go, and it was days before the man was arrested. Now, if we had this law in place, it would be obvious that it was as serious of a crime as it is.
Chairman, can I ask one more question?
You recognize.
Thank you so much. Do you believe that this might be a police protocol issue or not a law issue if the police were not, following a law that protects our residents from assault already?
Thank you, Representative Klein Knight. I think that's a good question. But I think that this bill will make it, like I said earlier, obvious to all, and that would include all police officers, that this is a very serious crime and should be treated as such, just as we would treat it that way if it were the town moderator that we did this to.
Thank you.
Representative Muse.
Yes, thank you for taking my question. Earlier, you framed this also as being a free speech issue. And so I guess my question for you is was the man who committed the assault acting on the part of the state in any way?
I'm not sure what his motivation was. I have not heard him explain what his motivation was, so that's unknown at this point.
Thank you.
Seeing no hands raised, I want to thank the representative for her testimony. Chair now recognizes Representative Peter Terosian. Hearing as Mary Beth Terosian.
Thank you, Mr. Chair. Can you hear me okay?
Yes, we can hear you, Representative.
Thank you. Good morning, Mr. Chair and members of the Criminal Justice Committee. For the record, I'm Representative Peter Terosian, representing Rockingham County District 14, the towns of Atkinson and Plastow. And I'm testifying today in favor of auto pass for House Bill 419 FN. To me, it seems like a common sense piece of legislation that, for that matter, anybody at the polling place should feel they're safe from being assaulted. And certainly at some point, we recognized that we need to put it in statute to protect people working in the polling places from the town, city, or a ward officer. I would suggest that a campaign worker at the polling place should be protected as well. And it's that simple. It adds a campaign worker at a polling place. I personally was attacked last February 11th, the presidential primary election. I was holding a campaign sign for a candidate in Derry at the polling place at Calvary Bible Church, which is 145 Hampstead Road. And a person coming in to vote shoved me. Now, I didn't press charges, but it was simply, it was unprovoked. That person just, I wasn't expecting it. It didn't knock me down. I have pretty good balance, but it would come out of nowhere. And I did ask the Derry police. They weren't there at the time. They came over and I gave them some information. I chose not to press charges. That's really not the issue. The issue is you shouldn't be feel threatened at a polling place when you're exercising your First Amendment right, whether it be working as a campaign worker or again as a worker that's participating to help the process of getting people in and out of the polling place voting. So I would just suggest that I don't see any downside to passing this legislation. Many of you probably know in New Hampshire, assault can be as simple as, and there's a definition for unprivileged contact. And this clearly went to that level. It was above just touching. It was a push, and it was a punch and a push, I guess is how I best describe it. So anyway, I hope you consider the OTP of this bill. And I would just add one last thing. I think we all know that a polling place these days can be a place of a lot of tension where people's emotions run high. So are people potentially more at risk of having these sort of things happen than in some other places? I would suggest yes. But anyway, with that, I would be, it's pretty simple legislation. I hope you consider it. And at that, I would be glad to take any questions that the committee may have.
Representative Knight.
Hi, thank you. Thank you, Representative Terosian. It's really nice to hear your voice. Yeah, thank you for bringing this bill. So you called the police and they came and they offered you the ability to press charges and document your assault. So my question is, how would this law protect you more than you were already protected?
Thank you, Representative, for the question. And as I mentioned, I elected not to go down that road of pressing charges. The police did not witness the event. There were witnesses that did. I don't know whether I would have been successful pressing charges or not. I would tell you that there was not a lot of interest in law enforcement wanting to get involved in the issue, and I wasn't pushing it. I wasn't pursuing it. So I don't know whether I would have been successful with that or not. Certainly, this legislation, if passed, I think would enhance the penalty, and whether or not that would make it easier to press charges, I can't say. But it may make people think twice if it's a more serious penalty than is currently there. People may think twice before they assault somebody. Again, thanks for the question.
No problem. Follow-up, sir?
You're recognized for a follow-up question.
Thanks, Chair, and thank you, Representative Terosian. So you're saying that if this were to pass, it would offer more protection to people at polls than we already have on the books?
Well, that's correct. If you look at the language, it under RSA 659:41, assault, etc. It simply adds the word or a campaign worker at a polling place. So it puts a campaign worker in the same class of protection, if you will, as town and city and ward officials working at the poll.
Thank you, Representative Terosian. It's a really nice again well, I can't see you, so thank you.
That's okay. Thank you, Representative.
Representative Newman.
Thank you, Mr. Chair, and thank you, Representative, for taking the question. Do you know if the phrase campaign worker is defined in the law? And if not, do you think it should be?
Thank you for the question, Representative. I don't know the answer to that. I don't know if campaign workers is defined specifically in other areas of statute. I don't know that. I'm not an attorney. But looking at the language, it looks to me, reading the bill, and again, I'm not a co-sponsor, but I simply testifying in behalf of in favor of the bill. If you look at the language, a campaign worker at a polling place, it seems kind of a pretty common, easy to understand term. But the legal aspect of that definition, I couldn't comment. Thank you, Representative.
Seeing no hands raised, Representative is accused.
Thank you. Have a good day.
Chair now recognizes Catherine Cooper.
Thank you, Mr. Chairman and members of the committee. This is Catherine Cooper, appearing on behalf of the New Hampshire Association of Criminal Defense Lawyers. We oppose this bill. I respectfully disagree with the two prior witnesses. This will not make anyone safer, and this will not offer anyone more protection. This is simply inflating penalties and essentially making people who are misbehaving at an election felons instead of misdemeanants. I would also just like to mention that I serve as the town moderator for the town that I live in, and I have several years of experience working at the polls and running the elections. I've also personally been threatened a few times, fortunately not assaulted. But I agree that people do get a little out of hand and a little hot-headed during election times. But I do not think that that justifies making them a felon for what is essentially simple assault. I mean, frankly, I don't even think that this statute overall is necessary. I think that the general assault statutes that we have and the criminal threatening statutes that we have that apply to the general public are sufficient. So I do not think this gives the police any more tools. I would agree with one of the comments made earlier that based on the story that was told, this was likely a problem with how the police handled the situation. It had absolutely nothing to do with the statutory structure of the state. So for those reasons, we think that this should not be passed and would request that the committee ITL this bill.
Thank you for your testimony. Seeing no hands raised, the witness is excused. If there's any members of the public who wish to testify that are in attendance that have not testified already, please raise your hand. Seeing no hands, Chair now recognizes Gordon Campbell. Mr. Campbell, you recognize?
Yes, can you hear me?
Yes, we can hear you.
Hi, my name's Gordon Campbell. I'm testifying in support of House Bill 419. It was actually my son and my family that were involved in the Windham incident. And from what I observed, the police were basically powerless on that night of actually arresting for simple assault. You know, my son was there expressing his First Amendment rights. Those were infringed upon. I think it's a little deeper than someone just slapping someone and calling it a misdemeanor. I think it goes beyond, it's repressing someone's rights. I think it should carry a little bit of a higher penalty than what's currently on the books. So any questions? I mean, our family's been through quite a bit through this whole ordeal, and it still is with us today, a year later. So we still talk about it quite a bit. But going forward, I think the perpetrator in this whole thing, even though he was emotionally overwhelmed at that point, he went in knowing and calling the poll workers fascists and all this, and he just snapped when he came out and hit the first person he could find, who just happened to be my son. So there's unprovoked assault, and I know the police did their best. They said they couldn't do anything unless they actually witnessed the perpetrator striking my son. The public was not very happy when they let him walk away, but they did build a case. They did bring it to Rockingham County, and I'm really not sure where the actual case sits at this point. But I do support making this not a misdemeanor when that does happen.
Thank you for your testimony. And, the chair just may inquire a question. So just for clarification, the police were present, but no one was arrested after this incident happened. And what was the explanation for why no one was arrested?
The explanation given to me, I was actually a first responder that went to the assault, and I found out it was my own son. But I was told by the police that due to the fact that it was not a witnessed assault, that just witnesses stating what happened was not enough to arrest somebody for assaulting a minor or anything like that. So they actually let him go, and actually said they had to build a case before they could go forward with it. If they had arrested him that night, they said that they really couldn't hold on to him for any particular reason. So I think that's why this bill's coming forward, to put a little bit more teeth into the campaign worker, protecting them.
Thank you again for taking my question. Representative Knight?
Thank you, Chair. And virtually you had pretty much the same question. I really want to know the reason, and I'm not a lawyer, forgive me. This is maybe more of a question for the chair because he is. Is that correct that police can take eyewitness accounts from an assault of a minor and then not arrest someone?
Representative Knight, please suspend for a moment. If you have any questions of the chair, especially technical ones that involve complicated legal matters, maybe we save that for the executive session.
Okay, apologies, thank you. I just wasn't aware that I just think this is outrageous, and I think that the police department, we really should have an investigation on them following proper protocols.
Thank you, Representative Knight. Representative Newman, you recognized.
Thank you, Mr. Chair, and thank you, Representative, for taking the question. Did you have any indication when this was not followed up that the reason for not following it up was that the penalty was not not severe enough to make it worthwhile, or if it had been some more severe that it would have been followed up?
No. Mr. Campbell?
Yes, I didn't know that question was directed at me. I think it was just going on it was just a minor infraction. I thought that assaulting a minor would carry a little bit of it would be almost a felony, not a misdemeanor. But to me, it went deeper than that. It's like there he is, at an event, showing his support for a candidate, and yet that had no bearing on the situation. I don't know if he was out on the street at McDonald's and the same thing happened. Would the charges have been different? That's where my question lies. I really don't know.
Thank you.
Mr. Campbell, if the chair may inquire for a question, and I apologize if you provide this information already. I know your son is a minor. Do you mind me asking, how old was your son at the time of this incident?
He was 15.
Thank you, Mr. Campbell. Seeing no further hands raised, the witness is excused.
Thank you, everybody.
Is there any members of the public who wish to testify that are in attendance already? Please raise your hand. Seeing no hands raised at this time, the public hearing on House Bill 419 is closed.
And Mr. Chair, we did have some sign-ins on this bill as well. We had 6 people sign in support. We had 11 people sign in opposition. And I also see Representative Burt in the attendee list. Would you like me to elevate him to a panelist?
That won't be necessary. Representative Burt is considered absent today. We have a substitute for him that's participating, who's sitting in the room with us. So Representative Burt, I believe, would be participating as a member of the public. We're glad to have him join us as a member of the public. At this time, we will now open the executive session on House Bill 493. Establishing a criminal penalty for an assault committed against a person who is conveying public health or safety guidance or requirements during a declared state of emergency. I'm I'm opening up for an executive session. Did I say public hearing? Executive session. Yes. Oh, excuse me. We're opening up for an executive session, not a public hearing. The chair recognizes Representative Wallace to make a motion.
Thank you, Mr. Chairman. I move House Bill 493 FN ITL.
Seconded. Representative Testman, you wish to be recognized to second that motion of ITL?
Yes.
Representative Wallace, do you wish to speak on your motion?
Point of order.
Representative Tree, you're recognized for a point of order.
I'm not trying to gum up the works at all, Mr. Chair, but did we close the hearing on 419? I did not hear that.
Yeah.
Did I close it?
Yeah.
Yes.
I'm being told that I closed it. But no, listen, but I will say that was an appropriate point of order. Because had I not closed it, then open the executive session. See, that's making sure we're following the rules. But I will give credit for the correct point of order. That means a lot to me when people actually make correct points of order. And now we've opened the executive session on House Bill 493. Representative Wallace, do you wish to speak on your motion of inexpedient legislation?
Thank you, Mr. Chairman. I will speak briefly. Although we understand the intentions of this bill, it is ITL because it is unconstitutional on its face, creating a special class of men, if you will, and that violates Part 1, Article 2 of the New Hampshire Constitution.
Are we on 493?
Representative Muse, you're recognized.
Thank you, Mr. Chair. Sadly, I find myself in the position of having to oppose this bill. I think this bill is redundant with our trespass and assault laws. I am extremely sympathetic to the situation, and I wish there was an opportunity to rewrite the bill so we could consider penalties, increasing the penalties somewhat for people who fall into these situations. I'm especially sympathetic with grocery store workers, restaurant workers, and other people who found themselves in this situation. I don't think this is a constitutional issue. It's more of a redundancy in our law issue. And I think one of the unfortunate things is this has been conflated into a partisan situation when I think, what we're really talking about here is the proper enforcement of the law. Throughout the state of emergency, I think there's been a lot of confusion around how the orders should be enforced. There's been a lot of anxiety on the part of people who own shops and stores and restaurants around what the role is of their employees and their staff. But what it doesn't change is the fact that if you are asked to leave a place of business because you're not complying with the policy of that business, if you refuse to leave or you walk by that person, you're trespassing and the police can be called to take you out. And if you decide to make a scene and to push people around and to assault people, then the other laws of our state apply in that situation. I think we have more of possibly an enforcement and an emphasis issue. And I also think we have an issue sometimes where the owners or the supervisory staff in grocery stores, sometimes I don't think understand, especially early on in the pandemic, really understood the importance of enforcing those orders. So all for the benefit of all their customers from a public health perspective. But this particular bill, the way it is written, without an opportunity to change or fix it, is not something that I can support going forward.
Representative.
I oppose this bill for a variety of reasons. We're focusing on the grocery store. Instead, I think that Representative Hopper presented a good point, and that is that if you look at this, it basically says if you have some policy that your group intends to enforce, it becomes a violation of law. And here it is relating health or safety guidelines or recommendations, regulations, or rules from a federal, state, or local public health agency. That's a pretty broad statement. And that could be as much as, do you have a vaccination? Or as she said, you get into an accident, you're in the hospital and you are injured and they want to vaccinate you after they, or maybe before, they end up treating you. I just think that this is such a broad law. I know what it was trying to do. It was trying to say mask. It was an anti-mask law without calling it an anti-mask law. I just think, but I think its broader implications are absolutely horrendous. The kinds of injury that could be occurring here are just unbelievable.
Representative Hopper.
Thank you, Mr. Chairman. One question of the chair, I guess, is I don't know why you kind of ruled me out of order, because although I was making a joke about the pedicure, the idea that the store can already enforce health ordinances seemed to be very relevant, because this is just an additional health ordinance.
Are you making a point of order?
I'm just commenting. So but the bigger point is the sponsor seems to be extremely well-intentioned, but the way that the court rules has nothing to do with intention. The court only rules on the actual letter of the law that we pass, and whether we intend it to do X, Y, or Z is entirely irrelevant when it gets to the court. So, well, as Representative Testerman said, this law, if passed, could be applied in a myriad of ways, none of which were intended, but could still be abused by people to suppress the public.
Representative Hopper, at the time that you were asking the question, I may not have found it to be relevant. I may have gotten lost in the analogy. And if that's the case, it may have been relevant. I do apologize.
Was it just the thought of my feet?
That probably contributes to the distraction. But I do apologize. Representative Klein Knight. In the future, though, a point of order must be made immediately. If you made a point of order now, it actually would be an incorrect point of order.
I didn't want to get into minutia.
Thank you. Representative Klein Knight.
Thank you, Chair. I agree with everything that my colleagues are saying. Unfortunately, I think we could work on this, and out of respect for frontline workers, I think it would be a disservice to immediately kill this right out of the gate. So I'll be voting against the ITL. Thank you.
Representative True.
Thank you, Mr. Chair. Mr. Chair, maybe just as a point of information, would the chair be willing and able to explain what the end of the bills for a period of 6 months after such declaration? What time frame is
so? My interpretation of that, and I will just limit that to my own interpretation. So whatever violation of this, if this were to pass and the violation were to occur while we are in the current state of emergency that is declared by the governor for the COVID-19 pandemic, but this would also remain in effect about 6 months thereafter. It also, this will take effect January 1st of 2022. Maybe I'm a glass half full type of guy, but I'm really hoping that we are no longer in a state of emergency by January 1st, 2022. That's just taking glass half full. Representative Bourdonnais.
Thank you, Mr. Chair. I'm going to support the motion to ITL. This bill is completely unnecessary. We have laws for assault, both first, second, and simple assault. We have laws against threatening, criminal threatening. But the third section refuses to comply as an assault charge with that not being the meaning, the intent of the a sponsor, is really about abomination. I don't think that they understood the bill that they wrote. So I'm going to vote for the ITL motion.
Who's watching what? No one else to answer that. I would just emphasize one point here that refuses to comply with another. I understand maybe well intended. That could apply to social distancing. For someone who inadvertently becomes within 6 feet of another person, this is going to be tough to enforce. One of the, I don't really engage in the conversation about masks. I always thought it would be hard to enforce on 1.3 million people, but I think this would fall into being very difficult to enforce and then prosecute. With that being said, if you have to ask someone to comply with a health order through the, COVID, whether it's the mask mandate or whatever, they're technically already violating the executive order, which is already an offense. I think it used to be a misdemeanor. The executive order changed that to a civil penalty, but it's already, that is also still against the law already to not comply with these orders. So we're just, instead of saying you're being charged for violating the state of emergency order, you're being charged under a second-degree assault. But you're not committing second-degree assault. You're violating an executive order. I think that's, if you're confused by what I just said, is the reason why you should probably be ITLing. Seeing no further hands raised, the question will be moved. The clerk will now call the roll. If you are in favor of the motion inexpedient to legislate, please say yea. If you are opposed, please say nay. And can the members participating remotely please turn on their cameras? Friendly reminder.
Chairman Welch.
Aye.
Representative Mooney.
Yes.
Representative Green.
Yes.
I'm sorry. Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harry Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Golden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
No.
Representative Bradley.
Yes.
Chairman Hess.
The chair votes yes.
Mr. Chairman, the vote is 20 yea, 1 nay.
I voted 20 yeas and 1 nays. The motion of inexpedient to legislate is passed. I'll move to put that on consent. Will there be a minority report?
I don't think so. Unless Nicole, yeah, she's saying no.
She waved off. Would anyone be interested in preparing the majority report?
I'll do it if you want.
Representative Hopper, thank you.
I thought the guy that moved on.
At this time, we will close the executive session on House Bill 493. This time, we are opening the public hearing on House Bill 239 relative to the prosecution for certain assaults against minors.
Yeah.
Chair now recognizes Representative Abramson.
This is Representative Abramson. Can you folks hear me?
Yes, we can.
All right. Still not used to these testifying by Zoom sessions. So this is House Bill 239 FN. I'm not sure why there's a fiscal note on it, but I introduced this bill last session, and it was one of the bills that passed unanimously, and of course passed unanimously through the House by a consent calendar and was killed during the coronavirus lockdown. The Senate didn't take up vast majority of our 2020 bills. So essentially what the bill deals with is a problem where a child is abused or is the victim of felony assault frequently with someone they live with or stay with. If it's felony assault, the current statute of limitations is 6 years. And I absolutely agree with the idea of a statute of limitations. The New Hampshire Supreme Court has said that there are two very important reasons for having a statute of limitations. That is to kind of get the prosecutor on the ball and get the case moving forward and not have things just delay in the courts for long periods of time. And also to ensure that the accused has the right to bring in defense witnesses in their favor who have a relatively fresh memory of the incident, if an incident occurred or if there's an alibi or some such thing. But there's a problem with a child. The child is usually living with someone else or staying with someone else or has a regular babysitter, and that child could be severely victimized. And if they are subject to serious bodily injury intentionally by another attacker, especially if it's someone they live with, then it's unlikely that they're going to come forward right away. So I don't base bills on specific instances or incidences, but this one is an exception where there was a child where the physical abuse started at age 4, and there was certainly felony assault committed against him at some point along the way. The problem is that whatever attack happened when he was 4 years old, the statute of limitations has run out by the time he's age 10. So I had a sit down with legislative services, and I suggested last session that we start the clock on the statute of limitations when the child turns 18. And a few members have suggested, okay, well, it's a 6-year statute of limitations. Why not have it go until their 24th birthday? And that would be much simpler. One of the problems, if you read New Hampshire case law, is from time to time, you'll have somebody who knows that they're accused of a crime and they'll leave the state for an amount of time, or they'll be inaccessible. So the actual statute of limitations clock, if you think of it as a stopwatch, it can only be running down while the prosecutor has a realistic chance to go after someone. So that's why the wording seems a little bit odd. 6 years after their 18th birthday, so the child turns 18, the victim turns 18, and then the victim has 6 years to come forward. And it has to be 6 years while the attacker is still in the state and is accessible by the prosecutor, and they can get access to witnesses. Sometimes you have people who know they've committed a crime and they'll even leave the country to evade justice and try to run out the statute of limitations. So that's why it's 18th birthday plus 6 years. But again, this committee did pass it unanimously last year. It was just, we sent it over to the Senate, and they took a large number of bills, a couple hundred bills, and they just tabled them, and they died on the table, unfortunately. So this is one of a few bills that I'm reintroducing this year in hopes of getting it passed.
Thank you, Representative, for your testimony. Representative Mooney.
Thank you for, Mr. Chairman, recognizing me, and thank you, Representative, for taking my question. I'm sitting in on criminal law today and learning quite a bit, but I want to ask you something. In 2005, I co-sponsored Senate Bill 75, which was very similar to this, related to RSA 508:4-G. At the time I sponsored the bill, it was so similar. It was 7 years from the 18th birthday, and then there was 3 years from the time of the plaintiff discovery.
Mhm.
But if you look at 508:4-G today, there is no statute of limitations. Have you compared your bill with that statute, and how does it relate, if it does at all?
Is that 508 section 4-G, a person alleging to have been subject to any of the offense under RSA 632A or 639-2 may commence a personal action at any time?
Correct.
That one is based on sexual assault. So that one, for some reason, I read it some years ago in another case that it was 22 years, and maybe you changed the law to remove that. I personally believe that you have to have a statute of limitations, having read the New Hampshire Supreme Court cases on it. But I thought, well, if someone commits sexual assault and that doesn't have the 6-year statute of limitations, why aren't we also starting the clock when it was actually, at the time, it was the child turns 18, and then it was, I think, 22 years, which I feel like is a long time to let the prosecutor kind of sit on a case. It's very rare. After a year or two, it's very rare that the prosecution just accumulates additional evidence by chance, although it does happen in wrongful conviction cases. But the statute of limitations is intended to kind of get the investigators to get moving and not hold on to cases and allow once you're accused of a crime, you need to be able to have a realistic chance to go after your own defense witnesses and gather evidence. There's a whole line of law dealing with that, but that one I thought was just sexual assault related crimes. So I thought, well, if it's felony sexual assault, for example, against a child, then it made sense that if someone also committed felony physical assault, breaking a child's arm, for example, or causing some other long protracted injury, purposely causing serious bodily injury to a child, that would be obviously felony assault, even if they're 13 or 14 years old. It would still, in that case, would still be felony assault. But it made sense in my mind to just start the clock when the child turns 18, rather than potentially the child turns 18 and now they're out on their own. They then go to report the case now that they're no longer under the roof of their attacker. That it didn't make sense in that case. That could be in some cases, the first opportunity that the victim has to come forward and report felony physical assault. It made sense to me that the statute of limitations should actually run when there's a realistic chance. The clock should run. There should be a statute of limitations, but the clock should only run when there is a realistic chance to go after the perpetrator. So yes, I am aware that it is different under sexual assault cases, but I just wanted to keep this very narrow down to felony assault.
Representative Klein-Knight.
Thank you, Chair. Thanks for taking my question. Do you know on average how long it takes for the typical abused child to come forward and make their situation known? How many years, basically, when they sit with trauma, do they finally come forward?
It could be the same day. However, in some cases, both physical abuse and sexual abuse, people are frequently in their 20s before they come forward. In some cases, there are certain types of abuse. For example, trying to remember the experiments by Joseph Mengele. This is not an American case, but children were subject to physical abuse that was so bad that it fractured their personality. And with Joseph Mengele was taking the extremes of torture in order to change their mind. He was trying to create something like a Manchurian candidate or somebody who could be controlled. But they found that that the trauma could be so bad that it could fracture their personality, and people could be as old as 28 years old by the time the they were finally able to access their memories. So it's possible in that case, although that's a very exceptional case, that due to the psychological damage, it could take even longer. It could take up to 10 years or 15 years before the person realizes it, before the memories finally come forward and the brain is developed enough that they can go back and review what happened.
Follow-up?
You recognize for a follow-up question?
With that being said, this bill wouldn't protect them, in my understanding. And my question is, with 90% of children being abused by victims of or members of their own family, and knowing that it takes that long to come forward and be brave and tell your story, are you open to an amendment to make this 6 years seems like it's just not going to protect the majority of victims that wait to come because they don't feel safe to tell their story?
I'd even thought of going to 10 or 12 years after they turn 18, so that they're in the, well into their 20s when they come forward. I think that pushing it even further might be, obviously the bill now belongs to the committee, so it's a decision that's up to you. But I'm just introducing the bill to introduce the question or the problem. What we're trying to do, of course, is with the law create a deterrence, so that there's at least a realistic chance that somebody who commits this type of felony assault against a child, yes, a super majority of cases, it's somebody who is under the same roof, but that's exactly why whatever you choose to set the statute of limitations at, I would start the clock at their 18th birthday.
Thank you so much.
Seeing no hands raised, Representative Abramson, you are excused.
Thank you.
Are there any members of the public who wish to testify that have not testified already? Seeing no hands raised, we now close the public hearing on House Bill 239.
And Mr. Chair, on House Bill 239, we had 12 people signing in support. We had 2 people signing in opposition.
Say again?
12 in support and 2 opposing.
Thank you.
At this time, we will remain in recess. The Criminal Justice Public Safety, we will remain in recess to at least 12:30. Alrighty, and mute the devices. You don't normally get a lunch break, so just please enjoy your lunch. And do you guys mind if we do a Republican caucus? All right.
You should see the paperwork. It's got to go to the clerk's office, the speaker. It's not
Do I
just,
want to be,
it's not just,
come up to your committee? I'm not sure.
All right.
it's not just willy-nilly.
Can the folks at home hear us? Hello, everyone. Representative Pantelakis, Representative Bordy, can you hear us?
I can't hear.
Well, they're on mute, but
Oh, is that,
We can hear you.
Representative Bordy, can you mind just saying something, make sure we can hear you guys?
I can hear you.
All right. Okay. Representative Gabriel, good to see you. We miss you in the room today. See, she's not used to having to unmute herself.
Hey, I'm sorry about that. Have to get my car registered. Slipped away from me.
All right, well, I keep looking to my right and,
Okay.
we're gonna, at this time, we are gonna open the executive session on House Bill 147. And then I recognize Representative Rhodes to make a motion to retain.
Thank you, Mr. Chairman. I would like to make a motion to retain House Bill 147.
And a second by Representative Welch. You don't wish to speak on that?
Sure, thank you. You know, I actually am a huge supporter of this bill. I do think that it is necessary. However, I do think that the bill, there's some work that can be done on it. I think to make it stronger, and instead of ITLing it, I think that it deserves another look to see if it can be stronger.
Representative Bornay?
Thank you, Mr. Chairman. I'm not in favor of retaining. I think that this bill has no merit. After listening to Catherine Cooper, I was convinced that there's no reason for to have this in law. Thank you.
Respect, I really disagree with the statement that it has no merit, but that's all right. Representative Fine Knight.
Thank you. I agree with Representative Rhodes. I think there is merit to this, and I think elder abuse is on the rise in our country. I'm not sure about the statistics in New Hampshire. I know that we have a real problem with elder abuse when it comes to theft and fraud, and I just want I would like to see us work on this more, and I'll support the retain motion. Thank you.
Seeing no hands raised, the matter, the clerk will call the roll. Now we put the question. If you're in favor of the motion to retain, please say yay. If you're opposed, please say nay.
Vice Chairman Welch.
Yay.
Representative Mooney.
Yes.
Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
yay?
Representative Pratt.
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harriet Gathright.
No.
Representative Pantelakis.
No.
Representative O'Hearn.
No.
Representative Bordenay.
Representative Bornay? You got to mute.
No.
Representative Muse.
No.
Representative Newman.
No.
Representative Bolden.
No.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman Abbas.
Chair votes yes.
Mr. Chairman, the vote is 14 yay, 7 nay.
By a vote of 14 yeas and 7 nays, the motion to retain is passed. We will now close the executive session on House Bill 147.
Huh? 14? Who's this?
Back to school. Dave,
All right.
honor report, agenda 21 math.
Now we're getting a little brain dead.
I have a question of the chair.
Representative Gathright?
Yeah, who moved, who are the two people that made the move on that?
I believe Representative Rhodes made the motion, and I believe that was seconded by Representative Welch.
Thank you.
At this time, we are opening the executive session on House Bill 307. I believe this was last open. We went into recess because there was an amendment. That was 2021-0411H. Some concerns by committee members that were expressed loud and clear about having an opportunity to review the amendment. Actually, that was on Friday, so hopefully this didn't ruin the weekend, but I would presume that every member at least had an opportunity to review the amendment. I believe there was an off the pass motion to withdraw the amendment. However, that motion is no longer in favor. Representative Hoffman, do you wish to be recognized to make a motion about the pass and offer an amendment? Say no.
I'll make a motion to adopt the amendment.
Okay. Well, there has to be a positive motion on the floor. Representative Welch, do you wish to make a motion about the pass and offer?
I'll make a motion to find House Bill 307 not to pass with amendment.
Is that amendment 2021-0411H?
I'll say that again. 0411H.
Mr. Chairman, just for clarity, the motion right now is ought to pass the amendment.
It's
Option of amendment.
It's ought to pass off the amendment. That needs to be seconded.
It's adoption.
Someone wish to second? Representative True, you
Second.
recognize the second.
Second.
You wish to speak to the amendment? You don't have to.
Mr. Chairman,
Representative Pantelakis?
yes, I want to tell you that I do not receive those amendments. I just got off my email and I did not receive John Burke's from last week. I don't know what the problem
Is there someone in this
is,
as the
but I am not receiving them.
Is there someone in this room, can they please forward a copy of the amendment to Representative Pantelakis?
I can take care of that, Mr. Chair.
Thank you. Representative Pantelakis, accept our apology.
Thank you.
The matter is now open for discussion. Representative Bourget.
Thank you, Mr. Chairman. This bill is so bad that any amendment to it will not improve it unless it is to repeal RSA 159:26. Thank you.
Representative Muse.
Yes, I'm opposing this amendment, and I do realize that there have been some changes made. The level of liability has been reduced from $100,000 to $10,000. And it looks like individual elected officials in cities and towns will no longer be liable personally for the cost of the suit. But what it still does is it essentially allows any person, or not any person, but it involves allowing people who do not live in a particular community, who consider themselves aggrieved, whatever aggrieved means from a legal standpoint, to bring one of these suits and to file for damages. I think that regardless of whether we're talking about Second Amendment, First Amendment, Third Amendment, Fourth Amendment, is an extremely dangerous precedent for us to set. We heard testimony from the New Hampshire Municipal Association that they opposed this bill, and the reasons why the Municipal Association opposed this bill have not been addressed in the amendment. So I have to agree with Representative Bourdonnais. Amendment should go down, and this bill should go down with it.
Representative. Who's that going? Representative True.
Thank you, Mr. Chair. The way I'm reading 307 with the amendment, it is simply restating the fact that New Hampshire is a Dillon Rule state. And to reinforce that fact so that all municipalities in the state recognize that fact, it puts some teeth into a penalty for a town that says, we don't agree that New Hampshire is a Dillon Rule state and we'll do things our own way. And under New Hampshire law and Dillon Rule, they don't have the authority to say that. If I am traveling through an area of New Hampshire that I am not from, and I am aggrieved because some town decides that they have an ordinance regarding firearms that is in conflict with the Dillon Rule, it doesn't make any difference if I'm from Sandown or if I'm from Pittsburgh. If a town is violating my rights, they're violating my rights, and I should have the legal access to ask to be made whole. Thank you, Mr. Chair.
Seeing no further hands raised, the matter will put the question. The clerk will now call the roll. If you're in favor of adopting Amendment 2021-0411H, please say yea. If you are opposed, please say nay. And for members participating at home, just remind you to turn on your video devices, or camera devices.
Vice Chairman Welch.
Aye.
Representative Mooney.
Yes.
Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gathright.
No.
Representative Pantelakis.
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse, Representative Newman,
Give him a minute. I believe he stepped out. So not participating now.
Yeah, he might have stepped out, so.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 11.
By a vote of 11 yeas and 9 yeas. So by 11 yeas, 9 yeas, the motion to adopt amendment 2021-0411H has passed. Welcome to make a motion about the pass as amended now.
I'll make a motion not to pass with amendment for House Bill 307.
Representative Walls.
Thank you, Mr. Chairman. I second that motion.
Representative Walls or Representative Welch wish to speak to the motion?
No, I think we all understand it.
Representative Bourdonnais.
Thank you, Chairman. I have to oppose this amendment to a bad bill law. 159:26 disallows schools to regulate schools on their property, which federal law already permits those regulations. In fact, they restrict the use of the carrying of guns on the school property unless they have a concealed permit. And then if a town or municipality want to restrict the use, the possession or use of firearms in public parks, they should be able to do that on their own individual town. Now, if some towns don't want any restrictions on the use of firearms in their parks, then they don't have to make such ordinance. But I totally reject this bill and 159:26.
Representative Muse.
Thank you, Mr. Chair. I think that bill, in addition to all the other issues it has, also has a constitutional issue. So in particular, the definition of aggrieved is having a feeling that one has been wronged. And this is very different than the requirements under our law that demonstrating a person or entity has required a definite and concrete personal injury and has personal rights that were impaired or prejudiced, which is actually required by Part 1, Article 74 of the state constitution in order to have standing to bring a lawsuit. I feel that this bill that we're about to take a not to pass with amendment vote on is unconstitutional for that reason and does not deserve our support.
Representative.
Thank you, Mr. Chairman. In reference to Representative Bourdonnais' comments that if a town or municipality, and I'm not quoting exactly, so bear with me, if a town or municipality wants to make a rule or a law that says that you're not allowed to have your firearm in their town, but they should be allowed to do that. How could that even be a Second Amendment? I don't even know what to say to that. So when you're driving through a town, now you have to stop and take take your magazine out of your firearm, go lock it up in your trunk, get through that town, go back, be able to go back to being able to protect yourself again. I'm sorry, I've got nothing else on that. I don't know what to say.
Representative Klein Knight.
Thank you, Chair. Thanks, colleagues. In light of what Representative Bourdonnais and Representative Muse have said, I can't support this. It opens up the state to being sued because it directly is in conflict with federal laws that are already placed here. And if that is the case, that means our taxpayers will be paying for the right for everyone else to just carry their guns and not being observant of the federal guidelines that are already in place. And that's very irresponsible. And it's not fair to my citizens. And for that reason, I'll be voting against this.
Representative Green?
Thank you, Mr. Chair. A friend of mine moved back from Georgia not too long ago, and he told me that there's a town in Georgia that if you want to live in that town, the requirement is that you own a firearm. Kennesaw. And everyone in that town has a firearm, and it's one of the safest towns in the country. So I will be voting for this bill.
The town requires your.
Kennesaw. Yes, thank you.
And all those conscientious objectors don't have to. Who knows?
I'm sorry, what town was that?
Kennesaw.
Kennesaw, that's the law. That's a town in Georgia, just for the record.
Just outside Atlanta.
Representative Pandelakis?
Yes, thank you, Mr. Chairman. I think this bill is too far-reaching. Not everything is guns. We do have rules about dogs and other things within our towns and cities. Is that going to aggrieve somebody?
Is that, is that a question?
No.
I do respect the point.
I just think it. Okay.
Have everyone who hasn't had an opportunity. Representative Mars, did you hand up?
Oh, no.
Oh, my mistake. Representative Wallace, did you have your hand up? All right. We have a few more bills to accept before 1:30. Has anyone not spoken yet that would like to speak? Seeing no new speakers with their hands raised, the matter will be put to question. Clerk, call the roll.
Where's my hand up, Mr. Speaker?
You just got elevated.
Well, Representative Marsden, please. You're not recognized to speak. Representative Knight, the chair is doing is that I'm recognizing everyone to speak. If I haven't recognized any member to speak a second time. It is within chair's discretion to not recognize any member to speak a second time. So in the interest of what we have left, we're gonna move the question unless anyone who hasn't spoken already wants to.
Thank you, Chair.
Seeing no further hands raised, the matter will be put to question. The clerk will now call the roll. If you're in favor of the motion ought to pass as amended, please say yay. If you're opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Mooney,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
the clerk votes yes. Representative Harriet Gathright,
No.
Representative Nicolakis,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman, Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 11.
By a vote of 11 yeas and 9 yeas, the motion of ought to pass is amended, is passed. Is someone willing to commit, complete the majority report? We'll let them know. Will there be a minority report?
Yes.
At this time, we'll close the executive session on House Bill 307. At this time, we are opening the executive session on House Bill 239 relative to the prosecution for certain assaults against minors. Is there anyone interested in being recognized to make a motion? Wow. Not all at once now.
What number are we on?
House Bill 239. Representative Bordenay, you are recognized. Make the motion.
Chair, I make a motion to ought to pass.
And I'll second it.
That motion has been ought to pass and is seconded by Representative Gaffroy. Representative Bordenay, do you wish to speak to your motion about to pass?
I think this is a reasonable extension of present law to allow the statute of limitations to go 6 years past the age of 18 for minors.
Thank you, Representative Bordenay, and you and I both served on the committee last term, as did a lot of members, and I believe we passed this on consent. Am I correct when I say that?
Yes.
I'm not sure. Probably.
So, Representative Knight.
Thanks. I don't have the statistics in front of me, but I know the majority of child abuse victims of child abuse really take a long time to come forward. So this is great, but I don't think it does enough. I don't think 18 plus 6 years is enough for victims. So I'd really like us to make this longer. I hope there's someone on the committee that feels the same way I do. I wish we could make an amendment for that. But if that isn't the case, I'd rather see this pass than nothing at all. So thank you.
Representative Knight, I appreciate what you have to say, and I will tell you this. I do agree with you that I would, at a different time, would support making 6 years, 10 years. But I will say, we did have a bill last term that did not pass, that would have got rid of the statute of limitations all the way. We could reach a point where too much is too much. So I would say let's start with 6, but in another term, at a different time, if you and I are both members, and you wish to file a bill, maybe keep me in mind as a co-sponsor.
Thank you, Chair.
Does anyone else wish to discuss the motion about the pass? Seeing no hands raised, the matter will put the question. The clerk will call the roll. If you are in favor of the motion about the pass, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Mooney,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn,
Yes.
Representative Bordenay,
Yes.
Representative Muse,
Yes.
Representative Newman, Representative Golden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman,
Chair votes yes.
20 yea.
By a vote of 20 yeas and 0 nays, the motion of ought to pass passes. I'll move, put that on the consent.
Bordenay, Representative Bordenay.
Representative Borney, will you be completing a majority report? A little bit on time. Just a quick friendly announcement to everyone, and please someone make sure if this is communicated to Representative Newman. So we're on, in all likelihood, we're gonna meet on the 11th. Sorry, the 10th. So after Wednesday the 3rd, we're gonna meet on Wednesday the 10th. Right, we're also gonna have something scheduled on the 11th, in case we don't, that's also our deadline day. So all the bills we have left need to be out of this committee with reports, might I add, so if I get a little, fired up over getting your reports in, just forgive me now. But, I'm gonna get some clarification on whether we have to schedule something for the 11th or we can just meet to exec. It's not proper for us to formally notice an executive session, but if we can avoid meeting on the 11th, that would be great. So my question is to the members, whatever's left on Wednesday, it would be about 8 bills. If we can get all those done on Wednesday, kind of like a
Marathon.
if we can get that done, we don't have to come in on Thursday, but it may be a late night. And then you'll have, we can get our reports, let's keep that in mind. Is there any feeling on us staying here till 7 o'clock on a Wednesday next?
If Representative Mooney wants to substitute for me.
Let's not.
But she may say yes now, then change her mind throughout the day, the rest of the day. So. But I just want to let everyone know that can avoid us, and that would really help the other committees out too, because there's a limited amount we can meet. So maybe we try to go the distance on that Wednesday, but it will be a late night. If you come to the room and can't stay, just please, you need to put in for a substitute if you wish for someone to sub-board it. Simple as that. Does anyone have any issues with that? Please speak now. Because once I give away the Thursday the 11th, it's not coming back.
If we're gonna go past 5 o'clock, you should probably get a substitute for me.
You would have to formally notify me that you can't, but I can envision us going, you need to be prepared to go past 5 if you want to be present for the second.
Right, that's what I'm saying, I'm formally telling you, saying that now.
That was the form, okay. All right, I believe the only other bill we have outstanding right now is House Bill 419. At this time, that we are opening the executive session on House Bill 419 relative to the assault of a campaign worker at a polling place. Representative Bordenay.
Thank you, Mr. Chair. I'd like to make a motion to ITL this bill.
Second.
That motion has been seconded by Representative Hopper. Representative Bordenay, do you wish to speak to your motion?
Yes. I feel the bill is unnecessary, and the raising of the assault issue for a campaign worker, which is, we're not sure who that person is, from a possible simple assault to a felony assault is, I think, beyond the pale.
Representative Muse?
I would agree. I would also say that we do have existing assault statutes on the books that would seem to address these issues. I think this is sort of our day to get legislation we really sympathize with. My wife is a campaign worker. I think all of us at one time or the other have probably in our careers have stood outside a polling place with a sign in our hands and understand what it's like to kind of deal with people who might be confrontational. But we do have laws in the books that that do provide justice in these situations. And I think maybe one of the things that might be necessary in some departments is occasionally reminding officers, you know, especially in inflammatory situations like the polls can be anymore, to really be on the lookout for this stuff and to not have any tolerance at all for physical confrontations. Like I said, I sympathize with where the sponsor is coming from, but I don't agree with changing our law in the manner that's outlined in this bill. Thanks.
If I can just point out, this is more, it's not necessarily the policy of this bill. It does say in there, if I can find it, it says a Class A or Class B felony, which when we see something written that way, just for interpretation purposes, it really leaves it within the discretion of the county or just the county or district attorney to prosecute under A or B. The law is written that way. If it's a really old law, will have be written. Sometimes we'll just say felony, but a person needs to be on notice when they're being charged what the offense is, so they know what the penalty is specifically. And that's a constitutional right. I don't think this really violates that, but I wouldn't support really having it be left open to the discretion of the county attorney to whether they feel it should be a Class A or Class B. I just think regardless of the policy, we should pick one. Whether that's stealing dogs or assaulting people at campaign workers, you know, at the mowing shows. Just that's something to keep in mind. I think what happened in Wyndham particularly is I am shocked that such a situation, a minor who's 14, 15-year-old kid can be assaulted by an adult in front of so many people, and you have a certain amount of witnesses, including someone who suffered a broken jaw, trying to defend the child, and no one be arrested on site. Now, maybe no harm, no foul, because the person's still eventually indicted. I'm not sure if they're indicted. It's going through the court system now. I just find, so it is kind of concerning that person wasn't arrested right away. I know that what I do know about the facts that the person was the defendant was local residents as well. So maybe there's some. I don't want to speak to the police. I'm just very surprised that person wasn't arrested for a violent crime. If this was a domestic violence case, there would be an exception. Assault on a minor. I'm just concerned how that happened, but that's really a police practices situation, and something that maybe should be looked into what occurred and why was there no arresting on site. I'm not a police officer, but I think it's a problem cause issue.
Mr. Chair, I can introduce a bill upstairs. You don't need to use this vote, do you? It's my bill upstairs, so.
When I'm in the voting mode, you're free to leave.
All right, I just want
me to say that I need you to stay to vote.
I know, it looks like it's gonna be unanimous anyway, so.
I love you. I would love you to stay for everything, but I understand that's not always possible.
Do that.
Don't worry about it.
Oh, feel the love.
Representative Knight.
You say you want your toenail paint.
I'm really, I want to say that I'm shocked at this story, but I'm not. It's sadly something that I've been hearing from other residents, that this situation sheds a light on our state police protocol and procedures and how they're not being followed. And I mean, this could happen to any one of us. We could be assaulted, our kids could be assaulted, and we call the cops and they do nothing. And what world is that okay? Obviously, this bill doesn't fix police protocol and procedures from being followed, but I think the testimony that we heard and the bills we've heard prior on streamlining police procedure really need our work. We really need to respect our citizens in the fact that making sure that our criminal justice system is working for us. Like, if they're not showing up when a kid gets assaulted, what's the point of them? We need police that protect us. This is outrageous. And I mean, this again, I can't stress how enough that when people say, oh, this might not happen in my town, oh, we have great police here in our city, whatever. I want to know where I go anywhere in New Hampshire that I can call the police if I am being assault, whatever have you. I want to know that they're following a police procedure. This is scary. I think everybody in this room should be very, very concerned.
Just for clarification purposes, I don't believe that the police didn't respond. I believe they were physically at the voting board. What happened was my understanding was that because the police officer that was present did not see what happened, that they claimed that they were unable to make an arrest at that time. So it's a little different. I mean, it's not like they were called and then they just said, well, we're not going to show up for that. That is a little different.
I have a question, Chair, since you're a lawyer. I don't know if you can help me with this. So let's say 10 people are eyewitnesses. They say this guy over here punched a 15-year-old in the face and the cops didn't see it. The cops they don't arrest the guy? Like, what is the usual thing that happens then?
Well, my understanding, and I'm not giving anyone legal advice, if an officer believes that there's probable cause that a crime has occurred, and that crime is above I think a class 8 misdemeanor, if it's a class 8 misdemeanor higher, then they can arrest the person. Now, they would base it on the credibility of, if 15 people tell me the same thing, I didn't see what happened, I would think it would be very difficult for that many people to organize such a elaborate lie. It's all about evaluating the situation. You have someone who's bleeding, it was clearly visible evidence that a violent altercation occurred. It was really a matter of who did what. So.
Thank you for trying to explain. I just want the record to show that this is really concerning in our state. And I've heard this, I myself, had some teenagers down my street and they were screaming and I went over to them. I'm like, what's going on here? And they said, there's somebody coming after us with a baseball bat. Okay. I called 911. This is a true story. They never showed up. I called them again. They never showed. I mean, like, I don't know what's happening. That's why I wanted to be in this committee. There is a real breakdown of communication and response to our our police. I don't know what's happening, but I think this is a really red flag for all of us, this story. And I just want to highlight it. It's very important because if the police aren't protecting us, what are they doing?
And just clarification to the public, when we say the police, this incident involved Windham. I'm not saying that Windham has a problem with how they operate. This wasn't a state police officer, from my understanding. And same thing, I just want to make sure there's a night. No, this isn't a statewide problem, not every department's fault. Representative O'Hearn, I see put your hand up. I believe at one point you have experience in law enforcement. I would have, if I could ask a question, Representative O'Hearn? If you have any,
You can ask, but I'm getting close to having to go to work, and I think we're just getting way off track here.
okay. Is that what you wish to say?
That's what I would say. I think we understand what's going on. The bill and the police matter, I think, are two different things, and we're talking about the bill, and we should just deal with it.
Representative Pantelakis, did Representative O'Hearn steal your thunder?
No, I just wanted to say that we need to address the bill whether we like it or don't like it, because we were not there. We don't know what they saw, what was done in it. You know, can't have a kangaroo court. Thank you.
Seeing no further hands raised, the matter will be put to question. The clerk will call the roll.
What the motion is?
Motion is on Teal.
Ideal. State, you know, you gotta state the motion.
The clerk will now call the roll. The motion is inexpedient to legislate. The clerk will call the roll. If you are in favor of the motion of inexpedient to legislate, please say yay. If you are opposed, please say no.
Vice Chairman Welch,
Aye.
Representative Mooney,
Yes.
Representative Hopper, Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yep.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman, Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman.
Chair votes yes.
Mr. Chairman, the vote is 19-0.
By a vote of 19 yeas and 0 nays, motion to inexpedient to legislate passed.
Consent.
Move to consent. Representative Bourdonnais, do you wish to make the majority report?
I shall.
Thank you very much. At this time, we will close the executive session on House Bill 419. We'll remain in recess until 1:30.
Why is it when some people vote, their picture doesn't show up on the screen?
No idea.
When everyone votes, their picture comes up on that screen.
This one?
Yes.
That one, you can set the Zoom to different features, and as whoever's speaking will get the big screen. I have mine set so I can just see everybody.
There's a gallery or a speaker.
Yeah.
Yes, what I'm saying is, when we're taking the vote, I'm not seeing the picture, the face of the person who's voting.
If it comforts you, I am watching to make sure.
I can see everyone on my screen as well. If you notice my little pause for a second, there was a representative who had the camera on, and I was waiting for the body to get back to where it was. But no, that can be an issue. Representative Pantelakis?
Yes, Mr. Chairman, could you tell me how many bills are left to exec?
Right now, we actually, it's just exec every bill that we could possibly exec. We are good. Which is great because we.
What about
Yes.
Thank you. What about the one that John Burke had?
That was House Bill 307. We did that today.
So you know, that was the amendment.
Yeah, I thought he was doing the, okay, sorry. I thought we had a reconsideration.
There was a reconsideration of CACR 8.
Right.
I believe we exec that on Friday, and it's all set. I don't believe there's any outstanding executive sessions.
On Friday, wasn't there, I remember that we asked that that we hold it until Monday because we didn't all have the amendment, and it was a strong amendment.
That was 307.
307, we did that. It's the one you didn't have. You did it with-
Okay. Thank you.
One thing we should do, I'm going to start the public hearing, so one thing we should do, when we send out the amendments, they all go to your legislative email. If you have a preferred email, maybe we create a preferred email to send the amendments to, if it's not your legislative email. I don't know if that would be more helpful. So Representative Gathright, I will leave it to you to maybe gather everyone's preferred email in your caucus, and I'll do the same for mine, and maybe we'll make a master email, or whatever you want to call it. We'll make one email, and we'll give that to the committee assistants to forward them to. That might be.
Okay, will do.
Printed copy. There'll still be printed copies here, but I'm just saying, it's the people, the members participating remotely aren't always receiving it, and that legislative email, I mean, gets flooded sometimes with so many emails that even if we try to look for it, it just.
I have a legal question for you.
You want to ask them for everyone?
May I?
You're guilty.
We are, what's the question?
It's in me a reference to House Bill 419 on the assaults at the campaign offices.
Yes.
A lot of times the police officers will not make an arrest because when they get into the courthouse and the judge says, were you present and saw this? They can say, no, I wasn't. And that can kill a.
That might explain why they, it sounds like they followed up on the investigation, but let's get, and because they eventually did make an arrest, so what they just let it go.
Right.
All right, let's.
I just, I had a message from Karen in regards to, we just discussed about the amendments. And she would like me to let you know that
Drugs.
she does not believe they are allowed
Massive
to
amounts
use
of
more than
drugs.
one email list, other than to send out the Zoom invite. So that's why they're all going to legislative email. They're not.
Well, the Zoom invites, I'm talking about the amendments that we have to the committee.
Right, she's saying they're not allowed to send out the two different emails.
We'll clarify that.
Yep.
All right, let's get started. At this time, we are opening the public hearing on House Bill 526 relative to the fine and the sale or possession of cannabis, and House Bill 511 will be heard simultaneously, and that is relative to the penalties of possession of certain controlled drugs. Due to the time constraints, we are going to limit testimony for each bill to members of the public to 1 minute, with the exception of the representatives that are introducing the bill, each bill. This time, the chair will recognize Representative Abramson. Introduce. Representative Abramson, you're being recognized to introduce House Bill 526.
All right, thank you, Mr. Chair, members of the committee. I'm going to try and speak as quickly as I can so that you can get through with your work. House Bill 526 is intended, the bill that wouldn't actually legalize or re-legalize sale or possession of marijuana. The intent of the bill is to reduce the fine to $1 per gram, which would be, if it were viewed as a tax, it would be paying about the same amount as what you would pay in Maine and other New England states. Unfortunately, we normally don't talk about the Senate, but being realistic, the Senate majority right now would not vote to re-legalize personal amounts of marijuana right now. So I think this is probably as far as we could go as a House in reducing the penalty or bringing the penalties in line with something that I think is more realistic. $1 per gram, of course, for a half an ounce would be a $14 fine. One of the problems we run into is someone goes to a medical marijuana dispensary and their ID card is either they're waiting for it, it's expired, it's from out of state. I know that there's another out of state medical marijuana ID card bill coming in. And you have patients who require cannabis in order to deal with any number of symptoms. Sometimes people change doctors and the doctor gives them a different same diagnosis, but a different prognosis, and they prescribe opioids or OxyContin or something that may be a little bit excessive, where medical use of marijuana may be preferable. But another problem that I encountered when going through medical marijuana statutes is if a cashier sells marijuana over the counter to someone, I believe the penalty is 6 years in prison and a felony if the person's ID card is expired or out of state. And I thought that was a little bit of, not just a little bit excessive, that's crazy. Just missing a factor detail. I thought it was pretty bizarre. I was contacted, I think the rest of us were contacted by DHHS, and they did bring this issue up that it is potentially a felony for selling this over the counter. So I'm going back and forth with Legislative Services right now to update the details of the bill. But the House last session passed a measure to re-legalize personal amounts of marijuana, and I think it passed by a margin of almost 5-1, knowing full well that it wasn't going to make it through the Senate and wasn't going to be signed into law, which is unfortunate. We do spend an enormous amount of money as a country trying to enforce marijuana laws. There are still a lot of arrests going on. We do have police coming up saying, almost every week saying we can't arrest our way out of the problem. Marijuana Policy Project has listed 10 reasons why marijuana prohibition doesn't work. But the main one is that it's contributed to a breakdown in respect for the rule of law. Every time Congress has stepped up drug prohibition since 1967, when it started under Lyndon Johnson, I think is when the national announcement was made. Every time they've stepped it up, crime has gotten worse. Drug use has tripled, death rates have skyrocketed, and prohibition, especially marijuana prohibition, gets in the way of harm reduction, which are generally efforts to minimize the harm caused by drug use. The loss of civil liberties, the 80,000 SWAT raids into people's homes every year. As a state, I believe somebody put a figure out of about $45 million a year in terms of lost revenue and money that we're spending on arrests, prosecution, and incarceration. Obviously, the environmental problems that result, the loss of control, that the sales of drugs when they're made illegal, or alcohol, or any type of prohibition, gambling prohibition, gun prohibition, alcohol prohibition. In doing research on Article 5, by the time alcohol prohibition was the only amendment passed to the Constitution through state ratifying conventions. And it's interesting, going back on the history of the debate, that they found that it was so obvious by the early 1930s that alcohol prohibition had been a complete disaster. And here we are with marijuana prohibition facing the same problem, or the same crisis. Making marijuana illegal tends to drive people away to other alcohol and other drugs. Marijuana prohibition in particular has caused more problems, more arrests, has led to disproportionate sentences for poor people and people of color. About I'm told that 88% of people serving time behind bars for drug violations or for mere possession of marijuana, and 85% are Black, Latino, or American Indian. So it disproportionately hits people of color much harder than anything else. This has been a policy that has cut across party lines for a long time, and in most of New England, at least, it's almost universal, and certainly among younger people, that it makes absolutely no sense to see people's lives being ruined for this. So the intent is not to make the policy change because of both federal law and because of the condition in the Senate. It's simply to reduce the penalty to $1 a gram, which is certainly a compromise position. The intent was that the revenue would be collected by the town, or that the dispensary would simply pay the fine to the town, allowing the town to use the money for improved funding for EMT resources, but that would be a decision to be made by the people of that particular town. I think that this bill could probably pass on the floor pretty easily as is, but I think as much as the House's position has been that we should re-legalize personal use, that just isn't the position of the Senate right now. So I think this is a compromise to try and see if the Senate will come back with something.
Representative Pantelakis, you're recognized. You have to unmute, Representative.
Thank you, Mr. Chairman.
Oh,
Thank you, Representative, for taking my question. How does a person or place that sells medical marijuana give the marijuana to people without a card?
In theory, they don't, but there's a bill coming over to deal with the same issue from your question. What happens if somebody comes in with an out-of-state medical marijuana ID card? Or what if someone has an expired ID card? Or what if someone shows up, a disproportionate number of people are disabled, and they come in, it's a very difficult trip to the dispensary, and they don't have their card with them. They would not be able to, probably would not be able to buy it. But if the cashier recognizes that person and believes that they have a medical condition, they would be risking prosecution for selling marijuana for medical use to someone who has a legitimate condition.
Second question.
Representative Pantelakis, you're recognized for a follow-up.
Yes, it was to my understanding when we made the rules for the medical center, and the people that bought and owned the businesses agreed that these laws were put in place for that reason. So I don't understand why we would want to give up that fact that cashier would go to jail for 6 years. She's supposed to be following our laws. Have you had any of them?
I lost some of your question due to signal loss, but it's a matter of.
Representative Pantelakis, do you want to clarify your question again before the witness answers?
No, it's all right. Thank you.
Representative, you still may respond to the question.
All right, I just believe that the penalty, we wouldn't do this for any other business. As far as I know, we wouldn't go to this excess, and we certainly wouldn't want to put a cashier who's selling, I don't know, tobacco, cigarettes, or even beer to somebody who has an ID that looks like a legitimate ID, but later on in court, maybe somebody on the jury says, oh, this is a fake ID, or here's an expired ID, or who knows what, or here's an ID and it doesn't quite look like the person, or somebody misuses an ID. The cashier should not be put in jeopardy of
Thank you.
jail time at all.
Thank you.
Representative True.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. The RSAs that presently say it's a felony if you are selling over the counter, and the idea, is that addressed in your bill? There's a lot of crossouts here. I haven't found that yet.
So I was the intent was, what I explained to Legislative Services was the intent was that for absolutely all purposes in the state, any sale or possession would be reduced to a $1 fine. However, I was contacted by DHHS and they said, well, this bill wouldn't have that impact. So I went back to Legislative Services. I've gotten an amendment back and we're going back and forth with them. I've taken that amendment that I just got back from Legislative Services and I emailed it to all the members of the committee. So it should be in your email inbox for this morning. So if I have to come up with another amendment to further clarify that, I'm willing to do the work.
Thank you.
You can't see me there, right?
Seeing no further hands raised, the representative is, excuse me, Representative Hopper.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. What concerns me is and has for some time, is products that are infused with tetrahydrocannabinol. They're wreaking havoc with children in Colorado and other places because it's not like marijuana. If somebody has an ounce of marijuana on the table, a child is unlikely to eat it. If a person passes out on their couch and there's a bowl full of infused gummy bears, the kid will eat them all. And the kids have gone into actually, one senator from Colorado told me a kid ended up in a coma from that. How do you propose to deal with the infused products that might end up in the hands of children if we're going to decriminalize them?
That problem can only be solved by either re-legalizing or completely decriminalizing marijuana. And that's one of the things that I'm trying to do with the bill, facing, of course, the problems we have with the Senate. When we legalized alcohol in 1933, until that, all through alcohol prohibition, people were going blind off of bathtub gin. People were, the amount of methanol that was existing in illegal alcohol prohibition was causing more problems than it was solving by far. And certainly marijuana prohibition is causing a lot of those problems. If the sale or possession is illegal already, you've already kind of crossed that line. We want to have, or the majority of members of the House want to have marijuana, the sale and distribution needed to be regulated and legal so that it's reputable businesses supplying these things, not illegal suppliers. One of my friends is Chucky Rosa of Chucky's Fight, and his eldest son died not from the marijuana that he smoked, but because it was illegal. I believe it was fentanyl was put into it, and he didn't know that there was fentanyl in it, and he died not from the marijuana, of course, but from what it was laced with. If marijuana is re-legalized, if the supply is re-legalized, then that would be much harder. It is still possible to lace tobacco or alcohol or anything else with illegal substances, but it wouldn't be done by the manufacturer and it wouldn't be done by reputable businesses. It would be done by presumably someone giving you, say, a rolled tobacco, and then people sometimes put other drugs into tobacco, but it's much less common because tobacco is legal.
Representative Testerman.
Thank you, Mr. Chairman. Thanks, Representative Abramson, for taking my question. You dodged Representative Hopper's question.
Representative Testerman, we don't speak to the intent of the members.
Gummy bears infused with marijuana, in the case that we heard testimony on, are totally legal because they're marijuana byproduct in Colorado. Those are available to purchase on the open market it's a valid question, and I want you to answer this, is if there are, somebody leaves a bowl of gummy bears out and it gets to them, what's your responsibility? I mean, total legalization makes no sense when marijuana today, rather than be 5% like it was, way back when in the 60s, can be up to 70, 80%. So I want to know, why you're trying to legalize something that is basically uncontrolled.
You're not the debate to win this either.
Kind of a hard,
Only respond to the question, not the debate part.
yeah, I'm trying not to get into debate. You could have gummy bears that are just, regular gummy bears with sugar, like the ones we got as kids. And anybody could lace those with anything right now. And when I was a kid, when we went, door to door for trick or treating, we had to throw away a lot of candy that we couldn't be sure about because of the risk of crazy people out there who would lace just existing candy. Or, for adults, alcoholic beverage sometimes get laced or spiked, or just, the punch bowl and back in high school. I'm not sure if that happened at your high school, but it certainly happened at college and high school back when I was a youngster. People do spike substances like that, but it's harder to do it if it's legal. If you have a legal product like tobacco or soda or something like that, because soda is legal, you're getting a 2-liter bottle of something, and you open it and you can see it being opened, and it's pretty hard for somebody to spike it at that point. Whereas illegal substances are just kind of very, very informal, and they just kind of get rolled manually. My preference would be that the supply of substances should all be legalized, or re-legalized, because we don't want things spiked. We don't want fentanyl put in things. We don't want illegal substances or dangerous substances put in that aren't even properly labeled.
Representative Klein Knight.
Thank you, Chair, and thank you, Representative, for taking my question and bringing forth this bill. I think we have a major lack of misunderstanding when it comes to regulating cannabis to make it safer so it's not laced with things. And would you believe that I am a medical card carrier, and this is what gummies look like? It's in medicine bottle. Would you believe that is how they package it? There's labels, there's warnings, there's not a bowl of gummies left out, and it's regulated completely. There's nothing added in.
Yes, I would believe that. I know that that really is the reason why some conservatives who don't want to legalize, don't want to legalize the use would still re-legalize the supply. In other words, the sale and possession rather than the use.
Representative Gathright, do you mind if we speak privately for a moment? Not the phone.
You want to mute this, sir?
No, I was just calling the phone. Representative Knight, I do recommend that you turn your video off, please.
Are we recessed, Mr. Chair? Are we?
No. Testimony is limited to 1 minute per person, members of the public.
All right. See no hands up. Does anyone on the committee have a question? Representative Harper? Okay. Then we thank Representative Stephenson for his testimony.
Thank you.
Representative.
No, I didn't know if the representative was done, if he had been cut off.
Oh.
Thank you. Thank you.
Erica Perez. Yes.
Hi, my name is Erica Perez. I'm with the New Hampshire Youth Movement, and I am speaking in support of both HB 526 and HB 511. Given that many states have moved to legalize and are making massive profits off of cannabis, it's unfair to financially punish other people for it, and a fine for cannabis should not exceed $100. And I believe that there should be no fine if people are caught with cannabis. So I support this bill because it minimizes the fine that they would get. And as far as HB 511 goes, 1 in 7 people are serving time in prison in New Hampshire for a drug offense. The average cost per inmate is $35,000 annually, and putting us at the top third in the country for incarceration expenditures. The state of New Hampshire has spent too many tax dollars on imprisoning people, and we should be focusing on rehabilitation and lowering fines, because fines tend to put people in a cycle of incarceration because people cannot afford their fines due to
Whatever.
1 minute.
Sorry, my video cut out. Yeah, in conclusion, I support these bills.
All right, are there any questions from the committee? See none.
Okay.
Could be killed HB 493.
I see no other people on the list. Is there any members of the public? Oh,
I do see 4 hands up now, Mr. Chair. Melissa Staples.
yes, Melissa Staples.
Good afternoon. My name is Melissa Staples. I'm the director of the State Police Forensic Laboratory, and I would like to address House Bill 511. 511 makes the first 4 convictions for possession of 4 grams or less of a Schedule 1 through 4 controlled drug a Class B misdemeanor, currently a Class B felony. Just to put this in perspective, one could have more than 100 bags of fentanyl doses and be under the 4-gram limit, or about 80 bags of heroin doses. Someone who may be charged with sale of these items based on the number of bags could argue the charges down to a misdemeanor if there's no corroborating evidence of a sale, for example. I wanted to discuss the impact on the laboratory of this bill, but due to the time limit, I'd like to jump ahead to one thing that I think the committee needs to be aware of, which is this bill is at odds with HB 615, which has already been heard by this committee, voted ought to pass with amendment and referred to the House Ways and Means Committee last week. HB 615 also amends the same section of the Controlled Drug Act, RSA 318B26, Section 2A, by replacing it with verbiage making possession of no specific weight of drug a misdemeanor for the first charge, but a Class B felony for subsequent violations. So HB 615 and this HB 511 both aim to amend the same portion of existing law in different ways. So I wanted to point that out to the committee. And if you would grant me more time, I could talk a little bit more about the impact to the laboratory of House Bill 511, but I want to be respectful of your time.
Very much. Any questions from the committee? Representative Rhodes?
Thank you. Ms. Staples, I actually didn't have a question for you specifically, but I wasn't able to hear if you were testifying in opposition or support of the bill.
I'm really testifying just from an informative view. The Department of Safety is not taking any particular stance. I can tell you from the laboratory's perspective, House Bill 511 does prevent several issues for us from a resource standpoint. it would significantly increase, for example, prosecutions in district courts. I can tell you when marijuana possession was a misdemeanor, the lab received up to almost 2,000 subpoenas a year and spent about 500 hours annually in court. That's about 12 and a half weeks of someone's full-time hours. The number of cases awaiting analysis was lengthy. Turnaround time took quite a long time. We basically were only able to test the cases we had subpoenas for each month. And that was just with one drug being a misdemeanor. Currently, with marijuana possession being a misdemeanor, a number of subpoenas and court hours has been cut by a third. Now, if we add all scheduled drugs as misdemeanor charges for the first 4 offenses, that court obligation is going to increase dramatically to meet or even surpass those previous levels. And that's a concern for us as a laboratory, because if our analysts are out at court, they're not here testing the drugs. And so that is one potential impact on the laboratory of House Bill 511 should that pass. In addition to added analyses that need to be performed for possession charges.
Other questions? Representative True has a question.
Thank you, Mr. Chair. Thank you to the witness for taking my question. Can you tell me where I would find a listing of Schedule 1 through 4 controlled drugs?
You know, I personally Googled it. The DEA certainly has that list on their website. It's not that difficult to come across if you simply Google it. Essentially, Schedule 1 are things like heroin, LSD, ecstasy. Schedule 2 includes fentanyl, Adderall, methamphetamine, and those are really our top drugs, are the methamphetamine, the fentanyl, and the heroin. Schedule 1 and 2 drugs. That's primarily what we see in the laboratory.
Other question?
Thank you, Mr. Chair. Thank you, ma'am, for taking my follow-up. And I don't know how many, I will Google that, but how many words am I going to find in those lists that I can't pronounce, like thruma, trozapam?
There may be quite a few. But as I said, as far as New Hampshire goes, and what we're seeing primarily, fentanyl's number 1, methamphetamine is number 2, and the pharmaceuticals like the Adderall, the Ritalin, those types of things are our number 3 drug. Beyond that, cocaine is further down the list, but those 3 are generally the ones that we see.
Thank you.
All right. Any other questions from the committee? Representative Mills.
Thank you, Mr. Chair, and thank you for taking my question. Not to make you go back over this again, but I'm not quite sure that I followed how the passage of this bill would increase the work of the lab. Maybe one more time slowly.
Sure, absolutely. It was rushed, as I said. Let me explain to you just quickly, but hopefully slow enough. There's essentially 3 impacts on the laboratory that I foresee should House Bill 511 pass. Number 1, currently, under current law, there's no weight limit associated with possession charges. If we received a submission of 5 bags of a white powder, for example, we can test 1, confirm heroin, and be done with our analysis. Should this legislation go through, we would now need to obtain a total weight of all of the bags and potentially perform additional analyses on at least some percentage of the packets. Over the course of the number of requests the lab receives annually, this would increase our workload substantially. More analysis means more time for analysts to interpret results. All of this impacts our ability to keep pace with the incoming submissions. Secondly, the one I spoke to earlier is the time commitment for district court appearances. Our analysts will receive numerous subpoenas every year, and we will always appear in court. It's not going to be the thing where you wait and see if we show up. We will be there. And oftentimes, once we arrive, these court cases tend to plead out. Over time, the amount of time spent by analysts going around the state to court is very impactful on our ability to perform analyses back here in the lab, if you can imagine that. And so when so many more drugs, essentially almost all of our submissions, 4 grams or less, could involve a district court appearance. And this can very much impact the laboratory's resources in terms of personnel. And also the district courts tend to want a faster turnaround time and get results because they're scheduling their cases somewhat quickly. All of those things impact the laboratory's resources. And the final point is that more analyses needing to be performed means the instruments that we have in the laboratory will be more in demand. We may face situations where our analysts are essentially waiting in line to utilize our instrumentation due to the potential increases in the analyses that we would need to perform. So the impact on the laboratory of House Bill 511, certainly there's a big resource impact, both in terms of personnel and equipment that would happen for the laboratory.
Thank you very much.
You're welcome. Thank you for the question.
You have no other hands up? And we thank the witness for his testimony.
Thank you very much.
Here calls Richard Head. Richard Head, are you there?
There we go. Thank you, Mr. Chair. My name is Richard Head. I am the Government Affairs Coordinator for the Judicial Branch, here to testify with regard to House Bill 526. This follows up on a letter I sent to the committee on the 19th. We take no position on the bill. We do ask for an amendment to the bill, however, relative to the effective date, which is upon passage. As I put in my February 19 letter, there's a statute, RSA 14:9-A, which governs the effective date of legislation, which says that each law affecting judicial practice and procedure, or establishing or eliminating criminal prohibitions, civil causes of action or remedies, or limitations of action shall take effect on the January 1 following passage. We are asking that if this bill were to go forward, that the effective date be modified and amended from upon passage to January 1, 2022, because this bill does affect criminal prohibitions and judicial practice and procedure. The reason for that, and the reason why that statute exists, I believe, is because hundreds of changes are required after each legislative session to the Uniform Charge Table, to our Odyssey database, all of which tracks fines, tracks how fine monies are distributed, who receives them, what are the criminal charges. The Uniform Charge Table is used by law enforcement throughout the state. And there are literally hundreds of changes that are required at the end of a session. They all have to be done very precisely because they drill down into sections, into paragraphs, and are used throughout the state to ensure consistent charging is conducted in court cases. So we simply take no position on the bill itself, but ask that it be amended to have an effective date of January 1, 2022, consistent with RSA 14:9-A. With that, I would be happy to answer any questions.
Are there any questions, Mr. Head? I see none. Thank you very much for your testimony.
Thank you. Thank you all very much.
Here calls Cam Kenny.
Hi there. Thank you, Mr. Chairman. Before I start, I noticed people were testifying on 511, HB 511. I'm actually the prime sponsor, so I didn't know if I should testify because people were already speaking on behalf of it or the process there.
You may just determine which one you're going to testify on, and you have 1 minute.
All right. Thank you. So I'll introduce 511. Thank you, Chairman, and my colleagues on the Criminal Justice Committee. My name is Representative Cam Kenny, representing Stratford County District 6, towns of Madbury and Durham, which includes UNH. I am here to introduce HB 511 relative to the penalties for possessions of certain controlled drugs. I worked closely with Rights and Democracy on this bill, and they will be testifying today as well. Under 2A and B in this bill, it aims to defelonize the possession of personal use amounts. In this bill, 4 ounces or less of scheduled drugs, reclassifying to misdemeanor B for the first 4 convictions for possession. After the first 4 possessions for Schedule 1 through 4, it would be a Class A felony, and Schedule 5 would continue to be Class B felony after the first 4 possessions, which doesn't change. 2C and D have to do with marijuana, nothing changes. E, nothing changes from current law. And F, I wanted to explain the amendment. I know that members of the committee got an amendment. I wanted to have that prepared just in case. At this time, as the prime sponsor, I would prefer it without the amendment and keep in F. In the end, we want to keep it because we're basing this off the language that came out of Colorado. Rohypnol was a matter of special concern because it's sometimes used to harm other people, not always personal use. So for the committee, that's why you had that amendment, why I sent it in, but I do want to keep that at this point. I know this was touched upon by a testimony, but the main difference between 615 and 511 is this bill does go further to give people who are suffering ample time to seek help, recognizing that this is a public health issue. So this is needed because between 1980 and 2016, the state's prison population increased in size nearly 9-fold, and admission to the New Hampshire prison increased by 24%. According to the ACLU, 1 in 7 people serving time in prison in New Hampshire are in for drug offenses. The average cost per inmate in New Hampshire is nearly $35,000 annually, putting us in the top third in the country for incarceration expenditures. And yet a felony conviction for a drug possession offense has never decreased drug use. It's only created constant barriers to future success and paths to recovery. I think we need to shift as a society on how we treat addiction, stop treating it criminally so individuals can get the help they can get. And this bill is a great start. So to conclude, I can send in my written testimony if that's helpful. Rights and Democracy and several experts, some who have already spoke, some who will, should be testifying. So please feel free to direct your questions where you see fit. Thank you so much, Mr. Chairman and members of the committee.
Representative True.
Thank you, Mr. Chair, and I thank the witness for taking my question. I'm referring to section F in the bill.
Yes.
What is that drug?
I believe it's a roofie, in other words. The layman's terms, Rohypnol.
Thank you.
You're welcome.
Representative, I want to thank you for your testimony. The chair would like to require just a question, and if you did answer this in your testimony, I'll apologize. I was not here for the beginning, and it's good to hear from the representative.
Good to see you.
On page 1, section A, lines 8 through 18, it says in case of possession of 4 grams or less, is that referring to all classes of controlled substances?
Can you say that last part one more time, Chairman?
Is that section that, and I would say the bottom part of section A, which is in case of 4 grams or less, the person shall be guilty of a Class B misdemeanor. Is that section referring to all classes or all classified schedules of controlled substances?
I believe that one is, just one moment, Mr. Chairman. I believe that one's Schedule 1 through 4, and 2B is Schedule 5.
Thank you. Seeing no further hands raised, the witness is excused.
Thank you so much, Mr. Chairman. Good to see you as well.
Just let you call.
Okay, go down there.
All right.
Good afternoon.
Good afternoon.
Yeah, I'm a little confused about the way we're taking testimony. Is this for both 511?
Both 511 and 526.
Okay. Well,
Let's do it, get to 1 minute. If you do wish to speak on both, there'll be some flexibility at the discretion of the chair.
Yes, I would like to speak on both. So yeah, good afternoon, the Criminal Justice and Safety Committee members. My name is Asma Al-Huni, and I'm the Movement Politics Director for Rights and Democracy in New Hampshire. It is a grassroots organization that organizes around human rights issues. And today I'll be testifying using expertise testimony from our National Harm Reduction Coalition Associate Director, Mike Selak, who is personalizing this to New Hampshire specifically. It says, I am voicing our strong support of HB 511. For many years now, the statement, we cannot arrest our way out of our drug problem, has been used time and time again, but progress towards shifting from a punitive approach to drugs to a health-based one is direly needed. HB 511 is a step in the right direction by lessening the criminal legal consequences people who use drugs face because of their drug use. This bill would have important and significant impacts on the costs of incarceration. In New Hampshire, it spends $35,000 annually in incarcerating human beings. Incarcerating people who use drugs for the drug use does not have any positive impacts on their health or their drug use. The result is wasting taxpayer dollars, a significantly higher chance of overdose death once someone is released, and a criminal record that creates barriers to housing, employment, and other opportunities that could actually help people change their lives. Imagine what a difference it would make if we reinvest that money in evidence-based interventions such as harm reduction programs, overdose protection programs, and medications for opioid use disorder, such as buprenorphine and methadone. These are the gold standard treatments for opioid use disorder and cost significantly less per year than incarcerating someone would. New Hampshire is currently dealing with a crisis of overdose deaths. Overdose has been the leading cause of accidental deaths in New Hampshire for many years. The New Hampshire overdose rate is 33.1 per 1,000 in 2018, significantly higher than the national overdose death rate of 20.7.
Thank you for your testimony. Due to time constraints, we do have to limit testimony. We did allow you to speak for 2 minutes, but we do have to conclude due to time constraints. And your time's expired. Seeing no hands raised, the witness is excused. The chair now recognizes Jason Snook. I'll remind the witness that the testimony is limited to 1 minute.
Yes, thank you, Mr. Chairman. How long do I have to testify?
Your testimony is limited to 1 minute. However, if you need to speak.
Yes, thank you, Mr. Chairman. So I am a licensed clinical social worker and master's level drug and alcohol counselor in the state of New Hampshire. I am a board member of the New Hampshire Providers Association and also a member of Rights and Democracy. So working in the therapeutic fields, my colleagues and I have time and again found the hindrance of therapeutic process as most of the time is being spent dealing with punitive repercussions of felonies from our clients that we have been working with. And also, time and again, countless research has shown that punishment of simple possession charges of drugs is just absolutely zero deterrent for individuals to stop using or not carry drugs. And we have found that there is absolutely zero rehabilitation happening within these correctional facilities. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Chair now recognizes Jody Noel.
Hi, thank you for allowing me to be here. My name is Jody, and I will be speaking to the personal impact of the criminalization of drugs. 13 years ago, my fiance, the father of my 2 boys, overdosed just 10 feet away from our oldest and I on the other side of a closed door. Corey had been through detox and rehab. He was doing what he could to stay sober. In fact, it became his full-time priority, having lost his job, our sole income, as the result of an arrest for possession of heroin. He faced a mandatory minimum prison sentence based on the quantity, and we all, as a family, faced the threat of the head of our household's absence. I believe that, unfortunately, this threat was not only unhelpful in dealing with his addiction, it exacerbated his struggle and contributed to his relapse and overdose. The research is clear. Those dealing with substance use disorder need compassionate care. They need support from their community, not isolation from it. Drug use and addiction aren't enemies to be defeated by force, but complex societal and medical problems. Punitive measures have only worsened the social problems causing addiction and overdose, and their implementation has hurt countless people, not just those whose lives have been lost, but those who have been left behind, like my sons and I. HB 511 would allow us to redirect funds toward proven treatment opportunities so people can recover and stay well. The benefits of doing so would be widespread and long-lasting. It would allow people to recover and find work, successfully reintegrate into society, support themselves and their families, remain grounded in their communities, and build a future. My story, Corey's story, is in the past, and there's nothing we can do to change that. But I beg you, as a mother, not to persist in this failed approach, because the next generation is at stake. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair now recognizes Aline Eagleton.
Hi, my name is Aileen Eagleton, and I'm a resident of Hanover, New Hampshire, and I'm a researcher at Dartmouth College. And I study neurotransmitters that are implicated in depression and substance misuse disorder. And 1 in 4 adults who do have a mental illness also suffer from substance misuse disorders. So these illnesses are commonly co-occurring. So it's important to have this bill pass because it helps destigmatize substance misuse by decreasing the penalty from a felony to a misdemeanor. And people who do experience stigma in regards to their drug use are less likely to seek treatment. And this results in economic, social, and medical costs. So I'd like to voice my support in the bill HB 511. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Chair now recognizes Dr. Joe Hannon.
Good afternoon, members of the committee. Thank you for listening to us today. My name is Joe Hannon, former state rep, retired doctor, and been very active in the recovery and harm reduction community in New Hampshire for the past several years. I'm also a person in long-term recovery for over 29 years myself. I can tell you that having this bill pass in this form would be a big step forward. It'd be better if it was a little bit further along, but I think that this is a very good start. We can't keep criminalizing people and for felony offenses for possession amounts. It's counterproductive. There's no evidence that proves that it's actually helpful whatsoever. There are many countries around the world that have death penalties for possession, and they still have drug use in those countries. Someone can't get a college loan, they can't get housing, they can't get a job because of a felony conviction. We see someone who's in trouble because of substance use, and we'll say, why don't they get a job? Why don't they go back to school? Why don't they do these things? They can't. Once you have a felony conviction, you can't do many of those things. So I think this is something that's absolutely necessary. The time is long past for doing this, and I implore you to please pass this bill. Thank you.
Representative True.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. The bill states that 4 grams doesn't show an intent to sell. Could you give me an idea of how much 4 grams of like fentanyl or LSD would be? What's the mass of that? How much is it?
4 grams. I'm not sure I understand the question. Mass is, that is, if you're asking how much mass is that, it's 4 grams. So you're asking, what does it look like? How many doses is it? I'm not really sure I understand.
Chairman.
You recognize for a follow-up?
Yes, I'm looking for how many doses are in 4 grams of fentanyl?
Good question. I'm not exactly sure, but I can look it up. I don't know. You want me to look it up right now?
Follow-up?
Thank you, I'm sorry.
The witness does not have to look any up to any.
The only reason I'm asking is because I don't know what I'm dealing with in this bill. And so if 4 grams says it does not show intent to sell, and 4 grams of LSD will get the whole nation high, then maybe it does, maybe it is an intent to sell. And I don't know what we're talking about when it says how many doses. That's why I'm asking.
Fentanyl is usually measured in micrograms. I can say that. You know, maybe if you want to, if this was such a big concern, you know, you can actually have someone look into what specific doses are gotten from a certain gram amount. But, you know, fentanyl is usually in milligrams or micrograms. Sorry.
Thank you.
It's a lot smaller amount. 4 grams. If you want to just real general, it is a pretty good amount of fentanyl, to say the least.
100%. So just to put that in perspective. Sorry to interrupt the witness.
It's okay. What was the question now? I'm sorry.
No, I'm all set, thank you.
Okay.
Representative Testerman.
Never mind. Let me just show you something.
Okay.
I'll show you.
Withdrawn. Seeing no further hands raised, I want to thank you for your testimony. The witness is excused.
Thank you. Have a good day.
The chairman recognizes Ryan Fowler.
Great. Thank you, Mr. Chair, and thank you, committee, for hearing me today. My name is Ryan Fowler, and I'm a person in long-term recovery. I'm also a certified recovery support worker. And before I get my minute, did you all receive the letter I sent this morning? That kind of has most of my thoughts in it. There was a letter I sent this morning with most of these thoughts. If you did not get it, I'd love to get that to you. I'm here as a member of the public, person in recovery. I have worked for various versions of the safe stations. I helped to roll out the doorways. I've worked for the addiction crisis line RAPS. I trained substance use professionals. And I was kind of one of the people who were saying that this bill would be a really good idea. It would simplify the scheduling apparatus for simple possession and make law enforcement's job easier, like we've seen in other states. The idea is that the scheduling apparatus that you all keep going back and forth with is always subjective. It's not founded in science. It's oftentimes founded in targeting certain populations. The current scheduling apparatus at the federal level makes no sense, and it oftentimes translates to the subjective dispensing of punishment. And I'm somebody who benefited from that. I'm a straight white middle-class male from New Hampshire. I've been arrested with felony drugs 5 or 6 times, and I'm not a felon. And because I'm not a felon, I was able to excel in recovery. In the past 6 years, I've developed professionally, and I've engaged in research, both personally and with Dartmouth. I've done a lot of really cool things using my negative experience for good. And I see all too often people whose felony conviction follows them forever, keeping them from housing, employment, education. And it's really contrary to what we know about substance use disorders, because we define these disorders as continuing to use despite negative consequences. So the first offense for a small amount of drugs should not be a lifetime of a scarlet letter F that follows them forever. When is time served? I could answer questions you had about the personal use amounts. My 10 years of chaotic drug use included selling. I was in distribution. And because of my research, I've had some interesting views of like what's going on now with the current situation. And moral of the story is prohibition does not work. Punishing people is not the answer to this. And we're really talking about punishing people and who goes to jail and who does not. Really, it's about compassion and human dignity and treating this like a health issue, not a criminal issue. This would support law enforcement, and it's really time to change what we've been doing. We have 100 years of prohibition. We know prohibition does not work. And if you, I've sent in a letter, you can read the rest. I think my minute's up. Happy to answer questions. Thanks for hearing me.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair will now recognize Tristan McLean.
Hello. My name is Tristan McLean. I am going to speak really briefly on behalf of Kylie Murardi. She is not able to be here today as she is in the hospital. However, she really expressed her testimony to be heard, and I echo that sentiment. Dear Chairman Bradley and members of the committee, I, Kylie Murardi, wish to register my support for House Bill 511, reduce criminal penalties for simple possession of all controlled drugs under 4 grams from a felony to a misdemeanor offense. I have been a New Hampshire resident for most of my life. I am writing this to you as a proud woman in recovery from long-term intravenous drug use. However, I cannot thank my home state for any of the outstanding changes I have made in my life. To be honest, New Hampshire has failed me, and it continues to fail its sick and suffering. Let me ask you, would you incarcerate someone with schizoaffective disorder for having auditory hallucinations? Why do we demonize human beings suffering from substance use disorder? I personally have been incarcerated for reasons due to my plight with substance use disorder. It has only made it harder for me to find recovery. Our prison systems are flawed. I received no help for my substance use disorder while I was within jail. I was only beat down and made to feel unworthy of a happy life. I signed up for every AA meeting, and none of them ever showed. I searched the bookshelf for anything that could help me, and all I found was one torn up AA book. I listened to women cry themselves to sleep every night because they just couldn't understand why they couldn't stop using. They swore that they would never pick up again, and then they were released out onto the street with no resources to allow them to help themselves. There was nobody there telling them that they are worthy or capable. I am one of those women. We cannot stop using because substance use disorder is a health use issue and not a criminal issue. The very definition of insanity is doing the same thing over and over again and expecting a different result. Why do we allow this insanity to continue? Why is change so scary when it's proven to save lives? We need to institutionalize women for being outspoken and opinionated. You cannot tell me that there is no room for growth within our system. There will always be a need for growth and understanding because our society is ever evolving. Are you going to be the ones to make a change? Are you willing to help an entire younger generation get their parents back? Or will you continue to show them that their parents' lives are not important because they are afflicted with an invisible disease? Let us be the change. Thank you for your consideration. Sincerely, Kylie Murardi. I also echo the sentiment of support for House Bill 511.
Any questions from the committee? Seeing none, we thank you very much for your testimony.
Thank you.
What do we have left? Are there any others that you can see?
I do not see anyone with their hand up at this time, Mr. Chair. Actually, we just had one person pop their hand up, Nikki Fordley. I will, and actually we now have 3 hands up. I'll put Miss Fordley on.
Hello, can you hear me okay?
Yes.
Okay, thank you. My name is Nikki Fordy. I am a licensed clinical social worker and master's licensed alcohol and drug counselor in New Hampshire. I work mostly in Manchester. I'm testifying in support of HB 511 today. I helped put some of it together and did a lot of the research behind it. I wanted to answer some of the questions that came up in terms of, why 4 grams? How much is 4 grams? What are we talking about? It depends, obviously on the substance, but it also depends on what the tolerance of the person is. I currently work with people being released from federal incarceration. I have seen what a felony conviction does to someone, and re-entry is very, very difficult in this state. There are very few resources available. My hands are often tied. But in working with people who use drugs, who have used drugs for many years, in fentanyl, when they tell me about what was at the height of their use, how much were they using, I have multiple people who are using up to 10 grams a day. So it really has to do with someone's tolerance, and what an amount is going to do to one person is not the same that it's going to do to another person. So we chose 4 grams because we wanted to specify an amount. It is not perfect. There's never going to be a perfect designation, a perfect line, but we wanted to create a line because as it is now, where there is no amount specified, you could have the smallest amount of a controlled substance and you're automatically a felon in this state. That is wrong. And I strongly believe in this bill that it will be able to help many people reintegrate into society much easier. And as far as treatment while incarcerated versus treatment in the community works. Treatment while incarcerated is very difficult, especially in times of the coronavirus. There's almost nothing going on.
Thank you for your testimony. We do have time to limit testimony. However, you are permitted to answer questions by members. Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question to the witness. I realize that there's a difference in substance abuse problems with alcohol and with drugs. And I know they're both difficult, but the one with drugs is probably much more difficult. Could you make some comments on the number of 4 prior offenses? Is that not enough, too many, and what your opinion is of that concerning a successful recovery for someone?
Sure. I don't know if I would agree with your statement about the difference with alcohol and substances and drugs. I think we often make a distinction between the two because alcohol has been legal for most of our lives. I have seen people's lives completely destroyed by alcohol and alcohol alone. In terms of the 4 offenses, as I think Ryan Fowler mentioned, we did model this on some legislation that had come out of Colorado. Again, recognizing we wanted it to not be unlimited. But the definition of substance use disorder is continuing to use despite negative consequences. And we didn't feel that a first time, just a one-time deal, a one-time shot made sense, that there can be multiple situations, particularly if people are in the same social groups or in the same parts of New Hampshire. The way that policing works, there are certain parts of certain cities that get people get picked up more often. So we wanted to create a line in terms of it not being unlimited. And we felt that we needed to have at least a few chances where someone would have a misdemeanor and maybe the first one is not enough of the wake up call. Maybe it's not enough to get them to think about having something different for their life. But to have a couple chances and interactions with the law and what that can make that possible, the idea is to rehabilitate people and increase their life functioning, and branding them a felon does not help that.
Thank you for your answer.
Representative Hopper.
Thank you, Mr. Chair, and thank you for taking my question. I concede the point about not making anybody a felon. But would you believe that somebody who shoots fentanyl into their arm has completely lost control of their ability to decide, and maybe they should be incarcerated for at least 6 months to give them a possible chance of breaking the bondage that they're in?
I would not say necessarily if someone is using fentanyl intravenously that they have lost all control. That is it's very different. I have, through different things I'm involved with, and I did work for 2 years at a methadone clinic in Massachusetts and New Hampshire. So I have interacted with many people who have used drugs recently or currently use drugs. There are some people that you would never know. If they didn't show you their arms, you would never know. I think our conception of what an intravenous drug user looks like or sounds like can be very deceptive, and there's a lot of stereotypes out there. In terms of, would a few months, 6 months in jail help someone find recovery or turn their life around? There are definitely, cases that I've been doing this type of work for about 8 years. So I have counseled thousands of people at this point. Are there specific couple anecdotal cases I could tell you about where a jail sentence did help? Sure, but it's not, I don't think it is helpful for everybody. I have heard far more cases of people experiencing terrible withdrawal that has not been medicated in jail. Also, we need to remember that jails and prisons are not drug-free spaces. The majority of people that I am counseling now in my position, people getting out of incarceration, many of them use drugs in jail. I have had people start drugs in jail and prison to cope with the reality of being incarcerated. So I don't think while I wish it were that simple, I wish that we could lock someone up and okay, fine, that would work. But in reality, that's not how it plays out. And if anything, the trauma that people experience while incarcerated can complicate their drug use and actually prolong it.
Thank you.
Seeing no further hands raised, the witness is excused. I want to thank you for your testimony.
Thank you.
Here are the top search results.
Chair now recognizes the Bedford, New Hampshire Police. Please identify your full name for the record. You're recognized. Having technical difficulties. The chair now recognizes Anthony Harris.
Hello, thank you, Chairman.
You guys.
My name is Anthony Harris. Pronouns he, his, and him. I'm the co-founder of Felon to Freeman. I'm testifying in support of House Bill 511. I don't see any reasons that an addict should be arrested and incarcerated due to their addiction. I don't think that incarceration ever helps an addict on the road to recovery. I just think it takes away the options that they have on that road, and I want to testify to the 4 grams. An addict is more susceptible to be walking around with 4 grams from the time wherever they got the drugs from on going to where they're going to use this drug. And in that time, they have to escape the law, and I don't think it's right to continuously incarcerate our addicts who actually just need help and on that road to recovery. The ones that are dealing the drugs aren't the ones that's walking around the streets with up to 4 grams. Those are the ones that need to be incarcerated, and not the ones that's actually suffering from this addiction.
Mr. Harris, we do have to limit a testimony. I believe the time has expired, but I want to thank you for your testimony.
All right, thank you, Mr. Chairman. Have a beautiful day. God bless you.
God bless you as well, sir. The chair now recognizes Candace Bouchard. And Representative Muse, before the witness begins their testimony, we managed to have 2 witnesses at once. If you don't mind seeing if the Bedford police are they still okay? We'll finish with Ms. Bouchard, and then we'll call the Bedford, New Hampshire police staff.
Yeah, they are there and they have their hand raised.
Ms. Bouchard?
There we go.
All right, we'll move on to the next witness. We'll call the Bedford, New Hampshire Police.
Yes, good afternoon, Chairman. Thank you for hearing our testimony, and thank you for hearing the New Hampshire Chiefs of Police. And the chiefs in the state of New Hampshire are opposed to both 511 and HB 526. I'll be speaking primarily to HB 511 today. I have more than 42 years of continuous law enforcement experience. 27 of those are spent dealing directly with substance abuse. By passing this bill, the chiefs believe that making possession of 4 grams or less of a Class B misdemeanor, you're effectively making the possession of enough of a certain controlled drug sufficient to kill 100 or more people a Class B misdemeanor. Each street bag contains enough fentanyl to kill a person. The consequence of this bill, when we are still within the grip of an insidious killer, fentanyl, which has killed more than 3,000 people in our state, with another killer following close behind, methamphetamine, is potentially devastating. We as a society must be clear to all those who seek to abuse and sell drugs that kill that society does not condone this behavior. There must be consequences to possessing killer drugs. You've probably read the tragic story out of Londonderry where an infant died because the parents and another person allegedly were in possession of killer drugs that resulted in the infant's tragic deaths. In my 40 years, I've spoken to hundreds of drug users and drug sellers, and most of those who survived that I spoke with told me that being arrested gave them another chance at a change, an opportunity to be drug-free long enough to reconsider. Parents have begged us to have their children arrested so they'll be in jail away from drugs that can kill them. Reducing penalties used against traffickers is just not the common sense approach to dealing with criminals whose only purpose is to make money by selling poison that destroys lives, families, and harms our economy and the future. If you really want to make a change, kill this bill and reinvest in evidence-based drug treatment programs for those in jail that really work. Give them a chance and don't take their few chances of survival away. Thank you for hearing our testimony.
I want to thank you for your testimony. If you don't mind, the chair would just like to inquire of 2 questions. Just for the knowledge of the committee, there's different schedules of controlled drugs. Can you just describe just a few drugs that would fall in the schedule 1, 2, 3, or 4?
Sure. Schedule 1 are those controlled substances that have no medical value or use and are highly addictive. So those are drugs such as heroin and other types of drugs that have no medical usefulness and are declared by DEA to be highly addictive and dangerous and should be placed in Schedule 1. Schedule 2 drugs like fentanyl, of course, there is a pharmaceutical and medicinal use for fentanyl that anesthesiologists use. So as an example, fentanyl is placed in Schedule 2, along with cocaine and derivatives like lidocaine, things that dentists use when you go to the dentist. Those are placed in Schedule 2, but Schedule 2 drugs are also deemed to have a greater risk of addiction and diversion and misuse. Schedule 3 drugs are those drugs that have medicinal value and that have a lower risk and potential for addiction. And Schedule 4 drugs are generally those medicinal drugs that have no risk for addiction or misuse. Hopefully that clears it up for you.
Thank you. Representative Muse.
Yes, thank you for taking my question. I'm just curious whether HB 511 would in any way affect your ability to arrest people who are selling drugs versus simply possessing them. So does it do anything that makes it harder for you to enforce the law against people who are actually selling drugs?
Well, yes, and thank you for your question. Absolutely, Representative. 4 grams of heroin and fentanyl are equivalent to 100 street bags. And oftentimes we encounter dealers that are selling 4, 5, 10, 15, 20 bags. I can tell you that when various laws change regarding the possession of quantities that reduces the penalty for a threshold quantity, what traffickers typically do is reduce just below that threshold, so that if they are caught, then they simply will face the lesser penalty. In this case, a Class B misdemeanor, for which in our state, virtually no one goes to jail and pays a small monetary fine. So 4 grams is an enormous amount when we're talking about heroin, fentanyl, methamphetamine, and some other drugs that kill people.
Thank you.
Representative True?
Thank you, Mr. Chair, and thank you, Officer, for taking my question. I think you're helping me get a handle on what the doses are. So 4 grams of heroin, I believe you said would be 100 street bags. I'm assuming that a street bag is 1 dose. So how many doses would a normal person use in a day?
Well, again, I think that you heard previous testimony that people develop a tolerance, a physiological tolerance to certain drugs, so that it requires over time greater use, right? So a bag of heroin typically runs around 1/4 gram, 1/10 of a gram, and it all depends on the strength of that drug that determines whether or not that person uses an entire bag a day. But oftentimes over time, an individual who is using a drug that they develop a physiological tolerance to, such as heroin, has to increase the amount of drugs that they use. So they may increase to several bags a day to be able to avoid being what we call drug sick or going into some withdrawal syndrome. So 100 bags is an enormous amount. Street sellers in Manchester, Nashua, and other places of the country typically sell 10, 20, 30, 40 bags or less. A 100 bag dealer is a significant dealer.
Thank you.
Representative Conley?
Thank you, Mr. Chairman, and thank you, sir, for taking the question. Am I right, this discussion around trafficking, I think that's sort of separate from the intent of the bill, but am I right that current statute offers a lot of discretion to prosecutors around weighing circumstances of a case to determine what to charge someone with? So it sounds like this bill is more about possession, and we've gotten off on a discussion of trafficking. So am I right in that there are ways to discern between trafficking and possession for personal use?
Well, yes, there is. And you're right that prosecutors and the judiciary take into account that information. And I think this bill is attempting to fix a problem by creating a problem. And that goes directly to what your question is. And thanks for your question. I think that what this bill would do is effectively eliminate an opportunity for law enforcement to deal with drug traffickers. Drug users, as you rightly know, in many cases throughout the state and many counties, go to drug court because they are typically in possession of personal use quantities of drugs, and so they are diverted into drug court system. The people that I talk with over the course of my 40 years of police work tell me time and time again, yes, there are drugs in jail. Sure, there's drugs in jail. But oftentimes when they're in jail, it gives them time to reflect, time to think about, and gives them another chance to consider where their life's trajectory is going. Where we fail is making sure that we provide those folks who do end up in jail, because oftentimes drug users don't end up in jail. They end up in jail after failing drug court 2 or 3 times, and then they end up in jail. Let's make sure that when they do go to jail and they're a substance abuser, no matter what the substance is, that they're given an evidence-based treatment program. That's where we need to be.
Thank you.
Representative Newman?
Thank you, Mr. Chair, and thank you to the witness for taking my question. We've had some discussions and we talk about going to jail. And I know that felonies mean that you go to prison What's your experience for people that are first offenders and they get the benefit of whatever the judicial system does for them, that people actually go to county jails and are able to be successfully rehabilitated there?
Thank you for your question. And in my experience, again, when we're talking about personal use quantities of drugs that are not to the level that we're talking about in this bill in 511, those folks, again, are diverted into drug court. They're oftentimes prosecutors know that these folks who are involved in shoplifting, let's say, that we see in property crime, that end up in domestic violence cases that have an underlying substance abuse problem. We work very hard in law enforcement to get those people into the types of programs that they need. But the leverage is that if they don't complete or they don't put their shoulder to the grindstone with respect to a treatment program, that the government has leverage to exert control so that the individual is forced into, and hopefully forced into, an evidence-based treatment program.
Follow up, Mr. Chairman?
Representative Newman, you recognized for a follow-up?
Yes, sir. So that, would they still have leverage if in fact that the penalty was one that would not put them in state prison?
No, because there's no incentive. There is no incentive for someone who's facing a Class B misdemeanor to follow the law, because oftentimes we see that they don't, because they know that effectively a Class B misdemeanor results in no jail time and usually maybe in a low financial fine. So in order to make sure that people do what the government wants, society, not government, society wants them to do, which is get better and treat the problem. In often cases, we need that leverage to make sure that the individual follows through.
Thank you.
Thank you.
Seeing no further hands raised, the witness is excused. I want to thank you for your testimony.
Thank you.
If there are any members of the public who have not testified already that wish to speak, please raise your hand. Leo Beletsky, I got that right?
Yes, Beletsky. Thank you so much for giving me an opportunity to speak. My name is Leo Beletsky. I'm on faculty of the Law School and School of Health Sciences at Northeastern University, just south of New Hampshire in Boston. And I just wanted to say a few words about my research focuses on the overdose crisis and the legal and policy measures to address it. And we've done a lot of research on laws such as this. We broadly term them drug-induced homicide laws or drug delivery resulting in death laws throughout the United States. These laws have been proliferating in response to the overdose crisis for many of the reasons that folks have flagged. And we've evaluated their impact from a public health perspective. So obviously there's different reasons to pass laws like this, such as victims' rights rationale and kind of retribution rationale. But from a public health perspective, we've looked at the impact of these laws and found that generally as a public health measure, they're not effective in addressing overdose. So even just looking at the numbers, states that have passed similar laws do not see overdose decrease. They actually see typically increases in overdose on the amount of about 7 to 10%. And the mechanisms for this, we can only posit that some of the ways in which laws such as this may increase overdose is the following. So one of the ways in which they may be counterproductive is.
Your testimony is limited to 1 minute, and we've almost reached 2 minutes, so I do have to suspend the testimony. However, the witness will be permitted to answer questions. Representative Hopper.
Thank you, Mr. Chairman. Thank you for taking my question. How can they be, the last statement was, how can they be counterproductive?
So yeah, I apologize that I wasn't aware of the time limit, but they're counterproductive in several ways. One, we know that many of the overdoses that are witnessed, help is not summoned and the person ends up dying. One of the reasons why, the top reason based on surveys why people don't summon help is because of legal repercussions. And when a law such as this is passed, the public awareness that a lot of that gets sort of affected in terms of public media outreach and prosecutors talking about these laws is people get those legal concerns get aggravated and people are not motivated to seek help during an overdose event. So that's one of the ways. I can keep going. I don't know how much time I have, but.
Newman, you were recognized for a question.
Thank you, Mr. Chairman. Your last comment, it seems like most of your research had to do with preventing overdoses. And has your research addressed the question of people that, referencing that towards trying to provide successful recovery opportunities to people?
Representative, I think that's a really important question. As was mentioned, I think it was the witness who had talked about the importance of giving folks access to evidence-based drug treatment. And we know that unfortunately in New Hampshire, as in many other places, such treatment is typically not available for people who are incarcerated. So to the extent that people get incarcerated based on these laws as well as others for drug dealing, a lot of those folks are actually using and have addiction issues. And what happens is they go into the criminal justice system, they do not receive treatment, and when they are released, they overdose and die at really high rates. So we know that the rate of overdose among people who had been incarcerated is about 120 to 130 times the background rate in the first 6 weeks after incarceration.
Thank you for your answer.
Thank you.
Seeing no hands raised, the witness is excused. Oh, excuse me, Representative Bourdain.
Thank you, Mr. Chairman. Thank you for taking my question. As we heard earlier, having the penalty of a felony over their heads are one of the reasons that people go to drug court. And I think New Hampshire's drug court has a fairly successful ratio. So if we got rid of the felony penalty, do you think that we would still have that kind of success?
Representative, I think this is a really important question. I think that it is absolutely critical to have a drug court system that provides access to evidence-based scientific treatment, and New Hampshire has made great strides in that direction. I think, though, it's also really critical to have access to such treatment on demand in the community. In other words, in addition to improving the way in which the criminal legal system deals with people with addiction, we need to have other opportunities for people to access treatment that is free and on demand and as low barrier as possible. In my view, forcing people into treatment, and this is not actually my view, this is based on scientific research, there's a concept called intrinsic motivation, which is that a person needs to want to get help, and that's when treatment works best. And so providing opportunities for people to access treatment when they're ready and willing to do so is the best chance that we have for people to find recovery, whereas to do so through coercion is not as effective, and sometimes the failure rate is much higher in those circumstances. So to your question, I don't think that sort of increasing the penalties that hang over people's heads is the way to go. I think the way to go is to invest in a variety of pathways, as many as possible, to get folks help when they need it.
Representative Bornay, recognized for a follow-up.
Thank you, Jim. Thank you for taking my question. You may not realize, we just passed a bill 615, which really allows the first offense for simple possession of any drug to be a misdemeanor. But further convictions become felonies. So if we use the first offense as an incentive to have people seek treatment, but they fail to, and the second time they are faced with a felony, then we are basically forcing them into a drug court situation. Now,
Your question?
that's the both worlds.
I mean, I'm a big believer. Thank you for the question. I'm a big believer in just all possible doorways, as many different paths as possible for people to get assistance and support. I don't want to comment on the sort of the priorities of the legislature and I have not read the bill that you cited. I apologize. I think that making treatment available through the drug court system is a really important priority, and I certainly support doing so for felony charges as well as misdemeanor charges. I will cite some research from that came out last year from Philadelphia, where they looked at treatment court outcomes. So what they did is they essentially did a retrospective review of everyone who had overdosed in Philadelphia for the year, I think it was 2017. And they assessed whether or not, where were the touch points? Where did we miss an opportunity for that person who had overdosed? And they found that about 80% of the folks who had overdosed had a contact with the criminal legal system at some point over the last 18 months. So there's a lot of missed opportunity. And in Philadelphia, their treatment court had narrow eligibility requirements that did not allow folks who were repeat offenders or had a violent offense or other kinds of considerations. They'd eliminated eligibility for those people. And so it sounds like what New Hampshire is doing is it is using those eligibility criteria widely and not kind of eliminating the opportunity for people with more serious offenses to get access to treatment. And I think that's a really important lesson that we have to learn, is that, it's not just the low level and sort of first time offenses. In fact, many people who have serious addiction issues have a really serious record. And that doesn't mean that they can't find recovery. It just means that we need to expand our thinking as far as who is eligible, who can benefit from these kinds of resources.
Thank you.
Seeing no additional hands raised, the witness is excused. I want to thank you for your testimony.
Thank you.
Members of the public, if you have not spoken already and your hand is not up, please raise your hand now if you wish to speak. Seeing no hands raised, we will now close the public hearing on House Bill 511 and 526. At this time, we are opening the public hearing on House Bill 603 relative to manslaughter and the use of deadly force in circumstances involving the sale or use of a controlled drug or controlled drug analog. In House Bill 238, prohibiting sorry, I wrote over my own stuff here. Based on a victim's actual or perceived gender identity, gender expression, or sexual orientation for being used as defense of manslaughter. Representative Muse, you want to do the honors for the prior hearing?
Yeah, why don't I'll do that. So for HB 526, there were 72 people who signed in support and 6 people who signed in opposition. For HB 511, there were 197 people who signed in support of the bill and 5 who signed in opposition.
Representative Marson, to answer your question, we've now opened the public hearing on House Bill 603 and House Bill 238. Yes. And to the members of the public, testimony will be limited to 1 minute. The exception will be for the representative who introduces each of the bills. Okay. Representative Vincent. Representative Vincent.
Chairman, I saw him on the attendance list. I know he's aware of. I believe he's a attending meeting now. Seems to be elevated.
Representative Vincent, you're recognized to introduce House Bill 603.
Thank you, Mr. Chairman. Can you hear me?
Yes, we can.
Thank you, Mr. Chairman, and thank you, honorable members of the Criminal Justice Committee. For the record, my name is Kenneth Vincent, and I am a state representative, and I serve District 17, which is Dover's Ward 5 and 6, and Somersworth's Ward 2. I'm here today before you as the prime sponsor of House Bill 603. This is a bill that is going to enhance the self-defense statute 627(4). You're going to hear testimony. You're going to hear testimony from one of my constituents, Art Williams, who is a retired detective with more than 20 years of service from the Somersworth Police Department, who is currently a private investigator representing Donna Barrett, a mother who lost her son back in 2017 in a drug deal where he was killed. Donna Barrett is also here today to testify. So basically, in short, I want to add, I'm trying to add to the law so drug dealers are not protected. And here's an example. So if I went to a drug dealer's house to buy drugs and something went down and I was killed at that person's house, then they could actually go off scot-free from the current law. And what I'm trying to do is I'm trying to make them accountable for their actions here. And I think that I would love if I could turn it over to Donna Barrett, the mother of the son that was lost. And Mr. Chairman, we are all here in the same room using the same computer. I would beg you if you could please allow Donna to talk and then Art Williams. It would definitely make the line and the pattern here very clearable, if that's possible.
We can accommodate that, Representative Vincent. The only thing I ask is that for each member, for each witness that is with you, to have them state their full name for the record and just whether they're in support, in opposition of the bill, just so for clarification purposes for the clerk.
That's not going to be a problem. I'm going to turn it over to Donna Barrett.
If I just may ask a question, the chair may inquire, Representative.
Yes, I'm sorry, Mr. Chairman. Go ahead if there's any questions.
I want to first thank you for your testimony and thank you for taking my question. You testified or suggested there was a self-defense bill that this would enhance. Do you mind just repeating that RSA you were referring to?
Yes, it is going to be RSA 627(4).
Thank you very much.
You're welcome.
Representative Conley?
May I ask a question of the representative if he's willing to entertain it?
You're recognized to ask a question.
Thank you, Representative Vincent. for coming before us today. So having looked this over, is my understanding correct that this would remove, in cases involving drug transactions, it would make it so that the seller of the drug would not be able to claim self-defense if there is some sort of altercation and deadly force is used. It's the act of the dealing of, or the sale of drugs that hinders the self-defense justification. Am I right? And that's what this bill would do?
Thank you for your question, Representative Conley. Yes, I'm believing that's what it would do. So I think that, I think that the real expert here is going to be former detective or retired detective Art Williams. He was my constituent when he came to me in this matter. And I think he would really be the one to ask that question to. But I do believe that that's right. This would not protect the drug dealer. Let's face it. Like I said before, if I'm a drug dealer and I have several people coming to my house and I'm selling drugs from my house, and say that's 20 people, 30 people in 2 days, and something goes wrong, and as a drug dealer in my house, I killed a person because I didn't like what was going on in this illegal sale. I just think that would protect the drug dealer. That's how I feel, and that's what this is all about. This bill is.
Thank you, Representative.
Thank you for your question, Representative Conley.
Representative Vincent, and the next is wrong with you?
Yes, the next person to testify will be Donna Barrett, and she is going to be in favor of the bill. She can tell you that herself. Hang on.
And Ms. Barrett, we do have to limit testimony to 1 minute per witness.
I wasn't able to hear that question.
Just a reminder that we do have to limit testimony to 1 minute per witness.
Okay. And my name is Donna Barrett. I'm a resident of the town of Dover. I am in support of this House Bill 603 and its amendment. I want to thank the chair and Ken Vincent and all the members of the committee for allowing me to speak. I want to begin and tell you a little bit about my son. I want you to know that this just doesn't come from me as his mother, but how other people have described him to me. Michael was easygoing. He was thoughtful and generous. He was constantly doing things for others. I want to give you a few examples of remembrances people had told me. If you were moving, and this was a true case scenario, everybody else bails out on you, doesn't want to come and help you move. My son would be the one to come and help you move, no matter how difficult or unpleasant the job was.
I'm sorry.
A friend of his came to me and told me that there was a time when he needed baby formula. He wasn't able to pay for it. My son helped him to pay for it, and they bought the formula together. He also told me that my son had expressed how he wanted to have a child one day. Another person came to me and told me when he was the new kid in school, and although this is back in high school, you know how it feels when you're the new kid, and my son would be the first to say hello and befriend him, and he remembers it after all these years. These are just a few examples of how Michael touched people's lives, and I know I can't go on, but there are many more. So now I have to go on and talk to you about why I think House Bill 603 is so important, along with the amendment, because my son Michael was brutally murdered by a drug dealer after he was sold cocaine. My son was 22 at the time. I'm going to give you a sequence of the events. A person arranged the sale and brought Michael to the drug dealer's house and left him there. Cocaine was delivered to the dealer's house a short time before Michael arrived. Michael and the drug dealer ingested cocaine. After a while, an altercation or some sort of disturbance occurred. Michael was stabbed to death by the drug dealer. Michael sustained multiple stab wounds, a compound fracture to his leg, blunt force trauma to his head, and many other injuries and contusions. Only Michael, the drug dealer, and the drug dealer's roommate were at the house at the time Michael was killed. The drug dealer and his roommate sustained no injuries. I would also like to tell you about the 911 call at this time, and I would like to give my support to the amendment to the 911. In Michael's case, the drug dealer and his roommate had the opportunity to call 911, but they delayed. They never called for EMS and only reluctantly called for the police. The 911 caller was described by dispatch as hostile and uncooperative. When police arrived, Michael was found unconscious and with no pulse. The police had to call for EMS. Michael's life could have been saved if the drug dealer and the roommate had not delayed in calling 911 and requested an ambulance. The 911 call was neither timely or made in good faith, and my son lost his life. Under current law, no charges were brought against anyone in this case. 2 people were involved in Michael's death, and 3 people involved in the cocaine deal. Under Michael's law, everyone in the cocaine sale could have been held culpable. I ask you, if this was your son, what charges would you want brought against the people involved? My son was not perfect. He was buying cocaine that night, but he was a good person. He didn't have to lose his life that night. Michael loved life and he loved his friends and family. He had hopes and goals for the future, and I know he would have achieved those and fulfilled those. We love him and we miss him. I'm pleading with you as a mother to support House Bill 603 and its 911 amendment. Our sons and daughters are dying at an alarming rate due to the direct actions of drug dealers and the secondary effects of the drugs they sell. Drug dealers are committing crimes and they need to be sent a clear message knowing that they will be held accountable. House Bill 603 and its amendment would bring some justice to Michael's death, and I believe it would help other families who find themselves in the same situation. Being the person Michael was, I know he would have wanted this to happen, and in honor of my son and in his memory, I would like it to be called Michael's Law. And I sincerely thank you very much for allowing me to tell my story in support of House Bill 603 and its amendment. Thank you.
Thank you, Ms. Barrett, for your testimony.
Thank you.
You have the condolences, and I believe I speak for the whole committee, and sorry for your loss.
Thank you. Thank you.
Mr. Chairman, this is Representative Vincent again. I understand that the members may have questions for Ms. Barrett, and that's fine. And then I would respect if Detective or retired Detective Art Williams would speak after.
Yes, and I don't believe any members have their hands raised, so the witness, Ms. Barrett, is, excuse me, Representative Newman, you're recognized for a question.
Thank you, Mr. Chair. I think I'm unmuted. Can you hear me?
Yes.
We hear you.
Yes.
Okay. My question is there any one of the witnesses that could respond just to clarify why the charges were not brought and how, or if they were, maybe I'm not sure of that, and how that relates to 627-4, which I believe is the right justification for self-defense in your own domicile.
I can probably answer that. Thank you. Your name, Arthur Williams, retired detective from Somersworth. I prosecute.
If I just may recognize the witness, Representative Newman, I believe if I just overheard the conversation, the police detective may be more able to answer that question for you. I just need to, for the record, I do need to recognize the detective first. Detective, please state your name, for the record, whether you are testifying in support or opposition to the bill.
I'm in support of the bill. My name is Arthur Williams. To answer your question on the deadly force, this case in point that you just heard was ruled by the Attorney General's a justifiable homicide, which is kind of the foundation for the bill because the ME and the AG claim that the deceased suffered, they call it something different. What is it? Excited delirium. I always get that wrong. I always call it cocaine psychosis. But they said that his violent behavior precipitated the deadly force. The violent behavior was caused, according to them, by the cocaine ingestion. That's why in the manslaughter proposal that we have, we've included that section. I don't know, can you see this, what the proposal is? No. Oh, you might be able to.
Representative Vincent, if I may interrupt, is there an amendment that is being referenced? And if so, has it been sent to the committee?
I'm sorry, Mr. Chairman, can you say again, please?
I heard a reference to an amendment a few times. Is there an amendment to House Bill 63 that is being referenced?
There is an amendment that was brought on by Representative Reed, Ellen Reed. She brought it on last week. It's amendment, and it is, you have it, you should have it in your possession because it was stamped by the LOB services.
Do you mind just forwarding that to the members of the committee? I saw a thumbs up over there. And can you also forward it to the committee assistant and have her print out a copy for the members of the room?
Okay, do you want that to happen right now?
Representative Muse, I believe, will be able to assist us with that. And we will let, the detective continue his testimony. Sorry to interrupt.
Okay. There you go. Thank you, Mr. Chairman. Arthur Williams back. I was answering the question that was proposed. Is that answer sufficient?
Yes, I think that's a good answer. I just didn't understand. I'll have to just check. That's fine. Thank you.
Is there any more questions for Ms. Barron?
Detective, this is Representative Abbas, the chair of the committee. I want to thank you in advance for taking the question. When I read subsection C, it said the sale, the transfer, injection, or ingestion. And I understand the sale to be, if it says, if it's directly or indirectly related to the sale, transfer, injection. When I was reading this bill, my anticipation was obviously not correct, but I was anticipating this had to do where someone would maybe pass away from an overdose, which is not the case that obviously the example provided to us. I'm just asking, would that section apply to overdoses as well?
Yes.
Thank you.
Does he have testimony?
And Detective, if you wish to provide any testimony, I know you answered the question to start. We allow you one minute.
Okay. There's three parts to the proposal. When we were looking at the Barrett case, we were looking at some of the deficiencies in the laws. And Representative Vincent had touched on it before, that deadly force is, the proposal would be that deadly force is not authorized in the sale of a controlled drug by either the buyer or the seller, so that if any drug activity goes on in a house, that negates any deadly force because the violence that surrounds some of those drug deals. I can only imagine what the consequences would be without it in some of these cases. The other amendment or proposal that changed the language was in the under the 318, the drug statutes, would make somebody strictly liable for the death and or the conduct of another. I think we just heard about the case in Londonderry where the young baby got a hold of some fentanyl and passed away. Parents have been charged. Person who delivered that fentanyl could be charged as well under this. And I think that's not inconsequential. We're averaging over 400 deaths a year for overdose. That's 800 parents a year that are looking for answers. Some of these proposals, I think, have been long in the coming. I retired from active duty in 2007, and I've just seen from the sidelines the drug crisis. Thank you. Thank you, Mr. Chairman and the committee.
Thank you, Detective, for your testimony. Representative Marston, you recognized for a question?
Thank you, Mr. Chairman, and thank you, Detective, for your testimony. I'm confused about the whole situation. Who initiated the altercation that ended up in the death of the young man? Do we know?
We do not know, because the only two people who lived through the altercation gave conflicting stories. So the truth, we don't know.
Thank you, I understand.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. I believe I heard you testify that under the bill that we have before us, it also includes overdoses. My question is, if now, before the bill, as the law is now, if a drug dealer gave somebody drugs, they overdosed and died, is not the drug dealer responsible for that overdose now?
They are. The proposed change to the language says the death and/or conduct of another is defined, which results in the injection. So I guess what we're seeking is, it's kind of like the bar that overserves the patron who goes out and kills somebody else. The conduct of another. So if somebody becomes under the influence of a controlled drug, goes and kills somebody else, whoever supplied that drug is liable. That's the easy way to explain it.
True. For follow-up, thank you, Mr. Chair, and thank you for taking my question again. So, when the conduct causing the death is directly or indirectly related, so if a drug dealer were to sell somebody some heroin, and a few days later, that person had a bad reaction to heroin and killed somebody, this bill would drug dealer responsible for what happened 2 or 3 days later?
I think there's a 12-hour limit imposed on that conduct.
Representative True, you recognize for follow-up?
I'm, and where was that? Where was that? Where was the 12-hour limit? Where is it written?
Is it not written on the?
It's not written on here. I think it had been written on here and I think it got removed.
Oh, I'm sorry, it's apparently has been removed. That was the original idea was it was a 12-hour limit, so there wouldn't be any confusion as to, like the proposal that you said, the situation that you mentioned.
Thank you.
Representative Testerman.
Thank you, Mr. Chairman. Thank you for taking my question. As I understand it here, tell me if I'm right. If a drug dealer sells drugs, he basically has essentially
product liability for as long as those drugs are in use, and could be held liable. And this is for manslaughter if that person causes or dies of manslaughter. Is that correct?
That's correct.
Good to me.
Representative Conley?
Thank you, Mr. Chairman. Thank you, Detective. This is, I guess, a follow-up on my own question. I'm still, this committee has dealt with RSA 67:4 a lot this term. And I'm still a little bit uncertain about how this proposal affects that bill. And I wonder if the detective or the prime sponsor can offer some clarity. I hope I'm not coming up the worst with this question, but I'm still not sure what's proposed and what it would do to the.
Doesn't it just add to it?
Sorry, I didn't quite get the question. I'm having a hard time hearing.
Detective, I'm going to try to communicate the question on behalf of Representative Conley. Please, Representative Conley, give me a thumbs up or thumbs down if I do not capture the spirit of the intent of your question. I believe Representative Conley was asking how would this bill, House Bill 603, change or impact the use of force under the RSA 627:4, specifically involving the use of deadly force.
I think that I could best answer that. This is Representative Vincent, if you would allow me, Mr. Chairman. So,
yes, ma'am.
So, I understand that we're talking about the stand your ground law. And I understand that when you talk about stand your ground law, everybody gets all nervous about it. I just want to let you know that this bill is in no way wants to change. I don't want this bill to change stand your ground law at all. What I want to do is I wanted to add the non-protection of an illegal act such as a drug dealer. Because if a drug dealer is dealing drugs, what are the chances of I get something that I don't like and I am not happy with what I have, and then or the drug dealer is mad at me, and then he kills me, and then claims stand your ground. I believe in stand your ground that a king or a queen is their castle, and anybody to go in there, I shouldn't have to retreat. However, under a drug sale activity, that's all off, in my opinion. But I am for stand your ground. But I just think if you're doing a drug deal activity where there's a mind-altering substance use, a sale of an illegal drug, I don't think that's a robbery. It could be robbery too. And then the person that they're robbing that went to their house kills the person, and then there's no grounds to stand on. I just find that, I understand that as lawmakers, we try to think of every avenue. However, sometimes we don't get it all right, and we come back to it like we are, I think, today. And I really respect and appreciate you letting me answer, Mr. Chairman.
Representative Vincent, the chair would inquire one additional question. I hope I didn't exceed my own limitation of 2 questions. Just correct me about, when I always look at the stand your ground protection under RSA 627:4, that often implies that the person inside their home or standing their ground is not committing any type of illegal act of their own. They have clean hands, per se. I'm not sure if that's clearly written in that RSA, but is the spirit of what is trying to be accomplished is to basically, if you don't want someone using RSA 627:4 to basically use the castle doctrine inside their home to facilitate a drug raid.
That is correct.
Representative,
That's the question.
Representative Newman, you recognize.
Thank you, Mr. Chair. I don't know if this is a follow-up to my previous question or my second question, but anyway, I've also looked at that paragraph and has spent a lot of time pretty much looking at 627.4. And I believe that the new paragraph, because this is a completely new paragraph, prohibits the use of deadly force in those kinds of situations. And I think that it also does not limit it to your own domicile. I believe that that could be done anywhere. So that's just my opinion of the bill, and I'm wondering if the witnesses might, or the prime sponsor might think that that's appropriate understanding.
Thank you. Mr. Chairman, did you want us to answer that?
I believe it was a question by Representative Newman, which the amendment is now being passed out. But you may respond to Representative Newman's.
And I'm going to let, if you so desire, I'll let the Detective Williams answer that question.
Yes, and the prior chair of this committee, who I have a lot of respect for, who I served with last term, did allow, when we were meeting in person, more than one witness to sit with the sponsor of the bill. So this is perfectly fine to kind of interchange.
Thank you very much, Mr. Chairman. We appreciate that, Brian.
In answer to your question, the proposed law change would make deadly force unauthorized anywhere if it involved the use, sale, possession, anything to do with controlled drugs. So it's whether it's in a home and in public, any place, it would just negate the self-defense, because violence surrounding the illegal drugs, the sale and possession of, is not authorized anywhere.
And thank you very much for that answer. That comported with what my opinion of what that paragraph was saying. Thank you.
Thank you.
Seeing no hands raised, I want to thank the representative as well as the testimony taken.
If I could, Mr. Chairman, one more time, I apologize. There is another individual that was kind of part of this group. His first name is Bill. I'm not sure, I'm thinking that you'll see him on your screen. He wants to talk towards the amendment part. I'm not sure if his last name is involved, because there's an ongoing case with his daughter who passed away in December. If you see him, I would beg you to pick Bill to talk more on the amendment.
Well, Representative Vincent, when that person is called, we will be sure to recognize that individual.
Thank you, Mr. Chairman.
In the same courtesy. Seeing no further hands raised, I want to again thank the Representative Vincent and the two witnesses for their testimony and for taking our questions. In respect to House Bill 238, is there a representative that is intending on introducing that? Representative Abramson?
Looking for someone to introduce 238.
Mr. Chairman, I believe the prime sponsor is present for 238.
Thank you, Representative Collins. Representative Joshua Query, you're recognized to introduce House Bill 238.
Thank you. Good afternoon, Mr. Chair and honorable committee members. My name is Josh Query. I represent Manchester's Ward 9, Hillsborough 16. I'm here today to introduce House Bill 238. I'm introducing this bill because the gay panic defense is a legal strategy that asks a jury to find that a victim's sexual orientation or gender identity / expression is to blame for a defendant's violent reaction, including murder. What we've seen around the country is that this discriminatory gay panic defense is used successfully to excuse the murder of members of the LGBTQ+ community. This is a bipartisan bill to ensure that this type of defense can never be used in New Hampshire. Let me begin with what this panic defense means. When a perpetrator uses an LGBTQ+ panic defense, they are claiming that a victim's sexual orientation or gender identity not only explains, but excuses a loss of self-control in the subsequent assault. This is currently allowed under New Hampshire law. This bill, HB 238, will ban the use of a panic defense on the basis of someone's gender identity, actual or perceived gender, gender expression, or sexual orientation. Someone's mere existence as an LGBTQ+ person does not constitute a reason or provocation to commit manslaughter. The American Bar Association opposes the use of gay panic defense, and since 2013 has called for local, state, and federal legislatures to curtail the availability of this defense. And let me be clear, this bill does not dismiss traditional self-defense lawsuits and does not deny existing due process defenses. This means LGBTQ+ people would not be immune from prosecution should they be accused of a crime. If passed, New Hampshire will join 12 other states and Washington, D.C. in banning this type of defense, and join 8 other states who are considering similar legislation this year, including Virginia, which just passed this legislation and is now going to the governor's desk. For our state, we would be proactive in protecting individual rights by barring this defense. Nationally, 1 out of 5 hate crimes are committed against LGBTQ+ people. To put this in New Hampshire's context, in our state, 5% of Granite Staters identify as LGBTQ+, the equivalent of 60,000 people. This is not a small constituency. Our state values personal freedom, and our state also ranks very high in LGBTQ protections. Over the past year, I have had multiple citizens from across New Hampshire ask me to sponsor this legislation. Some are members of the LGBTQ+ community who fear this law would excuse their murder. But mostly, I've heard from people who have friends or family members who are gay and have seen this panic defense play out in other states and do not want to see the same happen here. This legislation will be correcting an oversight that is needed to grant the LGBTQ+ people of New Hampshire the security that this cannot be used against them and their loved ones. Thank you for your time, and I welcome any questions. I will say that we do have someone from the National Bar who can answer more of the specific legal questions.
Thank you, Representative, for your testimony. Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. Could you tell me what the 8 states are?
Yes, I can. So Virginia, Vermont, Massachusetts, and sorry, I'm just pulling up that list right now. Florida is also on there. And I apologize, New Mexico and Oregon and Maryland.
Thank you.
I can email my testimony, and it does have those lists on there for you guys' records.
Representative, do you mind just repeating the 8 states one more time so the clerk can?
Of course. I also mixed up a few of the ones who already have it legal, so that might have been my bad. So they are Florida, Iowa, Maryland, Nebraska, New Mexico, Oregon, and Vermont, and then Virginia, who just passed.
Thank you.
Representative Marston.
Thank you, Mr. Chairman. Thank you for taking my question. The other states that have this on the books, are we writing our House bill exactly as they have it?
Yes. So we looked at all of the other states who have it currently, and we used theirs as a basis. OLS did have a few things that made it New Hampshire specific, including that last line in section A.
Thank you.
Representative Bourdonnais?
Thank you, Mr. Chairman. Thank you for taking my question. You say that you are putting this as an excuse not for defense. How is it a defense today?
Yeah, I think I understand your question. So currently, someone can, if someone committed murder in a kind of against an LGBTQ person, they could say that they were acting in a moment of insanity, brief insanity, because of that person's identity. And then they can use it as that was a panic. And that's why they committed that crime. So this would just ban it.
Representative Kesselman?
Thank you, Mr. Chairman. Thank you for taking my question. How many instances have we had of people using as a defense that they found out inadvertently that the person was part of this community? Here in New Hampshire.
So currently, New Hampshire has never used this defense.
Representative Kesselman, you're recognized for a follow-up question.
Thank you. Well, nationwide, how many instances are there like this?
Unfortunately, too many for me to count off the top of my head.
About how many?
I'm not unsure of the number. I would believe, probably over 50 cases.
Okay. And Representative, I want to thank you for your testimony. The chair will just inquire a question, and I want to thank you in advance for taking my question. When you're referring to saying a defense, are you suggesting that rather than if fall in manslaughter, it would be second-degree murder? Or
yeah, I believe in that case, yes, it would no longer be murder, but yeah, just follow the second offense.
Thank you for taking my question. Seeing no hands raised, I want to thank the representative for his testimony.
Thank you.
The chair now recognizes William Waters. And just a reminder, Mr. Waters, your testimony is limited to 1 minute due to time constraints.
I was trying to get in under House Bill 603 and I was having a little technical difficulty. Can I still give my comments?
Yes, you may, but we are the public hearing for both House Bill 603 and House Bill 238 are being heard simultaneously, so you may testify either one.
Okay, so I'll try to make it brief. I thank you very much to the chair and the members for the opportunity to speak on this matter. My name is William Waters. I live in Guilford, New Hampshire, and I'm speaking today in support of the proposed amendment to House Bill 603. Specifically, Section 2D, which says a person is guilty of manslaughter when such person causes the death of another by failing to request medical assistance for another person under circumstances where the actor knew or should have known that such person was in need of medical assistance. In our situation here, on December 12th, 2020, the light went out of our lives when our daughter died of a suspected opioid overdose. She was an accomplished award-winning costumer. She was 29 years old and she had accomplished so much in her life and was looking forward to many new adventures. She was a volunteer for the White Mountain Stewart Trail Stewardship, and she was deeply loved by her family and friends. Her death has left a huge hole in our hearts. Early in October of 2020, she started dating a man who introduced her to opioids. She was not an opioid user before meeting this man. It turns out that the man was a drug addict and a drug dealer and had already been arrested twice for drug possession, including another case involving an overdose. In the early morning hours of December 12th, her daughter experienced an opioid overdose, and the drug dealer boyfriend had been with her all evening, and there was no way that he didn't know that she was overdosing. She didn't have to die. If only he had called 911 and sought help. In fact, he was in her bedroom with her the whole evening with her dead body for several hours, and he did nothing. In the morning, when the boyfriend heard daughter's roommate get up, he told him that something was wrong with her. And they tried to do CPR, but realized she still wasn't breathing, and her roommate went for help. In the meantime, the boyfriend ran away from the apartment. And it appears he did this before. In the last overdose he was involved in, he ran away. So we believe that he was running away out of fear of being arrested again. So a person who is present for any medical emergency has a duty to call for help at the very least. To not do so is reckless and negligent. Inaction is the opposite of acting in good faith, especially if the inaction results in the death of the afflicted person. If this man had sought help when it was obvious that our daughter was in trouble, she might still be alive today. This could also help in other medical emergencies and accidents. Our daughter is irreplaceable and we cannot bring her back. She will forever be missed by those that love her. Our lives will never be the same again, and she left a hole in our hearts that can never be filled. We can only hope that a change in the law will be a deterrent against inaction. So that somebody else's loved one might get the help that they need during an overdose crisis. Please remember that every victim of an overdose is somebody's loved one, somebody's child. No one deserves to die needlessly. Thank you for this opportunity to provide my thoughts, and I sincerely hope that none of you have to experience the agony of a similar situation. We respectfully ask you to support this proposed amendment to House Bill 603. Thank you very much. It's all about saving lives.
Thank you, Mr. Waters, for your testimony.
You're welcome. Thank you.
Raise the witness's excuse. Chair, I recognize Cassandra Levesque.
Can everybody hear me?
Yes, we can hear you.
Thank you for allowing me to speak today support of HB 238. The LGBTQ plus panic defense strategy is a legal strategy that asks the jury to find a victim's sexual orientation or gender identity / expression is to blame for a defendant's violent reaction, including murder. It is not a freestanding defense to criminal liability, but rather a legal tactic used to bolster other defenses. A most recent defense of the use of this defense was in 2015. Daniel Spencer was stabbed and murdered by his neighbor Robert Miller in 2015. Miller claimed that he rejected a sexual advance from Spencer and acted in self-defense when Spencer became agitated, but physical evidence disproved his claim that he was never in danger. Miller's conviction was mitigated from murder to criminally negligent manslaughter. I will leave you with the following quote by Honorable former U.S. Representative Joe Kennedy III from Massachusetts, who said, "Murdering or assaulting anyone because of their sexual orientation or gender identity is not a defense, it is a hate crime." One would hope that as time progresses, we would have learned and done better for the victims, but we have not. And I hope that we join the other 11 states and change this law. Thank you, and I will divert other questions to others testifying today.
Thank you, Representative, for your testimony. I believe the representative does not wish to answer any questions. Representative Toll.
Honorable members of the Criminal Justice Committee, my name is Amanda Elizabeth Toll. I represent Cheshire 16, which encompasses the city of Keene at large. I'm here today in support of HB 238. I think the vast majority of New Hampshire constituents, regardless of political party, support codifying LGBTQ+ rights into law and making New Hampshire a welcoming state. Nearly every New Hampshire constituent knows and loves someone who is a member of the LGBTQ+ community. I cannot think of another instance in which a victim's identity can be used as a defense in a crime, and so this is a long time coming. Our neighbors in Connecticut, Rhode Island, and Maine have passed similar legislation. We want people in our state to feel safe, and we take pride in being a state that values diversity. This bill would be a crucial step forward in establishing legal safety for the LGBTQ+ community, and I urge you to support it. I will be deferring questions. Thank you for hearing my testimony.
Thank you, Representative, for your testimony. Representative Max Abramson.
Thank you, Mr. Chair, and thank you for taking my testimony. I'm speaking against House Bill 238. Not sure it'll take a full minute. The way it's written doesn't quite match the testimony that's been given so far. The bill as written appears to violate Article 15, which states every subject shall have a right to produce all proofs that may be favorable to himself, to meet the witnesses against him face to face, and to be fully heard in his defense by himself and counsel. Frequently, if you're charged with murder and you're introducing a lesser included offense of manslaughter, manslaughter is often admitting to all the elements except that you're saying that you're trying to introduce the influence of extreme mental or emotional disturbance caused by extreme provocation. And you have the right, you have a due process right to introduce all evidence and all eyewitness testimony in support of that. This has nothing to do with protecting LGBTQ+ people who do deserve to be protected. An example would be a woman who's being continuously provoked by a man or a woman romantically or sexually over and over again, possibly even being touched, where it doesn't rise to the level of a defense.
Representative, we have to limit testimony to 1 minute per witness. Your time has expired. However, members are free to ask questions of the representative. Seeing no hands raised, Representative Anderson is excused. The chair now recognizes Representative Ryan Fowler. Just a reminder, your testimony is limited to 1 minute. If there's any members of the public that are present who wish to testify on either House Bill 603 or House Bill 238, please raise your hands.
Mr. Chair, who was the last person you called?
That was Representative Max Abramson.
I'm sorry, did you call somebody else just now, or?
Excuse me, Representative Ryan Fowler.
Ryan Fowler. I am not seeing.
Is there a Ken Barnes available?
I am not seeing a Ken Barnes either.
Anthony Harris.
Anthony Harris. There is an Anthony Harris.
Hello, thank you, Chairman. Hello to everyone. My name is Anthony Harris. I'm the co-founder of Felon to Freeman. I'm calling in support of House Bill 238. There was a time where I didn't like gays, but I was young and ignorant, you know. And when I was 12 years old, my mother took me on the porch, and she actually she had me and my siblings on the porch, and she said, "What if I told y'all I was gay?" And she was laughing about it. And I said some words that I regret to this day. And I was like, "Mom, I'll disown you." And she fell out the chair crying and balled up on the porch. And that was the day I found out that my mother was gay. And we cried with her. And I said to her a couple of days later, I said, "You know what, Mom, if a female makes you happier than a male, then it makes me happy. In the end, you're my mommy, and I'm gonna love you forever." You know, and then I thought to myself, I was 12 years old, and I said, you know, I can't say I hate gays because I would never say I hate my mom. So it broadened my mind to it, and I actually started talking and open up to a lot of them, especially in college, you know, and I realized, that people just like us, you know, they are who they are, and in the end, we're all human, you know. And when I found out that there's a law that someone can just say, you know, "Oh, because this they're gay and I didn't know, and they did this," they can just do whatever they want, or up to even kill me and get away with it in the court's eyes. And I would never want to see any harm done to my mom because of the person she is and the way the way she chooses to live her life, you know. And so I'm calling in support of this bill.
Thank you, Mr. Harris. We do have to limit testimony 1 minute per witness due to the negligence of the chair. You actually testified for 2 minutes. I just going to stay consistent for members of the public. I do apologize. However, members are free to inquire questions of the witness. Seeing no hands raised, I want to thank Mr. Harris for his testimony. We recognize Sophia.
Hi, can you hear me?
Yes, I didn't want to guess how to pronounce the last name.
All right. Thank you everybody for taking my testimony. My name is Sophia Biondolillo, is how it's pronounced. I'm 14, I live in Manchester. I'm speaking today on behalf of the New Hampshire High School Democrats and as a member of the LGBT community in support of HB 238. I support HB 238 because it would prohibit the institutionalized recognition of hate and LGBT alienation in our state. Allowing the LGBT plaintiff defense to continue to be used divides and stigmatizes the LGBT community and says that we are something to be afraid of, and that violent action against us simply because of our identity is justifiable. It's estimated that almost 5% of our population in New Hampshire, more than 64,000 people, is part of the LGBT community. This legislation would help make New Hampshire a safe space for those 64,000. New Hampshire should not be a state where LGBT people have to fear for our lives. It should be a place where we welcome diversity and understand the value of every one of our citizens. By taking this step, we join other states in taking a stance on LGBT rights and ensure that we do what's necessary to protect our communities. In order to promote equality and ensure that we as a state do not recognize hate, and to show the rest of the country that we are doing what is needed to protect LGBT people in New Hampshire, I urge the committee to recommend ought to pass on HB 238. And thank you for your time.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Is Jody Sewell?
Hi, thank you for allowing me to speak. I'm going to be speaking in opposition to HB 603. And first, I just want to extend my sympathy to Donna and Mr. Waters, the parents of people they've lost. Your descriptions of your kids remind me so much of my Corey, and I'm so sorry for your loss. The night before Corey passed, I dropped him off at the program he was attending to get well. Later that night, he recorded a van full of folks singing Under the Bridge. I cherished that recording and I listened to it over and over and over until the phone finally died. In my grief and distress, I wanted an explanation. I wanted resolution. I wanted someone to blame. And it occurred to me that these were the voices of the last people he was with before he came home. I became obsessed with finding out who gave him the heroin, and eventually I found them. But the thing is, finding them didn't give me the peace I thought it would. Rather, finding them gave me a face. It was the face of a person I didn't know, but a person all the same, a human being who struggled much in the way Corey did. Meeting that person didn't make me want to kill them or have them rot in jail or for the rest of their lives. Instead of wanting to continue blaming them, to report them, to pursue some type of retribution, all it made me feel was empathy and sorrow. I wanted to help them, and I wish we had some better system to help them, not a system that'd throw them in jail, rather than helping them rehabilitate. In our quest to rid our community of a drug, we've ostracized people, we've vilified and maligned members of our community. We've taken our community from them, and I'm afraid we could be moving in much the wrong direction, even more so this year. This bill would give life in prison to anyone who sold or gave drugs to someone who dies of any overdose. I think if anyone in New Hampshire would feel this is justified, it would be someone like me who's lost a loved one to overdose. But having been through that, I learned just the opposite. I learned that criminalization is not the answer. It only serves to perpetuate a punitive mentality that assigns malice to hurting people whose desire to relieve pain manifests in this particular way. So rather than double down on this failed strategy, I humbly request that we seek out ways to support them rather than throw them in jail. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Chair now recognizes Dr. Joe Hannon.
Good afternoon, members of the committee. Thank you for hearing me again. My name is Joe Hannon, and I am speaking in opposition to House Bill 603. We heard previous testimony on other bills about how police and other people in law enforcement would like to see more evidence-based treatment available for people to help battle the drug problem in the state. But we never hear anybody say we want evidence-based prosecution of enforcement and more laws on the books. There is no evidence whatsoever to support a law like this helping to reduce overdoses, deaths in any way whatsoever. If anything, it can actually deter people seeking life-saving treatment because of fear of arrest. We do have a law that allows for Good Samaritan law to allow for calling for help in an overdose, but it would not prevent someone from calling in an instance like this. They'd be less likely to call for help and more people will die. Another really bad part of this is Section C, specifically where it says directly or indirectly related to the sale, transfer, injection, or ingestion. That goes way further than the homicide section where it has to do with the sale of the drug. This has to do with anything. This could be giving someone a ride there. This could be someone involved in a syringe service program, providing a clean needle so someone doesn't get hepatitis or AIDS. And if they are giving someone the means to safely inject, they could technically be indirectly liable for their death. And that is ridiculous. As far as I can talk about defense of a person in the stand your ground section if people have questions.
Dr. Hannon, we do have to limit testimony to 1 minute and more additional notice, the chair, you went on close to 2 minutes, I apologize. If we do have to suspend your testimony, but members are free to ask questions. Representative Marston, you're recognized.
Thank you, Mr. Chairman, and thank you, former Representative Joe Hannon. I worked on that bill that you just referenced to about if somebody has had a reaction to a drug and is in trouble and they call 911, no arrest can result from that. And I worked on that and got that passed. Do you recall the RSA number that now is?
Yes, I do. It's 626.8. If you look at Section 4, if an accomplice in conduct, I'm sorry. Oh no, I'm very sorry. I apologize. That is, I'm sorry. It's 318B28B. And if a person in good faith calls for medical assistance for an overdose in a timely manner, doesn't have a 12-hour requirement or anything like that, it says they shall not be arrested, prosecuted, or convicted for possessing or having under his or her control a controlled drug in violation of RSA 318B2. if the evidence for the charge was gained an approximate result for the request for medical assistance. That doesn't mean that someone can't be arrested for outstanding warrants. They can be arrested for self-defense. They could be arrested for trying to defend themselves. Say a drug dealer is asking someone for, forcing themselves sexually. They could be found liable. They could not be, according to this bill, they wouldn't be allowed to defend themselves against rape or another deadly or serious bodily injury because they were involved in the deal. This doesn't just pertain to drug dealers. This pertains to anybody involved in using or injecting or in any way. This could be the driver who drove you to the drug dealer's house. You're not protected. So it's a very dangerous precedent for stand your ground. And I think there's two very major issues with this bill that are more than concerning. And I think I do thank you for helping with that other bill. It has saved lives in my mind. I believe it has. But we want evidence-based practices, and we have not heard one bit of evidence that any of these kind of laws help in any way whatsoever. And I've been listening all afternoon. I've not heard one thing.
Thank you.
Representative Bornay, you are recognized.
Thank you, Mr. Chairman. Thank you for taking my question. So do you know what happens if a bartender sells a customer alcohol and they go outside the bar and have an accident in which someone dies in an accident? Is the bartender accused of manslaughter?
As a general rule, no, but they can be charged or sued if they were knowingly serving someone who was excessively intoxicated and they didn't prevent them from getting into a vehicle, I believe. I don't know the specifics of how that works, but I know that it has happened. I know of a few bar owners that have been charged or sued because of that. But as a general rule, no, unless there's something, if you're forcing a beer down someone's throat and then giving them their car keys, obviously that's a slam dunk. But if you're just serving a beer and someone you don't know they're inebriated, that is generally not what happens to them.
Thank you.
Thank you.
Seeing no hands raised, I want to thank the witness for his testimony.
Thank you all. Have a good afternoon.
And I'll just remind members of the public who are in attendance, if you are in attendance, please raise your hand. We'll call Joseph Ebert.
Good afternoon, members of the committee. My name is Joe Ebert. It's E-B-E-R-T. I'm a captain with the New Hampshire State Police. I oversee our Investigative Services Bureau. I wanted to start by saying I truly feel for the families who testified here today, and I have great respect for retired Detective Art Williams. I do have some questions within the bill, and Representative Bordenay's previous question gets to some of where my concerns come in. The line within the bill that speaks about or any conduct of another. I wonder if the bill were to proceed forward out of this committee, if the committee would consider some type of guardrail around what conduct could or could not be attributable to the sale of a drug. So that's the first thing. The second, as it relates to the homicide case that was discussed, although I don't know the details of that, I understand the intent is to take away a defense of a drug dealer, but as somebody who worked homicides for a number of years, what I can tell you is that we have to independently look at self-defense in many cases in which people put themselves in those scenarios. So I offer that to you. That does not make the loss of the life that took place there any less, and I don't want that to come across that way. But I would suggest to you that unfortunately that is the rule of law. We look at self-defense regardless of how a person became in a given situation. So having said those things and expressed my concerns, I'm more than willing to answer any questions from the committee.
Thank you, Officer, for your testimony. Seeing no hands raised, the witness is excused. Ken Barnes. Ken Barnes. Tim McLean. Chair recognizes Tristan McLean. We'll move on to the next witness.
Hey, wait. Sorry, technical difficulty.
Right.
My name is Tristan McLean, and I'm speaking as a resident of Plymouth, New Hampshire, and a member of the public. There seems to be a disconnect in the protections afforded to the LGBTQA community and testimony voiced in opposition of this bill. I fail to see how an instilled fear of someone's sexual orientation or identification has any business in justifying assault and murder of any individual or group, including the LGBT community. We preach that New Hampshire is safe in a nonpartisan form, and this is just one of a number of bills that is working to remedy past transgressions and providing legislative safety for every individual, regardless of characteristics. My mother should not have to worry about her son dying because someone feels fear. What would you do if this was your family? What if this protection was addressing Christianity or Caucasian? Would you be feeling different? That's all I have to say.
Thank you for your testimony. Seeing no hands raised, the witness is excused. At this time, we will recognize. It says the LGBT bar president, but just please identify your full name for the record and whether you're testifying in support or opposition to.
Yes, thank you, Mr. Chairman, members of the committee. I am Wesley Bazell. My pronouns are he, him, and his. I'm privileged to serve as president of the National LGBT Bar Association, and I'm here to convey our strong support of HB 238. This is an issue the LGBT bar has been working on for over a decade. Some may wonder why this bill is necessary today. Unfortunately, panic defenses are not a relic of the past. Throughout the country, judges allow the defense to be raised, prosecutors fail to object, and biased juries refuse to impose a just punishment. And murderers escape the punishment they deserve. I'd like to address a few questions that have been raised by the committee. First, in response to Representative Testerman's question, because there is no systematic way of tracking criminal cases, we do not have a clear picture of just how many times the defense has been used across the country. The FBI does not even systematically track the murders of LGBTQ plus victims, and trial court proceedings in criminal matters are rarely published. What we do know is that we have found hundreds of cases throughout the country, mainly from a result of press accounts of them. We also would note that there are no due process concerns regarding this bill. This bill does allow the allowance of evidence, and several scholars have looked at whether there are due process concerns raised, and all have resulted that the Montana v. Eaglehoff Supreme Court case is consistent with the banning of the LGBTQ panic defense. Finally, I would just say we urge the enactment of this important legislation that will prevent violent criminals from escaping the punishment they deserve and will make equal justice under the law a living, breathing reality for victims of violence. Thank you.
Representative Bournet, you're recognized for a question.
Thank you, Mr. Chair. Thank you for taking my question. Are you aware that this bill only pertains to manslaughter? Should it not also pertain to homicide?
Thank you, Representative. So what this bill does is that it would, would prevent the use of the provocation defense as a defense in manslaughter, to bring down a defense in the manslaughter cases. is my understanding of how the bill is drafted. So to reduce a sentence of murder in the second degree to manslaughter.
I guess that's not how I'm reading it, but if that's what you think is, that's fine. Thank you.
Representative True. Thank you, Mr. Chair. Thank you for taking my question, sir. So this bill proposes that a particular line of defense would not be allowed. Can you give us some other examples of lines of defense that, in other cases, that aren't allowed?
Sure, happy to do that. Thank you, Representative. So this is not saying that the defense is not allowed. What it is saying is that the use of a person's sexual orientation or gender identity as the reason for the defense is not objectively reasonable. There are a number of other cases where we see this arise, where we either limit evidence or say that a defense is not permissible. For instance, intoxication generally is not a defense in crime. We've also have rape shield laws that limit testimony about a rape victim's sexual history. And there are other laws in other states that cabin the use of defenses. For instance, at least 15 states require a duty to retreat in order for a self-defense justification as well. So it is a number of other states have certainly limited or cabined the defense, including in other heat of passion defenses such as adultery, where a number of jurisdictions have eliminated adultery as a reasonable provocation for assault or murder.
Thank you.
Representative Testerman.
Thank you, Mr. Chairman. Thank you for taking my question. I assume you're licensed to practice in New Hampshire. So I'll ask you a question. That was the other part of the question I asked before. Was how many cases are there like this in New Hampshire in the last 10 years?
Sure. Thank you, Representative. I am not licensed to practice in New Hampshire. I don't have that information in front of me. I again point out that we do have cases from across the country. Recently in Virginia, where we last worked on this, we found 8 or 9 cases there. It requires a lot of digging because there is no way to find these cases other than through press accounts or going to each of your superior courts and going through each of the criminal proceedings to determine, because these cases are not published. Criminal cases at the trial court level generally are not published. And so there's no comprehensive way to research them.
Thank you.
Representative Conley.
Thank you, Mr. Chairman, and thank you, sir, for taking the questions. Can you provide, in as briefly as possible, a rundown of the strategy behind using this defense? Is it to get the actor off have the charges dismissed? Is it to instill doubt? How is this used by defendants across the country?
Sure. So we typically see this in 3 ways, one of which here is addressed by the bill. So it is typically used in a claim of self-defense or a claim of diminished capacity, or as the case this bill addresses, in the case of provocation. Factually, how this typically happens is that an individual discovers that someone who they are with makes a pass at them, and in that moment discovers that they are LGBTQ+, and reacts violently to that. That is what we've seen in cases. The other type of case that we primarily see this in is where a man makes a pass at a transgender woman and does not realize her transgender status. And when he does, reacts violently in response to that as well.
Thank you.
The chair would inquire of a question, and I want to thank you in advance for taking my question. Is there any specific case that you could reference for this committee to refer to where this, I look at this as more of a mitigation defense, where this mitigation defense was actually successfully used in a trial setting?
Yes, it has been successfully used. And you are correct that it is typically a mitigation defense. There was a case in Texas that a murder that occurred in 2015. I think the trial occurred in 2018, where the defendant stabbed and murdered his neighbor, claiming that he was rejecting a sexual advance and acted in self-defense. Despite the fact that the physical evidence disproved this claim. This defendant's conviction was mitigated from murder to criminally negligent manslaughter. The other most familiar case that people may know of is where it was attempted to be used but not used successfully, was in the murder of Matthew Shepard in Wyoming.
Thank you for taking my question. Seeing no further hands raised, I want to thank the witness for his test. Oh, excuse me, Representative Conley.
Thank you. This is more a question to the chair, and this is in line with your question because I'm legitimately hoping to better understand it. Does one in New Hampshire need to demonstrate that the defense that they're using is justified? Like, can I just make up any excuse I want, including one like this one, in hopes that it might get me a reduced sentence or a reduced charge?
Well, is that for me or the witness?
Well, I guess to the witness.
I'll let the witness try to tackle that one first.
Thank you, Representative.
Okay.
So what I would say is that the reason that the defense is necessary is based on stigma and prejudice that judges and juries continue to have. So, certainly in other ways, a defendant can raise a theory of provocation based on whatever they like, that the person was wearing, the color red, and that created a violent reaction in them. And it's up for the trier of fact, in this case, the jury, to determine whether that's reasonable or not. The problem here is that even with the advances that we've seen with LGBTQ equality, the type of evidence that's being presented sways the emotions of the juries and feeds on their pre-existing biases to allow the defense to be successful.
The chair would just inquire of a question. You gave me a name of someone's defendant out of Wyoming. If Matthew was the first one, what was the last name of that person?
Matthew Shepard. His mother, Judy Shepard, has testified in support of this bill in various places. The Matthew Shepard James Byrd hate crimes bill at the federal level is named after Matthew's death.
Representative Newman.
Yeah, thank you, Mr. Chairman. Thank you for taking my question. I just have a quick question in my understanding of the bill as it's written. Does the new section 4, is that used as mitigation or prevent the mitigation of a murder charge because they were in that state of being upset? Is that what it does?
Representative, that is my understanding, yes.
Thank you.
Seeing no hands raised, I want to thank the witness for his testimony.
Thank you, committee and chairman.
Hello. My name is Asma Al-Huni, and I'm going to be speaking for two bills. I'll make this quick. I'm speaking in opposition of HB 603 because we can't punish our way out of drug use. I sympathize with the mother that spoke about her son, Mike, and my heart breaks for her, just as it breaks for the wife and mother who just spoke also, who lost her husband, but clearly one doesn't understand that punishment would not have stopped her son's death, while the other had to go on a journey of realizing punishment isn't going to end drug use or the sale of drugs. The mother who spoke about her son, Mike, it's very sad and unfortunate death, just fails to realize that her son, if he lived, he would have been arrested by the same laws that she's promoting, and yet is asking exactly that to happen of other sons and daughters. So I'm speaking in support of HB 238 because it gives people more protections to ensure that people who are trans and non-binary in our state are not targeted by people and are not just getting off the hook by the provocation defense that could possibly be used. It doesn't matter how many cases that's been used in New Hampshire. It's the fact that it can be used, and we need to send a strong message in our state that we will not tolerate that, and that trans, non-binary, LGBTQIA+, everyone will be included in our state, and we'll make sure that we protect everyone. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Is there any members of the public who are in attendance that have not testified already that wish to testify in regards to HB 238 or House Bill 603? Seeing no hands raised, we now close the public hearing on House Bill 238 and House Bill 603. Please.
On those two bills, on House Bill 238, we had 311 people signing in support. We had 18 people signing in opposition. And on House Bill 603, we had 16 people signing in support and 15 in opposition.
Thank you. The Criminal Justice Public Safety Committee will be in recess to 4:45.
Darrell, is Ms. Chair?
Yes, we can hear.
Okay. Are we gonna exec anything?
That's the goal. I just wanna.
Which ones?
Excuse me?
Which one?
Well.
These two?
I would say all of them. If we can, I think we'll discuss one of them that may require a lot of work, and the deadline coming up next week. Despite the importance of the bill, I feel that we would never make that deadline to the justice. So one of them, but we will. We'll be in recess to 4:45.
Hey, guys, can you hear me? John,
Yeah,
Laura?
Yes.
Okay, you guys want to join the bridge again?
Sure.
It's open. So the same bridge that we joined before.
Okay.
Linda, what did you want to do?
You can, if I can see it. Show me what we're doing up there. We did something earlier, it was good.
Brad, can you hear us?
So when do I?
Ray, you can hear us?
I haven't heard that they hear us.
All right, his thumbs up.
Why would I make corners mute? So when?
I heard something.
Where's Representative Conley?
You guys want to tell Representative Conley,
I think they're still on the phone.
if you guys are still having your, a caucus, we will, we can accommodate that. In a couple of minutes.
You still having a caucus with your guys?
Yeah, we're wrapping up though. I think everyone's coming back to that thing.
You guys voting IGL and everything too?
We're just gonna follow your.
In that case, I'll be right back.
You'll be a team player, see?
Finally see the forest tree tree.
Oh, that was good.
I knew he'd come to the right side sooner or later.
With that, or we going to their side?
Always go to the right.
Getting late, so. You know what the horrible thing is? I looked up on Google, make sure I was pronouncing pedicure right, because I didn't want to get that wrong. So now, I go on Facebook, guess how many freaking
Oh my
advertisements?
gosh.
At least you spelled it properly.
Right, I know, that's what I was worried about.
Hello, everyone.
Only you.
I know.
Representative Gamble with us?
Takes forever.
At this time, we are opening the executive session on House Bill 526. Can everyone hear us at home?
Yeah.
Sorry. The chair recognizes David Wells to make a motion.
Make a motion, we retain House Bill 526.
Is there a second?
Second.
That's been seconded by Representative Hopper. Wish to speak on the motion?
No, it's gonna retain it. Talk about it in the fall.
The chair and I will open the question up for discussion. Seeing no hands raised, the matter will be put to question. The question will call the roll. If you're in favor of the motion to retain, please say yay. If you're opposed, please say nay.
It's Chairman Welch.
Aye.
Representative Mooney.
Yes.
Representative Hopper.
Yes, ma'am.
Representative Green. Representative Walsh.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Morrison.
Yes.
Clerk votes yes. Representative Harry Gathright.
No.
Representative Pantelakis.
No.
Representative O'Hearn. Representative Bourdonnais.
I have a question, please. What bill are we dealing with?
Oh,
526?
Correct.
yes.
The cannabis.
Yes.
Was that a yes vote?
Yes.
Representative Muse.
No.
Representative Newman.
No.
Representative Bolden.
No.
Representative Conley.
Yes.
Representative Klein Knight.
No. I mean, yes, sorry.
I mean, no, just go with no, please. Thank you.
Representative voted no.
Representative Bradley,
No.
Chairman,
The chair votes yes.
Mr. Chairman, the vote is 12 yay, 7 nay.
By a vote of 12 yeas and 7 nays, the motion to retain has passed. At this time, we will close the executive session on House Bill 526. We now open the executive session on House Bill 511, relative to penalties for possession of certain controlled drugs. Representative Testman, you want to recognize to make a motion?
Make a motion, we retain this one.
Five 11.
That has not been seconded.
That's what I had my hand up to.
Oh, Jesus Christ.
The motion was to.
I will second the motion to retain. Didn't that what they wanted to do?
Mr. Chair, could you restate the motion that's on the floor?
I withdraw my motion to retain. So you can make it, somebody else can make another motion.
I withdraw my second.
Thank you. Representative Buzz, do you wish to be recognized to make a motion?
Representative True has his hand up.
Representative True, do you wish to be recognized to make a motion?
Yes, Mr. Chair. Mr. Chair, I move House Bill 511 inexpedient to legislate.
Second.
Seconded by Representative Wallace. Representative True, do you wish to speak to your motion of inexpedient to legislate?
There was a lot of talk about people needing help, not throwing in jail because they have a drug problem, but the amount of illegal drugs being discussed not only shows me that the person would be selling those drugs, but according to the bill, they'd be allowed to sell them up to 4 times of being caught. This is, to me, this is about a bill authorizing the sale, and that is why I cannot support it, and I moved ITL.
Now open the question up for discussion. Representative Houston, you're recognized.
Thank you very much, Mr. Chair. As I read this bill, it does not address people who are actually selling drugs. This bill impacts people who are basically caught in possession of drugs. And I think one of the things that we heard was some pretty compelling testimony around the fact that different people react in different ways to different doses. And absent the evidence that somebody is actually trying to sell the drugs, to me, it just seems to be almost cruel, given the way that the opioid situation has hit our state, and the way that so many people have just fallen into this trap, sometimes almost through no fault of their own. They've just run with the wrong people. They've gone with the wrong crowd or whatever. To me, it seems unnecessary and cruel to keep our possession laws the way that they are. I think it's time that we tried a different approach. The approach that we have tried for years and years and years, we just hear one person after another coming up saying it's not effective. So I say, if you're selling drugs, you should get prosecuted to the full extent of the law. But if you're caught with them, I think that's a different situation, and I think we need to, as a body, look at that situation with a lot more compassion, especially given what the state has gone through over the last 5 or 6 years with the opioid crisis. This is a crisis that has touched so many families in such a difficult and painful way. And I think this bill would actually go at least part of the way of trying to put some of that behind us without relieving penalties for people who are actually engaged in the sale of narcotics.
Representative Bournet.
Thank you, Mr. Chair. I really would rather see us retain this bill rather than really inexpedient to legislate. We have just, and the House just passed HB 615, which did reduce penalties for drug cases, but we don't know what it will happen to it in the other body and what will happen to it when it reaches the governor's desk. If it does not become law, then we are to keep this for us to make changes we need to drug penalties. So I'm going to vote against the ITL motion and hope for another motion to retain. Thank you.
Representative Rhodes.
Thank you, Mr. Chairman. So a couple of things. Representative Hughes made a statement, that, if a person is doing the drugs or a person is selling the drugs, about two different penalties, but you can't sell them if you don't have them. And now we're getting into a territory of trying to decide what the person's intent was. And Representative True made a good point of just how deadly a very small amount of some of these drugs is. And the other thing that I think that we have to take into consideration here is that everybody's tolerance level is different based on their usage. And the more we keep on raising the bar of how much you're allowed to have, the more the bar will be raised on how much people continue to push it. So right now they know if the legal limit is this, they're going to keep it right at or under that. And then whenever we raise it, they're just going to keep on raising it. To what point? To what point is it not their fault?
Pretty good summation.
Thank you.
Representative Hopper.
Thank you, Mr. Chairman. I know quite a bit about addiction, and I will tell you that if somebody in this room was caught with a revolver playing Russian roulette, somebody who's sitting at this table right now playing Russian roulette, they would be taken and brought to Concord Mental Hospital for evaluation and maybe stay there for a month or two. Everybody that sticks a needle in their arm is playing Russian roulette. They have zero control over their lives anymore. The drug is making their decisions for them. I know I heard testimony. The testimony is not correct. Somebody who was on fentanyl or heroin is no longer in any way remotely in control of their faculties and should be put in treatment. They should be taken to the state hospital, put in there for evaluation, and stay there until they're leveled up and see if they will actually respond to getting help. Because they're gonna die. The idea of raising the thing to 4 grams, give me a break. A gram will kill 500 people. You're gonna raise it to 4, that's insane. I'm voting expedient to legislate. We're doing this all wrong. This is not the right way to deal with this problem. But giving people a free ride and letting them get out of jail free for a few times only is enabling them to dig themselves deeper into the hole. Thank you.
I think there's a lot to unpack here. I think what our Representative Hopper said, some of it was I agree with, is that if people are misusing something and self-harming, they deserve to get treatment. And what we're doing as a state now is making it worse. We're not giving them treatment. We're condemning them. We're putting them in confinement on our people's dime. And then they get it back out. They're homeless. So it's contributing to the situation because they didn't get the resources that they needed. And then we arrest them again. And then our people are paying for it again. And it's this cycle, right? So how do we help our people get the help that they deserve and need? And how do we limit wasting our people's money for paying to have these people incarcerated when all they're doing is self-harming? And with all due respect, I think a lot of us don't know how drugs work because we're not drug abusers. And I think that there's a lot of misinformation in this committee right now where people think they understand how much something does and where it causes and what harm it causes. But then I think there's a complete lack of education, really understanding what these drugs do and what they're used for, regardless of, we're trying to make the distinction between people starting a business and people that are self-harming. And this bill clearly states that difference. And we need to have compassion if we're going to help these people get over this treatment. And we don't have that. And we need to work in the right direction to give them a chance to access that care. And I think this bill is the right step in that direction to get that care instead of condemning the people that are suffering from illness and that we end up paying for over and over and over again.
Representative Pantelakis, your hand was raised.
No, I don't have anything to say.
Seeing no further hands raised, the matter we put the question, the clerk will now call the roll. If you are in support of the motion to take speed to legislate, please say yay. If you are opposed, please say nay.
Vice Chairman Welch.
Aye.
Representative Mooney.
Yes.
Representative Hopper.
Yes.
Representative Green.
He's not here.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harry Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn. Representative Bordenay.
No.
Representative Muse.
No.
Representative Newman.
No.
Representative Bolden.
No.
Representative Conley.
No.
Representative Klein Knight.
No.
Representative Bradley.
No.
Chairman.
The chair votes yes.
Mr. Chairman, the vote is 12-7.
A vote of 12 yeas and 7 nays. Motion to take speed to legislate passes. The minority report. Yes. Representative True, will you be doing the
Yes.
majority report? This time we will close the executive session on House Bill 511. This time we will now open the executive session on House Bill 603. Chair recognizes Representative Welch to make a motion.
I move that we retain House Bill 603.
Representative Marston, you recognize?
I will second the motion.
Representative Welch, you wish to speak on your motion?
Work on this in the fall.
And I would just say that in respect to the members of the public and the bill sponsor, there's a lot of very important issues that were raised by the testimony today. A lot of things to put into consideration. The bill has a deadline of March 11th. If we attempted to, we don't have the ability to meet in subcommittees. So if we were to attempt to work on this bill, I'm confident we would not be doing the justice or respect that the issues deserve. So I would be supporting the motion to retain, and hope as a committee we can work together on this and try to address all these concerns raised by the testimony.
Question, Mr. Chairman?
Parliamentary inquiry?
No, just a question. When you retain a bill, does the amendment go with it?
The amendment technically, well, no, but yes. I mean, it's not like the amendment, we keep the amendment for our own knowledge because we may, yeah, we still have it. It's not, the amendment hasn't been adopted, but I would find
Correct,
it
that's
useful.
why I asked the question. Okay, thank you.
Senator Bournet?
Thank you, Mr. Chairman. I don't understand why we are retaining this bill. It clearly is a stand your ground, and it should be ITL'd. Retaining will not do anything for us.
Good job. Representative Bournet. Anyone else wish to speak on the motion to retain? Seeing no hands raised, no matter we put the question, the clerk will now call the roll. If you are in support of the motion to retain, please say yea. If you are opposed, please say nay.
Vice Chairman Welch,
Yes.
Representative Mooney,
Yes.
Representative Hopper,
Yes.
Representative Green, Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
the clerk votes yes. Representative Harriet Gathright,
No.
Representative Pantelakis,
No.
Representative O'Hearn, Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Golden,
No.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
No.
Chairman.
Chair votes yes.
Mr. Chairman, the vote is 12 yea, 7 nay.
By a vote of 12 yeas and 7 nays, the motion to retain passed. This time we will close the executive session of House Bill 603. At this time, we now open the executive session on House Bill 238. Mr. Teston, you wish to be recognized? Yes.
I make a motion that we ITL.
Representative Marston, you wish to be recognized? Second the motion to expedient to legislate.
Yes.
Representative Teston, you wish to speak to your motion?
I think it's the case where we have trying to come up with another reason for a jury. And I think the jury's smart enough to take a case like this and proceed with it correctly without telling them to do it.
I'll now open the question up for discussion. Representative Knight?
Yes, I think we have a duty to the state of New Hampshire to protect all people, including those that are different amongst us. And clearly there is something wrong in our law that basically allows somebody to commit murder when they feel like they've had a pass made at them. And that is just unacceptable. if you're going to vote to kill this, you're sending a clear message to the people of New Hampshire that you don't support protecting LGBTQ plus members. Thank you.
Senator Knight, we're not supposed to speak to the intent of the members, including anything implied in their vote. And this also will not legally justify any type of lawful killing. It's simply a bill that involves the mitigation of someone who's charged with second-degree murder and simultaneous manslaughter. They would not be, they're not going to be convicted of both. It's simply a mitigation of a mitigation defense to second-degree murder. No one's getting away with killing someone. So just to clarify that, and I don't believe anyone in this committee would support someone getting away with killing people simply based on their sexuality. Representative Boardman.
Thank you, Mr. Chairman. I think that you and the attorney have misread this bill. This is not a bill that allows you to go from murder to manslaughter. This is only to exclude a defense against manslaughter. I myself think that it's a good bill, and I would like to pass it.
So I'll explain, Representative Bourdain, and I'll just admit I've never worked on a murder case in my professional career. But my understanding is quite often when someone's charged with manslaughter that would involve violence, it's often second-degree murder is often charged as well, where you wouldn't have a conviction of both, but you could have a conviction of one but not the other. What this would do, and this basically the facts that were described in the testimony, you wouldn't be able to claim this as a reason that caused you to lose control, to no longer be objectively reasonable or and made you lose your cool, and that's why you lost all control of yourself. You're not going to claim that as a reason to mitigate second-degree murder to manslaughter. But this doesn't need to mention second-degree murder. It doesn't need to address that because that's a different. That's RSA will be not impacted at all. So this is not a flat-out defense to manslaughter. And I'll recognize Representative Bourdain to respond to what I just said, even though there's other members with their hands up. I hope no one raises a point of order.
Thank you, Mr. Chair. Maybe I'm misreading the RSAs, but 630:2 is devoted only to manslaughter. It has nothing to do with homicide. And this is where this paragraph is being inserted. It is being inserted as this is not a defense for manslaughter.
I'll read it again, but I respectfully disagree, but Representative Pantelakis?
Time to do it. You can talk to me sometime when we have more time on our hands.
Thank you, Mr. Chairman. I would like to see this bill passed. With such animosity out there nowadays, we haven't had it happen in our state, but it could. I remember years ago when the LBG was out, that they would beat a man half to death because they found out he might be gay. So I don't think it hurts anything to put this on the books. It hasn't happened and maybe it never will, but at least we're protecting them. Thank you.
Representative Muse?
Mr. Chairman, we heard that intoxication and adultery aren't acceptable defenses. And I think a pretty good case was made today that a person's identity should also not be grounds for them to be victimized in this way. I think one of the things, I've been kind of looking for an analogy, and I think this situation is very much analogous to a lynching defense that would center around a person being triggered by seeing Black people. And in many parts of the country, that was an acceptable defense until not too many years ago. I think that passing a bill like this is part of the process that we need to make as a society to essentially get to a point where all of our people have equal protection under the law, and really do have equal protection under the law. I've yet to see a bill come across our desks this term that isn't more about that than this particular bill. So I'm going to oppose the ITL motion.
Representative, if I can inquire of a question. You said that that adultery would not be grounds as a mitigating defense to claim that you can't be objectively reasonable. Is that in New Hampshire law? I'm just wondering, I didn't.
We heard testimony from the person from the LGBTQ bar that was the case. I'm not 100% sure if that's the case in New Hampshire, but it sounded like that's the case in some other states. And if it is,
Pretty good.
and it's not the law in New Hampshire, we should join those states as well.
Thank you, Representative Bradley.
Thank you. I really feel like this is a good bill and that we should be trying to pass it. It just, I agree with Representative Klein Knight that if we ITL this bill, it just sends a clear message to the people of New Hampshire, and it's awful. So I will oppose the ITL.
Representative Conley.
Thank you, Mr. Chairman. We heard testimony today that this panic defense lets people concoct a defense that may or may not be based in reality. And depending on the jury that they draw and the prejudices those jurors have about LGBTQ plus people, could then potentially allow for a reduced sentence. This is a type of defense that is unique in our statute. One's sexual orientation should not be used. The victim's sexual orientation should not be used as a mitigating defense. We heard testimony that a number of states have done this, red states, blue states. It's good practice, and we should do it. We should vote against the ITL.
Representative Newman.
Thank you, Mr. Chair. And I also believe this is a good bill. And I believe that from the testimony we heard today, that this mitigation effort, because of the sexual orientation of the victim, it can objectively not be used when someone could potentially be convicted of murder or second-degree murder. So that's my take on the bill for my 2 cents. Thank you.
You're recognized.
Thank you, Mr. Chairman. I seconded the ITL, and my reasoning for doing that is a couple of reasons. One of them, to start with, is our Constitution already covers everybody, and are we looking to carve out? And if we're going to carve out one group of people today, then tomorrow somebody's going to want to carve out the liberals for attacking the conservatives.
Yeah, we don't need to use that type of rhetoric. We just try to.
May I continue that?
You may continue, but referring to people as liberals, conservatives, that does not provide any productive thought to the conversation.
Okay.
We're all members in here.
That's fine. Well, we refer to people as gay or LBGs and so on and so forth, and we want to carve them out and say they got special privileges. Our Constitution of New Hampshire, as I understand it, covers everybody to begin with. And we only, a number of years ago, amended our Constitution about discrimination towards somebody. And we don't want to do that. But I'm just saying, we don't want to have special privileges for special people. We're all the same group. We're all the same people. If you kill somebody, you should be charged for murder, and then you should be tried on it. And there's no way in heck that you're going to be able to say, well, because he or she was some deviant sexuality that I'm not.
Representative Marston, no member is able to speak of someone's deviant sexuality of that nature.
What is LBG? D.
We're gonna close the executive session. The safety committee is now adjourned.